Sorry. Where should she sit? Okay, and I think we have a 10 minute. I think we have a 10 minute. 10, 7, 5, and 11. Yeah, we have 10, 7. It's the new part. Yeah.
Right. Good morning, everyone. I'm so happy to have you all here, and I'm so excited to kick off our symposium events. We have a great slate of speakers, and I just know that it's going to be entirely impactful and insightful for all of us. Again, I just want to thank all of our faculty and our staff and our planning committee and members of the law review, as well as our panelists, of course. Saying thank you so much for being here. Before we get started, I'd like to let Tyler Kelly, our editor-in-chief, come up and say a few words.
All right, well, thank you, Rachel. Good morning, everyone. My name is Tyler Kelly, and I have the honor of serving as the editor-in-chief of the Mercer Law Review. And so on behalf of the Law Review, I would like to express our sincere gratitude to the many faculty and staff and Law Review members that have worked so hard to make this symposium possible today. I would like to extend a special thank you to our panelists. We're so grateful for the opportunity to sit under your leadership today. And as a brief primer kind of on the heart behind this symposium, Justice Colvin often emphasizes the importance of having your why. And so at the Mercer Law Review, our why is reflected in the preamble to our journal's constitution. Now, our members might groan because they hear this from me a lot, but that's because it's such an accurate reflection of our mission. And so the preamble reads, "The purpose of the Law Review shall be to advance the study and development of law, to provide a forum for the expression of ideas, to encourage creativity by scholars, practitioners, judges, and students, and to promote scholarship, excellence, and original thought by students." And so the symposium represents these four action words: to advance, provide, encourage, and promote. And here at Mercer, we focus deeply on making practice-ready lawyers. And part of that readiness is being intentional now, while we're in law school, about developing our professional identity so that we can exercise servant leadership both within the walls of the law school and as a practitioner. And so at Mercer, we're quite fortunate to have such wonderful mentors who support us in that mission. And with that, it is my pleasure to introduce our Dean, Dean Sneddon.
Well, I'm delighted to add my welcome to you to join us here for our 2024 Mercer Law Review Symposium titled Parts of the Whole, the Multiple Roles of the Lawyer and Professional Identity. I know we heard a lot of thank yous last night, so I don't want to repeat all of them, but I do want to ask you to help me thank a couple of individuals who have done above and beyond here. I hope you will join me in thanking Rachel, who was our lead articles editor. This event is a result of hours and hours of Zoom calls, emails, and conversations. I want to especially thank two faculty members. I want to thank Professor Mark Jones, who is our Symposium faculty coordinator. So thank you, Professor Jones. Back in the day, Mark and I were co-faculty advisors for the Mercer Law Review, so it's really delightful that we've been able to partner again with this special symposium. I also want to thank our current faculty advisor, Professor Caleb Byers. This is his first year as faculty advisor, and when he asked me whether it was a lot of work, Professor Jones, I'm looking at you, I said, it's a lot of fun, and I just left it at that. There are so many people across the law school who have been helpful, from the Dean's Suite to marketing and communications to IT, and I know we're going to thank them throughout the day, but it really does take a village. I'm really excited that we were able to gather you all today at what I think is a really critical time in the legal profession. We are exploring reforms in licensing nationwide. We are thinking of how do we leverage technology, including the use of large language models, commonly known as generative AI, to both help what we do as lawyers and possibly think about opening up some other opportunities. So I think it's really important that we evaluate the role of the lawyer and think about what it is that we do. And today in our panels, we get to explore that in a very intentional and deliberate manner. Of course, at Mercer, we have been delighted to be at the forefront of considerations with professional identity, with so many of our faculty taking leadership roles, not just in the law school and the State Bar of Georgia, but across the country. And I know that all of our panelists have done that today as well. The symposium brings us an opportunity to gather and to learn from each other, and the conversations and presentations that we are having today are absolutely building upon those discussions and conversations and publications that we have been having for several years. What I'm most excited about is the impact of what we're talking about today is not limited today, and it's not limited to the individuals who are in this room, because the works are going to be published in the Mercer Law Review, and that is going to keep the conversation going nationally as you all probably get invited back to more symposia. I know that we have a very, very busy day and a packed schedule, but I did want to make sure to extend my words of welcome and appreciation to everybody who is here. There's lots of discussions about where the future is going. There's a time of great possibility as well as uncertainty, but I think one thing that we all know for sure is that the world needs more lawyers. So thank you for being a part of that today, and I turn it over to Professor Pat Longan.
Well, good morning, and thank you all for being with us today. As Mary Smith noted last night, the accreditation standards of the American Bar Association were recently changed to require every school to provide substantial opportunities for students for the development of professional identity. The interpretation that goes with that standard provides guidance, as she said last night, about what professional identity means for lawyers and how law schools should seek to shape the professional identities of their students. That guidance says that professional identity focuses on what it means to be a lawyer and the special obligations lawyers have to their clients and to society. The development of professional identity should involve an intentional exploration of the values, guiding principles, and well-being practices considered foundational to successful law practice. I want you to notice that this explanation refers to the values and guiding principles that are considered foundational. The assumption behind that part of the statement is that there is a universal set of such values and principles and practices that are and should be non-negotiable for all lawyers, regardless of the lawyer's type of practice. There are various very thoughtful ways of describing what those universal values are, and even though those descriptions do vary somewhat, they mostly converge, and they converge around notions of professional competence, fidelity to the client within the bounds of the law, and public service. And there is, I think, surprisingly little disagreement about what those core non-negotiable values are. With this symposium, Parts of a Whole and the multiple roles of a lawyer and professional identity, we at Mercer are endeavoring to take the next step in exploring what students should learn about professional identity. Beyond the universal, non-negotiable values and guiding principles for all lawyers, we ask, what should professional identity include more specifically for lawyers who serve in the different roles that lawyers serve in the profession? Is it different? How is it different for the advocate, the counselor, the judge, and the active participant in public life? Are there ways in which these bedrock values and principles should be refined in each of these roles? What values and principles might be added for each? And is there anything that we can learn from consideration of these various roles that lawyers play that might lead us to refine or to add to the existing set of universal values and principles? At Mercer, we did not start our work on professional identity when the ABA adopted its standard. We have been explicitly trying to teach it for over 20 years. It is not an easy thing to teach. This is the third symposium that we have hosted relating to professional identity in our continuing effort to find the best ways to do that. We're looking forward today to the chance to learn from all of you and through the symposium issue of the Law Review to share your thoughts and insights with the entire profession. Thank you all again for coming. I'm looking forward to the day. Thank you.
Well, after those four great speakers, you get me, but for anyone that doesn't know me yet, I'm Chase Smith. I'm the administrative editor for the volume 76 of the Mercer Law Review, and it's my distinct honor this morning to introduce you to our first panel. So I guess if our panelist and our moderator for our first round would like to come on up. Now, wait for them to make their way, but... To begin, we have Professor Joan Hemingway. She is a graduate of the NYU School of Law and is the Rick Rose Distinguished Professor of Law and former interim director of the Institute for Professional Leadership at the University of Tennessee College of Law in Knoxville. She currently serves as a teaching fellow at the Haslam Leadership Scholars Program and is a fellow in 3 university centers on corporate governance, entrepreneurship, and innovation, and the study of social justice. When she joined the College of Law faculty in 2000, Professor Hemingway had nearly 15 years of corporate transactional legal practice experience at the Boston office of Skadden Arps, Slate, Meagher, and Flom, LLP. Professor Hemingway's principal doctrinal scholarship focused on securities disclosure law and policy and on business associations law, including entrepreneurial and social enterprise governance and finance. She also researches and writes on law leadership topics. She is a member of the American Law Institute and a fellow of the American Bar Foundation and the Knoxville Bar Foundation. Professor Joan Hemingway. And just for her, after our conversation last night, go Bulls. Miss DeAndrea Morning. She's a 2007 graduate of Mercer University School of Law and currently serves as Vice President, Corporate Compliance, Chief Compliance and Privacy Officer, and in-house legal counsel for the Grady Health System, which consists of an academic medical center, the largest nursing home in the state of Georgia, EMS operations, and ambulatory clinics. In her role as Chief Compliance and Privacy Officer, Ms. Morning oversees the compliance and ethics function for Grady Health System, and she's a fellow of the American College of Healthcare Executives. She also represents in the health system in various legal matters, which specific focuses on healthcare regulatory, corporate governance, and compliance issues. Before joining Grady Health System as a Senior Associate General Counsel, Ms. Morning was a Senior Associate at Alston & Bird LLP for 6 years in the firm's healthcare practice group. Ms. DeAndrea Morning. Professor Ben Parrish. He is a 1982 graduate of Mercer University School of Law, where he served as Editor-in-Chief of the Mercer Law Review and was a member of the Moot Court Board. After beginning his legal career as an associate with King & Spalding, Mr. Parrish served as the general counsel of 4 companies over a 25-year period, most recently for Tractor Supply Company. As general counsel for those companies, he managed legal affairs and played a key role in successfully completing numerous acquisitions and financings and in resolving complex litigation. Under his leadership of Tractor Supply Company's environmental program, Tractor Supply was twice named one of Barron's 100 most sustainable companies in America. Drawing on his extensive experience as a corporate general counsel, Mr. Parrish currently leads the corporate counsel externship program here at Mercer Law. That is Professor Ben Parrish. Last but certainly not least is our very own Professor Daisy Floyd. She is the moderator for this panel. She is a professor of law and ethical formation here at Mercer. Professor Floyd also served as Dean of the Law School from 2004 to 2010 and from 2014 to 2017. Professor Floyd came to Mercer in 2004 after serving on faculties at the University of Georgia School of Law and Texas Tech University School of Law. Professor Floyd's teaching and research interests include ethics and professionalism, legal education, civil procedure, evidence, and remedies. Professor Floyd has a special interest in the way in which higher education affects the ethical formation of lawyers, and that is Professor Daisy Floyd. And that is our first panel, which is Lawyer as Counselor.
Could I get some tech assistance? Oh, there we go. I think I can get rid of this.
I wonder if we need to hit escape to get that.
Yeah, I probably do. Oh, there's escape.
One of the great things about teaching is there's always somebody young who understands technology.
I don't use a PC anymore, so I'm a little PC challenged. There it is. And it's just more search. And this hopefully will work to advance that.
We hope so.
Oh, that's great. Perfect. There we go. Oh, actually, it looks like we have a clicker over here too, so that's good. All right, so rough start. Good morning, everyone. I want to add my welcome to the ones that have already been offered. It's so great to see so many people here, although a lot of backbenchers. Just saying, I feel like I'm at home, I guess, coming into an environment like this. And it's a pretty auspicious thing to be starting a program like this. I'm so excited, though, to be here. I'm excited because of my friends here at Mercer Law, whom I love. I'm also excited about the new people I've already met and look forward to meeting later today. So we're talking, as you just heard from Chase, about the lawyer's role as counselor. And my sort of primary title has to do with dealing with context. And I want to invite you to actually think about, hopefully think about, let's see if I can get the slides to advance here. Not yet. Okay, I'm going to try one of these and see if that works. Better. No, so far not. Maybe I should sit over here. By the
might have to
computer.
sit
You're
here.
welcome.
Push the button. We can switch.
All right.
There we go.
There we go.
Perfect. Thank
Sorry
you.
about that.
That's okay. Okay, so I want to invite you to think about this diagram as I speak. And I'll bring it back at the end so you don't have to memorize it. This symposium has been a wonderful excuse for me to step back and think about what the relationship is between my role, namely the role of counselor. And I'll explain to you what that means to me, what it means to the ABA, and also what it means to me in a moment, and my professional identity. And then also leadership. As you heard, I actually write and speak and teach in that space as well. And we've worried. I was talking to Professor Tim Floyd last night about worrying about, like, what is the relationship between and among all of these things. So this has offered me the opportunity to step back and do that. So I'm going to start with the bottom part here, the practical legal skills and knowledge. For those of you in the room who are law students, that is sort of your primary job right now, because you've got the bar ahead of you, and you've got to make sure you pass that. Until you do that, you can't be part of our profession, right? But there's so much more than that to the practice of law, and I hope to make some of you all who are students excited about that today and about what the possibilities are. And part of the reason why I find this so exciting is this is my 40th reunion year from my graduation from law school. In the spring, I will celebrate 40 years as a lawyer, something I'm super proud about, super stoked about, and I love to teach the law now for that reason. And I teach it as a transactional business lawyer. That's my role, okay? That's not my professional identity. It's foundational to my professional identity, but I'm a transactional business lawyer. And so what does that mean? My second bullet on this slide tells you sort of what my statement is about that. So I do deals, right? I don't do litigation. A lot, I do sometimes. I'll come back to that in a minute. But most of what I'm doing is stuff that's outside of a courtroom, outside of where a judge is, outside of, quite honestly, a lot of where the professional responsibility rules, in my mind, take me. And this is my controversial statement here, right? The students have asked me to think about the model rules of professional conduct. And they've asked me to think about that in a personal way. The set of questions that they gave us were super provocative. I can't begin to answer all of them today, but I hope to touch on a lot of them. What I found is that the model rules, and I do live by them, and I understand that they are things that I need to live by, have not been super helpful to me in defining who I am as a lawyer. And I want to illustrate to you first why, and then show you what was useful to me, in case any of that is useful to all of you. So this is what the model rules say about our role as a representative of the client. And from the previous slide, you know that's where I see myself, okay? Transactional business lawyer representing clients of various different kinds in transactions. Yeah, I'm an advisor. Yes, I'm also an advocate, including in the sense that the model rules cover. We have to sometimes, as business transactional lawyers, suggest litigation, suggest mediation in order to get transactions done. Yes, I'm a negotiator. That's, I think, for most students, you think transactional business law, if you haven't been exposed to it, yeah, I'm going to draft contracts, I'm going to negotiate contracts. Sure, it's way more than that. And I'm an evaluator. I write legal opinions that are used by my clients. I write legal opinions that are used by other people, okay? And I have to do other forms of evaluation, sometimes program evaluation if I'm giving ongoing advice internally to a client. I think we'll hear a lot more about that from our general counsel folks later in the panel. And then there's the role of neutral. And some jurisdictions have this rule and some don't. I did not make myself familiar with the Georgia rules here today, but you can go look up and see what your rules are on being a neutral. So transactional business lawyers do all that, right? So it seems like, wow, the model rules really do speak to us, right? Well, yes. And they also tell us more about some of those roles, right? The advisor role, also covered, right? This rule should be familiar to, I think, a lot of you in the room. Candid legal advice is what we are supposed to give. And by the way, if you haven't read the leadership book, Radical Candor, high recommend, by Kim Scott. So that's my first book recommendation of the day. The evaluator role is also expanded on in the rules. Again, it speaks to legal opinions, including ones you might give to third parties. Okay, and I'm foregoing the comments on a lot of these, but you can be a neutral. There's stuff in the rules on that. So in addition to the preamble, telling us sort of about those general rules, we have some guidance. But did you ever notice that the role of advocate and negotiator within the role of counselor is not really addressed in the core rules in a meaningful way? So we are advocates and negotiators. I think we need more help So we were called upon to give suggestions for reform. That's one of my suggestions for reform, is let's say a little bit more about those roles to the extent that we can. So they're not really addressed in a way that I would hope. They're addressed more for the courtroom lawyer, right? And at least with respect to the advocacy piece. So what's really happening in my role? These things. This is what I think about when I think about what a transactional business lawyer is. I did mergers and acquisitions. I did public offerings. So I had to know all these areas of law, right, on some level. And I had to call on experts when I couldn't deal with those things on my own, right? I had to know how to find things about those laws that I didn't know. So I have this substantive expertise, also part of my role, right? And yet, all of this doesn't really begin to speak at all about my professional identity. It doesn't even really tell me everything about the role, because on the one hand, there's lots of information there. Some of it I don't really even need. On the other hand, there's not enough information there, as I've suggested, to really give me guidance. And so what do I think my overall job is? Well, it's basically, I have to understand where my client wants to go. I have to identify risks associated with that, assess those risks, and help my client to identify those risks and assess those risks, and facilitate decision making. It's not my job to make the decision, but hopefully to give both guidance on the law and norms around that. And so I'm planning, I'm strategizing, I'm drafting, I'm helping them enforce their rights in certain situations, consistent with advocacy. It's a lot of stuff, right? It's a little overwhelming to think about the kind of work that a counselor does in the business transactional space. So I said none of that really helps me, but it's there. It's foundational. It's part of who I am. It's maybe the base. What helped me to understand what my actual professional identity was? Reflecting on it, it's my yoga practice, right? So this is me. My hair was a little bit longer back then. That's the College of Law at UT, so I'm bringing a little bit of Knoxville to you today. I teach yoga classes at the law school to students and faculty and staff once a week this semester. My body is healthy enough for me to be able to do that, and I also teach some private classes to people who just want to know about certain poses. And one of the concepts when I was studying to be a yoga teacher that I learned about was proprioception, a word we don't talk about a lot, but it's basically a person's knowledge of their body in space. So as I get older and my balance is challenged, maybe I have a less good idea of where my body is in space, right? But that's something that as a yoga practitioner you understand after a while. When you've been practicing for a while, you begin to understand the relationship of your body in space. In reflecting for this symposium, I've learned that what I've really been doing in developing my professional identity is a version of proprioception with respect to my professional role and my professional existence. Namely, as I say here, my legal body in its space. It's contextual. We heard Mary Smith say last night that professional identity development is a process of becoming, right? That was super important. I wrote it down. I pulled out my phone, just very rude during someone's presentation, and wrote it down. She said it's a compass, right? Magnetic north and true north, for those of you who were there. And she spoke about each. It's about the integration of experience with who we are, who our personality type is, what our Myers-Briggs test might be, and other things that I'm going to speak to you about in a minute. So how have I used this concept? How did I come to this in reflection? So as I said, proprioception is really understanding where you are. So by living my life as a lawyer for 40 years, I've been able to, step by step, without even thinking about it, understand better who I am. And it's only today that I'm actually really putting labels on some of these things. So thank you for the opportunity to do that. We've seen and heard about this rule before, or I should say the interpretation that tells us what professional identity is. I think it's a nice definition, but it's also something that I think we feel from our hearts and our souls and our guts as lawyers. And I want to invite all of you to engage in the same exercise that I've engaged in today, to step back, look internally at your role and at what your professional identity is in that role, using this as guidance. There's a lot more in the rule here. your education here as law students is going to affect this. This role, this professional identity development, right, as part of our professional existence. Your practice over years, for me, it's been, you know, in a private law firm, it's been in consulting and not as the practice of law, but in expert witness roles. I've learned more about who I am as a lawyer. And I make my students read testimony that I've given. That's sort of interesting. Professor Byers has been part of that exercise in one of my classes. But it's also about us getting together as a bar, us getting together as academics and as practitioners and talking about this and listening to each other's stories. And we have been invited to give personal narratives today, as I'm doing today. So all of this is part of why we hang together as lawyers. It's part of our commitment to the profession, to each other, and to the society around us that law serves. And it's, to me, it's super inspiring. So where did all of this take me as I was thinking about it? This is where the leadership part comes in. I realized as I reflected on my professional identity and as I continue to develop it as my career moves forward, that really where it was heading me was to leading as a lawyer, something that I teach, that taking that professional, foundational, substantive core of corporate finance law that I've learned and that I've practiced, and then moving through that and determining where my legal body is in space was teaching me along the way to be a leader. And that by being a leader, I also then was infusing that practice so that it became part of that circle that we talked about before. By the way, these are folks that I've met along the way who are part of my professional identity, who have helped me to see who I am. That's one of our instructors in the leadership program at the University of Tennessee at the top, our former dean on the bottom, who's one of the co-founders of our Institute for Professional Leadership at Tennessee, as well as some of our alums, two of whom I know super well, who come in and teach in our program, just as Ben does here. I think it's a wonderful thing to continue to have lawyers in our classrooms all the time, with us and without us, quite honestly. So the reason why I see this connection between professional identity and leadership is because of values. And they've also been, they're spoken about in the professional identity rule, they've been spoken about last night and this morning, values. What kinds of values infuse my existence, my professional identity? Emotional intelligence just jumps out at me. But the whole process of determining who you are as a professional is about self-awareness. It's about self-identity. It's about putting some kind of a label on who you are and being able to describe that. It is about resilience. I've been through financial crises, several of them now over the years, over 40 years, as you might imagine. I've been through personal crises, and I've had to come back from all of that and still step up and do all of that work for my clients. And basically, again, this is all laying for me, and Professor Short says it, I think, quite well from Texas A&M. It lays a foundation for effective leadership and gives us valuable tools. That's the connection that I see. Buck Lewis is one of our founders of our Professional Leadership Institute, and he and our former Dean Doug Blaze, the other co-founder, have written a wonderful article, Training Lawyers the Very Best Way We Can, from a number of years ago. I have two quotes here that I think are important. This is about self-awareness, self-perspective, and as I said in the prior slide, self-identity. So this is about us stepping back and looking at things, something we probably don't do in our common practice altogether that often. So what have I done? I've done, in addition to Myers-Briggs testing, I'll spare you that today, but I have done VIA character strengths testing and Clifton strengths testing. And I've highlighted two of my top 5 characters in both. And if you don't understand what those testing processes are, they're looking for internal strengths within you that are not related to law, right, but that you can use as a practicing lawyer and as a lawyer leader. My 2 top ones, Love and Woo, when you go look them up, don't do it now on your phones, maybe during the break, right, but go ahead and do that. Both speak to the same thing, and so do the characteristics underneath them. Notice learner, love of learning, all kinds of things that are common about these. It has to do with relationships. I just wrote a piece about leading in relationships, and somehow I wasn't necessarily seeing how I fit into that picture until I had to prepare for this symposium. And so my conclusion is, not just that healthy relationships are important and relationship management is important generally, which is what my article speaks to, but that I'm a relationship builder. That's the core of my professional identity as a counselor. I've looked at myself, and that's who I am. And it's not surprising. And it's an emotional intelligence attribute, right? So, some practical legal knowledge is our base. We layer onto that this self-awareness, self-discovery, self-identity, and get ourselves to leadership, and it comes back around, and we just keep going around that circle for our whole careers. As my husband said, the two things I do most, yoga and law, they're both about practicing. He said, aren't you ever going to get there? Just keep practicing? And I said, yeah, but that's the beauty of it, is we wake up every morning with more work to do. So that's the diagram. Is this the whole lawyer? I welcome your comments. I welcome your thoughts as to how well that resonates with you. And thank you very much for your time this morning.
Thank you, Professor Hemingway. We talked last night, and we were trying to decide what order we were going to go in, and nobody wanted to go after the other person. So thankfully, I'm going after Professor Hemingway. It's wonderful, and she certainly laid the groundwork for us today. So as our student who introduced us said, I am DeAndrea Morning. I'm Vice President, Chief Compliance and Privacy Officer for Grady Health System in Atlanta, Georgia, and a proud graduate of Mercer Law School. And Dean Floyd was my dean when I was here, so thank you for the invitation. Yes. So thank you for the invitation to be here today. Thank you, Dean Snedden, and to the Law Review students. Rachel, thank you, and Professor Jones. So I don't have a slide presentation. I have been tied up with a myriad of things at work, but I am going to talk to you about what I think my role is as the Chief Compliance Officer at a major academic healthcare system is as counselor. So I always like to start at the beginning, at the root of the word. What is a counselor? And many definitions, but a counselor in the legal context is a lawyer or attorney who provides legal advice or guidance to clients, helping them navigate legal matters, make informed decisions, and manage risk. All of the things that Professor Hemingway discussed with us. This role includes not just advocating in court, but advising on legal strategies, ethical considerations, and practical outcomes. But I also like the general definition. And the general definition of a counselor is a person who gives advice or guidance on a particular subject, right? And you can kind of take that and then frame that into whatever your subject matter is that you are working within as an attorney. And I think all of us kind of took something from the speaker last night, Mary Smith, when she was talking about her journey through her career and really having that North Star, that true north that guided her. And so one of the things that I wanted to share with you all that I use as my North Star is the Lawyer's Creed. Is anybody familiar with the Lawyer's Creed that was published by the Supreme Court, Professor Longan, by the Supreme Court of Georgia? I'm sure if you have taken his professionalism class, he has shared that. So for me, this is my North Star as I practice, and I'm going to share it with you all. To my clients, I offer faithfulness, competence, diligence, and good judgment. I will strive to represent you as I would want to be represented and to be worthy of your trust. To the opposing parties and to their counsel, I offer fairness, integrity, and civility. I will seek reconciliation, and if we fail, I will strive to make our dispute a dignified one. To the courts and to other tribunals, and to those who assist them, I offer respect, candor, and courtesy. I will strive to do honor to the search for justice. To my colleagues in the practice of law, I offer concern for your welfare. I will strive to make our association a professional friendship. To the profession, I offer assistance. I will strive to keep our business a profession and our profession a calling in the spirit of public service. To the public and to our systems of justice, I offer service. I will strive to improve the law and our legal system, to make the law and our legal system available to all, and to seek the common good through the representation of my clients. So for me, that's the North Star. That is what we should aspire to do. And so I think the role of counselor, it also translates across a number of the things that you all are going to be talking about later today. Advocate, neutral, service to the public. Our role as counselor kind of encompass all of those things. So what do I do? As the Chief Compliance Officer for Grady Health System, I use my legal background, that practical legal knowledge that I obtained working as a healthcare regulatory attorney to advise the organization on healthcare risk, on healthcare issues, to oversee and implement our compliance program so that we comply with all of the laws, rules, regulations, standards that govern us as a provider of healthcare. And I ensure that we put into place the mechanisms to avoid potential issues under the law. And so as part of that, I have to think about this role as counselor and compliance officer. So for me, and I also still wear a hat doing legal work, but I will let Professor Parrish talk about the general counsel role and in-house counsel. And I'm going to kind of focus just on the compliance portion. So as a compliance officer, being that counselor and providing that advice and guidance, what is the most critical thing that you have to do is you have to know your client's business. You have to know the business strategy. And that's one of the key and most critical components of helping to provide the necessary advice and counsel to your client, is understanding what they do. And so I shared a story with the law students that were at the table with us last night. When I worked at Austin & Byrd, I had the opportunity to work in-house with UPS. And I went in-house, I was a healthcare attorney, and I'm like, why are they sending me to UPS? It's a logistics company, they send packages, why am I here? But they had a healthcare arm of their organization. And so I went to do their healthcare work. But one of the first things that they make any of their attorneys do is you have to learn the business. So I had to ride on a truck. I had to deliver a package to a client, to their customer. I had to see the logistics from start to finish so I could understand what I was advising on. As a counselor, you have to understand the business. You have to know when you are in-house and you're a corporate attorney, you have to really understand and have an appreciation so that you can understand the impact of that business decision. It's not just about the law, it's also about ensuring that what you are doing and what you are advising on makes good, practical sense based on what it is that your business is built on. So you have a dual role as an attorney and a compliance officer. And if we look at the preamble, the model rules from the ABA preamble, we have to recognize that for the role of the compliance officer, part of that forces us to ensure that we provide ethical guidance to our client. And from a compliance perspective, that is huge because you sit sometimes in, I don't want to say direct contrast sometimes to the general counsel, but it's a difference in roles. So as a compliance officer, your role is to identify the risk, to address those risks, and to help to mitigate those risks. The general counsel and the attorney arm and the legal arm of the organization has a different responsibility. And so sometimes there can be that tension of what's appropriate, how best to handle a situation. And how do you work together with your legal counsel to ensure that you are coming to the most ethical and appropriate and legally appropriate decision for your client? As a compliance officer, you have a duty to the organization and not to people in the organization. And I think that's a challenge for a lot of people because you are partners and you're working together. You are colleagues, and a lot of times, sometimes these folks are your your CEO or your CFO, but your duty is to the organization. And there is a lot of guidance from the federal government, a lot of things that have come out that are holding compliance officers responsible for the activities of their corporation. And having that professional liability now sit with the compliance officer as well. And there was recently a case that was issued where the decision said, as a compliance officer, it is your duty to ensure that you are proceeding from an ethical perspective, that you are ensuring your client is proceeding from a legal perspective, and if you have ethical concerns, it is your duty to leave that employment. And I struggled with that decision. And I ask you all, for our aspiring attorneys and those that are currently practicing, if you knew that you were representing a client who was doing something unethical and you were employed by that client, how easy is it for you to leave that employment? Even though your personal ethics, you may be conflicted. I said, wow, when I read that, I said, wow, that is a very strong opinion to come from the court to tell someone, just leave your job. If you are ethically conflicted, just leave your job. And how many times do folks, even when you're representing a client, you have an ethical conflict, do you say, I can no longer represent you? I have to step away from this representation. So something for us to think about, but that is our duty. Our duty is to the organization to ensure the organization is functioning from an appropriate perspective and ensuring that we have both legal and ethical integrity, even if individual executives have a different priority or interest. We also have a duty to advise and to warn our client. So the preamble emphasizes the lawyer's duty to counsel clients and advise them on the potential legal risk of non-compliance. As compliance officers, attorneys are responsible for identifying, analyzing, and addressing the risk, as I mentioned. If you become aware of an action that could harm the organization and you advise that leadership, what are you doing to implement things to prevent further violations? What are the necessary steps? How far do you go? One of the things that you also have to ensure when you are in-house and you're working from a compliance perspective is having a very strong relationship and connection with your board of directors, because that is your outlet for, even if your internal executives that you're working with may not see, may not want to move forward with the things that you identify potentially as risks, the things that you have provided advice and counsel on in your role as counselor, that you have that board to go to ensure that you have someone to help you maintain the integrity of the organization. Another key component for compliance officers to really think about is confidentiality and disclosure. So most compliance officers have responsibility for overseeing their organization's what we call compliance hotline. Some places call it the ethics line. Some people call it the help line. But it is, all organizations are required to have a place where employees can present anonymously any issues and concerns that they may have with the organization. And those typically come through the compliance department. And how do you handle those disclosures of issues? How do you maintain confidentiality when you are working with employees in your organization? And you learn of something of significance or something that is potentially a violation. And knowing when and having enough as integrity as a counselor and understanding and appreciation for the law to know when you need to turn that over to your legal counsel for them to handle and to take it out of your office. So ensuring that as a compliance officer, that you balance this duty of confidentiality and that you maintain the integrity of the work that you do, and so that people can understand that reporting is okay. You don't want to send out a chilling effect across the organization. You want to make sure that people understand that they can disclose, and you provide sound advice in that role. I like to say, when people ask me what I do, I say I'm an investigator, I'm a therapist, I'm a counselor. You know, I sit on many hats, but really a lot of that is taking a play on the word counselor. It really is also counseling the employees that come with issues. You have to make clear that you represent the organization, but also in the role that I sit in, I do have to oftentimes provide counsel to the employees that raise issues and concerns. And then another major component of what I do is addressing conflicts of interest and making sure that individuals in the organization understand the role that we play in the community and how we are seen and how we are viewed, and ensuring that there aren't any acts of impropriety or that there aren't any acts that could be viewed negatively upon the organization that would appear to be a conflict. And so part of the preamble also tells us that we have to adhere to the ethical standards, that while sometimes there may be conflicts within our organizational priorities, we have to ensure and counsel the organization to move forward in an appropriate way. Our ethical duty as an attorney takes precedence. And so the compliance officer has to guide the organization to avoid any potential conflicts of interest that could reflect negatively or impact the organization negatively, and maintain professional independence while we do so. So I just want to close out by saying that from the perspective of a counselor, as a compliance officer, there are a lot of components, but the major thread that I see in terms of our role and how we provide advice and guidance on the particular subject that is presented to us is that common thread is ethical consideration. For me, my North Star, starting out as an attorney, is the lawyer's creed. And on the bookend of that, my North Star and the thread that weaves it all together is ethical consideration. And so in that first part of the ethical creed, it says, I want my client to have trust in me, to know that they can trust what I say. And I think you only get to that trust, you can only build that trust if you have that foundation of ethical practice, ethical considerations, ethical guidance, ethical advice, ethical guidance when you're functioning in the role of a compliance officer for your organization.
Well, boy, two tough acts to follow. I was worried last night about following DeAndrea because she has been kind enough to speak to our corporate counsel externship class and to our corporate counsel society here, and so I know what a great speaker she is. And Joan, you hit a home run, and so anyway, here I am following the two of you, but I'll do the best that I can. So as general counsel for companies, there were four very distinct companies in different industries. I had the chance to wear many hats. One of the things about being general counsel of a company is you are the general counsel. So I remember I was only 38 years old, was wholly unprepared to become general counsel, but my boss, the general counsel who had hired me and had me relocate, left about 2 years into my tenure. So I had the opportunity to serve as acting general counsel, but I was going from I viewed myself as a somewhat of an expert at securities, corporate, and transactional law. But suddenly I was thrust, and struggling to be an expert in those areas, suddenly you're thrust into this role being responsible for litigation. You're responsible for employment matters. You're responsible for becoming this counselor to the senior leadership of the company and to the board of directors. So it was a huge leap for me to go from being specialized in a transactional practice to being the general counsel of a company. And honestly, I think it took many years for me to grow into that role. And I'm very appreciative of my bosses who were also mentors. They were non-lawyer mentors of mine, as well as mentors that I had who were lawyers who helped me on that journey to becoming, hopefully, a good general counsel. And again, being a good general counsel to me means being a good advisor, a good counselor. In my view, there was no greater compliment than being called counselor. And my second to the last boss, the CEO, second to the last boss when I was at Tractor Supply, always referred to me as counselor. And I don't know, I've never told him this, but I loved it. I loved that title, and I loved being a counselor. God knows I'm not a litigator. I proved that on more than one occasion early in my career. But I loved being a counselor. So it was definitely my favorite role as general counsel. And again, I view the role of counselor as one of the highest callings for the legal profession. Because it requires not only a good understanding of the law, there's certainly the technical aspects to it, but it requires a broader understanding, as DeAndrea said, of the business. I mean, you really have to learn the business and learn it inside and out. And you do it in a variety of ways. One of the things we do in the corporate counsel externship class, in fact, if we have any students in here, you're doing this next Tuesday. They will do a presentation each semester on the business and culture of the companies where they're externing. And so they really begin to understand the importance of, if you want to be a good lawyer for your client, you need to know your client. So that process, we're trying to get that started early in the development of the student's professional identity in the corporate counsel class. But it requires not only an understanding of the business, but you have to understand factors outside of the business. And it requires good judgment, which I think is something that hopefully you develop over time. It requires common sense. I mean, very often when you're put into that role that DeAndrea was describing of counseling someone, you have the advantage of being dispassionate. So you'll have people come to you who, their hair is on fire because they've got a major problem and they need advice. And as the attorney who's not directly involved typically in these matters, you can be dispassionate, you can be objective, and you bring that calmness to help solve the problem. And frankly, again, your common sense plays a big role in this. So those are all important aspects and important attributes, I think, of being a good counselor. I think being a good counselor also requires you to be a good listener. And you have to be a good listener, but you also have to ask questions. And I think, with the students in the externship class, that is the biggest issue they have to overcome when they're beginning their externships and they're beginning their legal practice, is because no one wants to appear to be dumb, right? You want to appear that you know everything, you know it. No, you have no idea what you're being asked to do. You need to raise your hand and ask more details. You need to ask dumb questions because they're really not dumb. So that's one of the things that we spend a lot of time in the corporate externship class working on, is just simply asking questions and going back for follow-up as necessary. But again, part of that is also, once you ask the question, being a good listener, taking notes, doing all of these. They seem like little things that add up to being a successful lawyer. But I do think being a counselor, in this role of being a counselor, it offers the attorney the opportunity to exercise all of the responsibilities in the preamble to the model rules of professional conduct. As Joan said, the preamble makes it clear that our responsibilities as lawyers, it goes beyond zealous advocacy for our client. We have broader responsibilities that include serving as an officer of the legal system, and as a public citizen, we have and a lawyer, we have special responsibilities when it comes to the quality of justice. So I think that's important in our role as counselor, and it helps me focus on the fact that we have to take into consideration ethical consequences of our advice. Again, one of the things I liked about being a counselor is that you not only can, but you, in my opinion, should consider the ethical consequences of an action that your client is about to take or is considering. Another aspect to that is I think you need to not only consider the ethical aspects of the decision, but how it impacts others. Not just your client, but others outside of the organization. So again, I think it allows us as counselor to take all of those things into consideration. The ethical aspects, as well as the impact on the client and others as well. So Rule 2.1 of the model rules and the comments to 2.1 luckily permit lawyers to refer not only to the law, but to these other considerations. And the considerations that are laid out in 2.1 include moral, economic, social, and political factors that may be relevant to the client's situation. So again, in that role as counselor, we are allowed, specifically by the rules, to take these other factors into consideration. When I think about the lawyer's role as counselor, I think it's helpful to consider a concept that I'm sure we've all heard about or familiar with, the concept of the lawyer statesman. And this was a concept that was outlined by Ben Heinemann in his book, The Inside Counsel Revolution. Mr. Heinemann served as the general counsel and senior executive of General Electric Corporation for 18 years. Now, while Mr. Heinemann is referring specifically to the role of the modern general counsel as a lawyer statesman, I think that concept applies more generally to a lawyer who is serving in the role of counselor. And in the book, Mr. Heinemann says the ideal the lawyer statesman is, number one, an outstanding technical expert. Secondly, a wise counselor. And third, an accountable leader who plays a major role in assisting the client, in this case, the corporation, achieve its goals. He also writes that for the lawyer statesman, and I think this is the most important point, he writes that the lawyer statesman, the first question should be, is it legal? But the ultimate question should be, is it right? So you look at more than just, is it legal? But you also take a look at the moral implications, the ethical implications, and try to answer the question and explore this with your client, whether it is right. But with training and experience in policy, law, ethics, and process, most lawyers are well positioned to provide a unique perspective as an advisor or counselor. I mean, after all, law school teaches us how to think logically, and it provided us with a good understanding of laws and regulations in the legal process. But he explains that, you know, when he talks about the term lawyer statesman, it's not meant to just be some platonic guardian ideal, but the practical act of asking whether an action is right in light of its purposes and consequences, considering a broad array of perspectives, including commercial, prudential, legal, ethical, risk, and citizenship. But it's the act of asking the hard questions that is critical. And that really goes to the heart of being a lawyer statesman, asking the hard questions. And to do this, the lawyer statesman must have character and independence. And as DeAndrea mentioned, a lawyer has to be prepared to resign over an issue that involves an ethical dilemma or a moral dilemma. And it's very difficult for many in-house lawyers because you are at times, many times, put into positions that raise those kinds of questions. You know, one of my mentors reminded me just recently of a story, something that happened to him when I was working for him. But he went in and his client, the CEO of the company, he was the general counsel of the company, my friend, the CEO asked him to do something that, in his view, was unethical. And he told the CEO, no, I'm not going to do that. And the CEO said to him, well, I want you to think very hard about this, and I want you to go home and come back to me and give me your answer in the morning. So he went home, told his wife, we need to start preparing to pack up and move. I'm going to be fired in the morning because I'm not going to change my answer. So he went back to the CEO the next morning and said, no, I have not changed my mind. I gave you the correct answer yesterday, and I'm not going to agree with what you're proposing. He fully expected to be fired or asked to resign in that moment. Fortunately, he was not. And the CEO just simply changed the subject and moved on, and he spent another 6 years as general counsel of that company. But the point is, you have to be prepared in those situations to potentially resign or, at a minimum, take it to the next level. If it's the CEO where the issue lies, you may have to then take it to the highest authority within the organization, which is typically the board of directors. So the lawyer-statesman has to have the capacity, as we mentioned, to see problems from different perspectives, drawing not only on legal skills, but on non-legal knowledge and vision in all aspects of the business. Now, as the leader of the Corporate Counsel Externship Program here at Mercer, I have the distinct honor and privilege of working with a lot of in-house counsel and a lot of general counsels who either mentor our students or they come and speak, as DeAndrea has, to the students. And so I get to hear their perspectives. And much of what we talk about in class really is about formation of the student's professional identity. So I get to hear their advice. And I don't always agree with it, but usually it's very insightful information. And the number one thing that I would say that our guest speakers and our mentors to the students tell the students is that you have to understand the business of your client. And that's first and foremost. But then the other thing that they talk to the students about is that, especially as you get more experience in your position as an in-house lawyer, you are called upon to give business advice. And in fact, this past week, we had a senior attorney with a major corporation say, and he's been with the company for 26 years, but he told the class that probably 50% of his advice in his role as counselor would be considered business advice, and only about 50% that would truly be legal advice. But I do think that there are a number of attributes, and I see that I'm running out of time, but we talk about a number of those attributes with our students that apply to being a good lawyer and especially to being a good counselor. But I do think that what we've seen over the last 25 years is there's really been an evolution of general counsel to being a much more senior executive involved in decision making, who can give the advice that can help with strategy and help prevent problems. And I think it's that prevention of problems in the future that is an important role of the general counsel and of a counselor. We also see that there's been a huge growth in in-house lawyers at companies over the last 25 years. And in fact, recent surveys have shown that there are now more in-house lawyers than there are lawyers who are part of big law. So there's been a huge growth in that area, and I think it's primarily because we have lawyers who are in-house, who are dedicated to one client. They know that client, they know the goals, they know the culture of that client, and it enables them to be a very effective counselor for that company. And with that, I see that my time is up.
Thanks to all three of our panelists. It's been really thought-provoking and energizing. And if you were at all like me as you've been listening to this, it's also generated some questions. So our panelists have agreed to take a few minutes to answer any questions. So what questions do you have? Yes.
For Ms. Moore. So, a healthcare system has so many different components of the law that you have to stay on top of. For instance, liability, waste management, FDA, kind of everything. How do you stay on top of identifying risk proactively and analyzing it with a clear mind and deciding what proper course of action needs to be?
Yeah, it's a great question. Thank you. So one of the things, we actually just did this, is I work with our executive team to do our annual risk assessment. So I am not doing and evaluating and determining our risk in a vacuum. I work with our leadership team to determine those risks because they are varied across the organization, right? As you mentioned, all types of regulatory issues and operational issues. And so we do, as a leadership team, we do our risk assessment and we make a determination on our high priority risk. We stratify those risks and determine what we can tackle as an organization based on key priorities, impact to the organization, availability of resources to address those things. But to your question about how I stay on top of it, it's a lot of reading. And one of the things we talked about, having that practical knowledge, is staying up to date, being a part of a lot of industry affinity groups that send out information to kind of keep me on top of the latest things. But also, as a lawyer and as a counselor, knowing when I don't know the answer to that, knowing when that's not my specialty and I need to bring people that have that skill set, who are that subject matter expert, to the table, knowing when I need to engage an external auditor maybe, or outside counsel to come in and help do that evaluation. We actually talked about doing enterprise-wide risk assessment practice, which would take it beyond just your traditional kind of healthcare focus and really look at a larger scope. And we had to say, that's not something we can do in-house. We had to, make the decision to transition that to an external party to do, because they had the expertise to do that. So part of your role and my role and when you go out and practice is you have to know what's within your span of knowledge, what's within your span of control, and when it's not, having enough comfort to bring in the right people, having enough comfort to know who needs to come in to advise. But it's also your job as counselor to stay up to date on the information and to make sure that you have the knowledge and that you continue to build and continue to educate yourself so that you can make the most informed decisions and provide the most informed advice to your client.
It was really interesting that there seem to be kind of two different narratives that the panel is offering. One is the kind of the role of in-house counsel as traffic cop, trying to sort of maintain compliance, and the other is kind of the role as team player, as part of the offering business advice, and presumably you are loved within the organization to the extent you're a helper, and traffic cops aren't necessarily perceived that way. I'd like you to talk a little bit about what I think is that tension.
So, Deandra, you're the traffic cop.
I am.
And I'm the beloved counselor, right? Now, I do think, you raise a really good point, and I think there's a reason that a lot of companies have decided to have compliance and have a chief compliance officer separate from the role of general counsel. Now, I unfortunately had the responsibility for compliance in my group because you do have to, in that role, you do have to at times play a bit of the traffic cop or the cop saying no versus just giving pure advice. So I personally like that model better, where you have compliance separate from the general counsel. But your point about UPS though resonated with me. I think to be accepted in your organization and for your advice to be taken seriously, you have to demonstrate that you're willing to be a servant leader. And that's the term that we used often at Tractor Supply, and it was an important part of our culture, is being that servant leader. So as part of the executive team, we would visit stores. And we'd go in the store, and we didn't come in to criticize. We didn't come in to, give great advice. We usually came in to say, how can we help? And I can't tell you how many times the CEO and I and the CFO would be over rearranging the jeans in the jean department or putting shirts on the right racks, or a truck just came in and we're putting inventory up on the shelves, usually in the wrong place, by the way. I think they had to clean up our mess after we left. But I do think it's important to demonstrate that servant leadership, and show that you're not, this lawyer, statesman, or you're above the folks in the organization, that you're part of that and you understand what they're doing, and that informs your ability to give good advice. But what are your thoughts about that?
Yeah, it certainly is that tension of the strategic business partner oftentimes being the general counsel, and compliance oftentimes being seen as the department of, what I like to say, the department of no. And so I have made it, a priority for me and my team to reframe that and to become the department of KNOW, right? Which is, we want to be seen as the place that you can come, so that we're all together, so that we are seen also, compliance is also seen as a strategic partner, because we're going to help and advise and provide good counsel on the front end versus on the back end to say there's a problem. So I like for people to involve me as part of those decisions, so that if I do have to stop traffic, they know why, and they know that Deandra is stopping traffic and there's a good reason why, and not just saying no. I heard someone say, give an analogy of, someone takes a ladder and props it up on the side of a building, and they say, well, I need this ladder to go on top of the building, and compliance is like, no, you can't do that. Instead of saying, well, what's on top of the building that you need to get to? So that's the answer. That's the question is, what's the objective? What are we trying to get to? There may be another way for you to get there, not just propping a ladder up on the side of the building to get there. So it's kind of reframing that. I think compliance in general across the industry is really trying to work to shift the narrative of being seen as the bright yellow vest with the stop sign.
And I'll just add a quick footnote here, which is that if you're outside counsel, you can be called in to support the trust or to support the no, N-O, right?
Yes.
And so you can deflect so that you're, allowing someone else to make those decisions for you.
I did that many times.
Yeah. Yep.
Thank you.
I've been on the other end of that many times.
Ms. Hemingway, you mentioned your interest in yoga and the mind and body, and how has that helped you? Because there were a lot of questions raised about some really difficult ethical questions. How has that helped you in those types of situations, maybe making a hard call?
Yeah, so in the interest of time, since we all had more to say, I think, than our 20 minutes, I did skip over that value, but it was on one of my slides. Well-being, the holistic well-being, physical, financial, emotional, mental well-being of lawyers is a predicate to everything, to any professional identity we're going to talk about today, to any of the work we're going to talk about today. I was saying last night to some people, it's like and we've used this analogy a lot in class, but the airline, when they're telling you that if you're with a child and you need to help the child, you put on your own mask first, right? Your own oxygen mask first. If you're not taking care of yourself, you cannot help others adequately. That's super hard. We're talking about, these folks work in high-stress environments every day. I've had the opportunity to tell a client, you don't want to do this deal because what they want to ask us to do is borderline unethical, and the client has backed out of the deal, right? And it's like going home that night that guy had to do and decide, is this really what I want to tell my client to do? Technology, I do a lot of law and innovation work. It's the shiny new penny. Everybody wants to work with blockchain. I'm going to be talking about that at a different conference back at UT tomorrow. Everybody wants to work with AI. Your dean raised that earlier today. We have to. It's there, right? It's so exciting, but there are so many perils in the sort of crossover between law and innovation. So I found yoga, but I encourage mindfulness more broadly, even if it's just flower arranging. I'm looking at these beautiful flower arrangements on the desk, or maybe you can read with the kind of focus and intensity, the kind of awareness that allows you to get into a mindful space. Our minds are full, right? So we should try to be more mindful and pull ourselves away from that. But also, balancing your checkbook, spend time doing it, right, so that you don't have that stress on you. It can be done online now. You don't have to handwrite little things in a book anymore like we used to have to make sure that you are taking care of your physical wellness, not stop going to the gym, not stop walking, not stop the physical practice of yoga. Yoga has 8 limbs. One of them is meditation, one of them is physical asana practice, and another one is breath work. Those are all great things to do. So thank you for the question, and thank you for allowing me to pull that out of my slides. It's a super important value for me. It's part of what has enabled me to be a relationship builder. You can't be in a relationship if your life is falling apart around you for one reason or another.
Thank you. I think to keep us on time, we're going to stop now, but I do want to thank the panel. One of the things that really struck me as I was listening to our panelists is the way that they captured their professional identities, and not just their professional identities, of course, but their holistic identities, because we heard relationship builder, we heard about DeAndrea's North Star, and we heard how you love the title counselor. So I think it's just a great reflection of the opportunity that awaits our students out there as you all embark on your careers, to embrace those various aspects of yourselves as you continue to develop your identities. So thank you for your part in helping that process today.
Oh, heavens, wonderful.
Thank you.
It is really wonderful that the volunteers, have the same color all y'all do here, so that I can carry this with pride back in Knoxville. Thank you.
Well, thank you again so much. We're going to take a 15-minute break, and then we'll come back for our second panel.
Ben, that was great.
Thank you.
Really well done. Really, really well done. So many good things in there. I could see you were leaving a lot on the table from that last page of your notes.
Several pages.
Yeah, I know we all have that. I think we're going to have that problem. Sorry,
Thank you. I enjoyed that. Especially mindfulness. We do a lot of work with that with public defenders.
Oh, yes. We just talked about compassion fatigue in the public defender last
Absolutely.
week.
And
I'm going to show you.
you've probably heard about moral injury.
Yes.
Which is something that plagues public defenders.
Yeah, you may never leave.
And my brother was a social worker, but I'm going to show you something. I sent a text to you.
We have a bottle or filling station where there's a submission of a book and then a personal anecdote from the person who submits the book explaining how this helped with their professional identity.
Thank you.
Accessible to upcoming leaders.
Send me an email. I'll talk to you about it. See what we do, because I love
on this next panel as well?
I am, sir.
I'm John Rappin.
Hey, John Christian Stegman.
Christian, great to meet you. Great to meet you. Did our seats taken? Is that
You have whatever seat you like.
whose stuff is that?
Well, I don't know. I know the moderator sat in his seat the
All
last
right,
time.
I'll grab this one. Chris? Justin. Justin, I'm sorry. Okay. So Justin, show me again, what do I need to do when I'm right down? Do I hit escape to minimize that?
Yeah, you'll hit escape here,
Uh-huh.
and escape again.
Escape twice. Minimize it. All right, open it. And then, is this clicker working?
Yes, sir.
All right.
Powered off last time.
Got it. Okay, good. And let me put your other thing back up.
You speak to first.
No, I'm last. Professor Jones.
Jones.
He's
Jones. McCain, Sam Van Tucker.
Okay. So which one was your, is that the?
Yeah.
I really did feel bad about hearing
Chris forwarded me one that was I put on this morning. I don't know if that's the right one.
Okay.
We can get her a hook. You're a pro. I know. You're gonna hit your mark.
Yeah, respectfully, yours is. I think you totally.
You just want to stay in the same order? So everybody's comfortable with that?
Yeah, I think that's what. I'm trying to think. I wrote it down.
I kind of panicked. I thought this would be more of a conversation. It's like, I gotta get up and talk for 20 minutes. Okay, I can do that.
Yeah, I guess the only question is, do you want to go second or third?
I'll do it.
You go third?
Yep, that makes sense the way it's situated.
Yeah.
Second season is great. Third season, we're struggling.
Okay, I may not be the best person. I'm not ethical. I find that hard to believe. I've done this. Hi there.
Hi, I am introducing, my name's Sydney. Hi,
Sydney
Sydney.
Christian Stegman.
I'm introducing y'all, and I wanted to see if there's anything special y'all want me to add into y'all's biographies. I think I have a general overview.
So if you can remember, apparently when they talk about their practice areas, they say alcohol liability and dram shop, those are the same. So if
Okay.
you just put alcohol liability, it's fine. It'd be repetitive. That's my fault.
And redundant.
Yeah. I can put my cats in. I used to represent the Ethics Commission in South Carolina, which regulates all the electioneering communications under our Ethics Act. And I haven't done that work probably now 10 plus years. Once they changed executive directors and general counsel, they found somebody else they liked better. But we were involved in a lot of it. Back in 2006, 2007, with the issue advocacy in South Carolina, with like dark money. It's in the name of issue advocacy, as you know, rather than electioneering. There's almost no regulation, and they avoided the definition of committee in South Carolina.
You mind going second?
So we're now, where the money's coming from, how it's getting spent, who's actually doing the communicating, none of that is regulated. And Wild West, yeah, it is. People I represent don't have the money.
Certainly not to pay you.
No. I guess we're in the order we're going to speak. All right.
Did you get my comments?
Sounds good.
I didn't mean to spring a whole nother mess on you, but it just occurred to me while I was looking at it. I know.
I do. But I think I talked to Justin about how to do it.
Okay.
And the more I thought about it,
Escape twice, minimize, open that folder. Minimize.
I mean, obviously that it can be interwoven with a client relationship that's different.
Got it. And then I just need to make sure the clicker is on.
Yes, I turned it off to save battery, but
Not a problem.
So glad you're here.
Hey,
Really.
good to see you. Yeah, that's what's up. Good to be here. How are you?
I'm doing well.
I'm really
delighted you came down here.
Glad I could do it. I had to teach a class last night. I've got an appointment at 4 back in.
Yeah, I heard you had to come and go quickly, but I'm glad you took the time to do it.
Yeah.
That's one of the most heartening things about my work. I don't know how it is for you. I've still got plenty of them that are not interested in that. You've got a much higher percentage of them that will make a difference in the lives of not only road many of them in public defense, maybe more there than in civil defense.
Well, that's good to know, because I
I'm looking out there, and these guys are students primarily.
Right.
And yet I can look out there and see a handful that I know already are. Several of them have worked in political service.
Let me tell you what the secret sauce is. So I do know some of the things. And so for years, I hired a couple of officers. I know what I'm accepting solicitors and not just the attorney. They've been,
cases.
well, the solicitor in my circuit,
So do
he's
you
about to
agree or
have my
disagree
head.
with me
I've had
that
it
the
filed with
role
me.
of advocate
Because they've all been in court, they're all salty as hell. And I love
I
having.
tell our students, I want to be a trial lawyer.
Yeah.
And they do criminal work. So
Yeah.
I give these civil
That's
litigators, so
what-
I mean trial lawyers, and they go to trial. But if you want to do it day after
Yeah.
day,
That's right.
that's where you get you.
I had a student in my office last night. I said, you know, I don't want to be a public defender. So I said, "What's the best way to get trial experience?" I said, "Cool.
Right. Right. Unfortunately, most people that get into it, even if they're, at least in my experience, you know better than I do, they get to know their clients and they realize that, yeah.
I think that's right. I think that's right. And they realize that.
And if they don't realize that, they don't need to be doing the work.
There you go. Are you working, do you work with the office here? To make it?
I haven't. I used to. Right now, Sarah Gerwig's doing all that work for us.
Is that right?
She's on leave this semester. She's in town in and out, and I thought she might have been.
Well, tell her I say hello.
I'll pass that along.
Thanks for coming by and saying hello, Tim. Good to see you.
You headed out there to Atlanta after?
Yeah, I've got a 4 o'clock meeting back in Atlanta.
Oh, so you're headed right.
I'm gonna get right on the road. I actually have a 12:30. I had an issue come up at my son's school, so I have a 12:30 Zoom meeting with his counselor that I'm gonna just do somewhere around here. And then probably wolf down something and get on the road.
Okay, we're gonna still go to the airport.
What time's your flight?
This
What
afternoon.
time's your flight?
Flight's at 8 p.m.
Oh, so you're good.
We're gonna leave here at 3, so.
You're good.
Yeah.
Where is Capital?
Columbus, Ohio.
Columbus.
Beautiful Columbus.
I've been there.
We've got OSU in
Yeah.
Columbus also.
OSU is like a city
It is.
to itself.
It is, and it really is. So we have a lot of competition. That's Ohio generally. 9 law schools. It's crazy. We are Capital is an old YMCA law school in the early 20s.
Oh, wow.
They became, started out YMCA, became part of Franklin. It was called the Franklin Law School for a while.
I know about 20 years ago, we only had one law school in South Carolina.
Yeah.
You either went to the university or you didn't. Now that they've got a private law school now in Charleston.
That's still there.
Yeah.
My buddy, Richard Dershowitz. Yeah.
Yeah, it went from being a for-profit to not-for-profit.
Yeah. So it survived. It survived after all these other
I mean, it was shaky there for a minute, but they got over the hump. We need more lawyers. We have the fastest growing state in the country.
South Carolina? So you're the man we're looking to for the time, huh? All right.
What do we have, 20
We
minutes?
won't hold it against you.
How long do they have, Thomas?
20 minutes per, and I think
15.
I imagine if you have a federal judge up here, then he goes to the trial.
They're advisory only.
They're advisory.
When I do panels at our law school, everyone's equal. I'll say to the judges, 20 minutes. Sir, Your Honor.
So I guess we're the old white guy panel.
Okay.
We're the old white guy panel.
Yeah, I don't know how many boxes in the check.
Yeah.
Other than being above 40. So that's when
I remember 40.
good times.
All right, everyone, we're about to get started with panel 2. Sydney over here is going to introduce them.
Hey everyone, my name is Sydney Winter. I am the Senior Managing Editor for Volume 76 of the Mercer Law Review, and I am pleased to introduce our panelist and moderator for Panel 2, Lawyer as an Advocate. Our first panelist is Professor Mark Brown. He is a graduate of the University of Louisville School of Law with an LLM from the University of Illinois. Professor Mark Brown clerked for the United States Court of Appeals for the Sixth Circuit in 1984 to 1985 and served as a judicial fellow at the Supreme Court of the United States under the Chief Justice during the October term in '93. Having taught at several other law schools, Professor Brown currently holds the Newton D. Baker and Hostetler Chair at Capital University, whose faculty he joined in 2003. He teaches courses on constitutional law and constitutional litigation and has co-authored or authored several books and scholarly works addressing topics in both subject areas. Our second panelist is Professor Jonathan Rapping. He is a graduate of the George Washington University National Law Center and is currently a professor of law and director of the Criminal Justice Certificate Program at Atlanta's John Marshall Law School, which he joined in 2007. He is the founder and president of the nonprofit organization of Gideon's Promise, which grew out of his work at several public defender offices and which seeks to transform criminal justice and ensure equal justice for marginalized communities. Professor Rapping authored Gideon's Promise, a public defender movement to transfer criminal justice, and inspired the award-winning HBO documentary Gideon's Army. He received the prestigious MacArthur Foundation Genius Grant for his cutting-edge approach to justice transformation and is a member of the American Law Institute. He is a frequent contributor to the national conversation on criminal justice reform and has been featured by numerous media outlets. Our third panelist is Mr. Christian Stegmeyer. He is a graduate of the University of South Carolina Joseph F. Rice School of Law and has been educated in postgraduate work at the University of California, Los Angeles. He is a shareholder at Collins & Lacey's PC, a Columbia, South Carolina-based civil defense firm where he leads the Retail and Hospitality Practice Group. A member of the American Board of Child Advocates, Mr. Stegmeyer has extensive experience in defending businesses and their insurers in high-exposure litigation, including over 45 appearances before state and federal appellate tribunals. Mr. Stegmeyer regularly advises clients on risk management and litigation strategies, and his expertise also includes alcohol liability and ADA compliance. He is a frequent speaker at legal seminars and a published author, contributing to industry blogs and legal publications. Mr. Stegmeyer also serves as the staff judge advocate for South Carolina State Guard. Our moderator for this panel is Professor Pat Longan. Professor Longan is the director of the Mercer Center for Legal Ethics and Professionalism and a member of the Georgia Chief Justice Commission on Professionalism. He also serves on the State Bar of Georgia's Formal Advisory Opinion Board and its Disciplinary Rules and Procedures Committee. In 2018, the Supreme Court of Georgia appointed Professor Longan as one of 20 special masters who hear disciplinary cases involving lawyers in Georgia. Professor Longan teaches Mercer's first-year course on professionalism, their upper-level law lawyering course, jurisdiction and judgments, and the judicial field placement. He received the 2005 National Award for Innovation and Excellence in Teaching Professionalism from the Conference of Chief Justices, the ABA Standing Committee on Professionalism, and the Burge Endowment for Legal Ethics. In his academic career, Professor Longan has also taught at Stetson University, the University of Florida, Southern Methodist University, the Charleston School of Law, John Marshall Law School, and Georgia State University School of Law. Before entering law teaching, Professor Longan served as a law clerk to Senior United States District Judge Bernard M. Decker in Chicago and practiced law with the firm of Andrews & Kurth in Dallas, Texas.
Good morning, everyone. Again, my name is Mark Brown. I'm from Columbus, Ohio, not Georgia. I teach at Capital University, where I've been for the last 20 years. And before that, I had some tenure time at some other schools before I moved back north to Columbus. I've been engaged in civil rights litigation, constitutional litigation for about 30 years now. I entered the profession, so to speak, while I was teaching at Stetson University. And I've handled a number of civil rights and constitutional litigation course cases. I teach a class on constitutional litigation where I try to convey some of the practical knowledge as well as the book knowledge that I've gathered to my students. I try to give them advice on constitutional litigation and how to handle the cases. So that's kind of my background and where I'm coming from. I consider myself a cause lawyer. I'm fortunate that I have that luxury because I am teaching. I do draw a paycheck. It's not as much as it should be, but I do draw a paycheck. And I tell my students, you got to keep the lights on, right?
And so I can keep the lights on and still kind of pick and choose the cases that I want to take. Quite often when I do engage, in litigation, I'm partnering with something or someone else. It used to be I did a lot of work with the ACLU when I lived in Florida. I no longer do as much with the ACLU. I've kind of gone more solo because I'm kind of cantankerous, they say. But I have had the pleasure of using past students partner with me in some of the litigation, which has been terrific. I try to get as many students involved as I can, and I hope you too will, once you graduate, consider taking on what I would call cause cases. Taking on civil rights cases or constitutional cases, whether they're Section 1983 or something else. Because I do consider myself a cause lawyer, I pick and choose, and I absolutely insist to myself that the causes that I pursue are just in my personal opinion. So there are things that I will do, and there are things that I simply will not do, even though maybe they fall under the same umbrella. And not all lawyers have that luxury, as I pointed out, but I hope it is something that you do, consider and strive for in your practices. Think about, is this something I really want to be doing? Is this something I should be doing as I go forward? Just a little bit of background. I know war stories and all that, but maybe it gives you, an idea of where I'm coming from. My first civil rights case, constitutional litigation case, came from 1990. Quite a while ago. I was in St. Pete, Florida. I just started teaching at Stetson University at the time, and the local local fire department decided to drug test all of its firefighters. There was no problem. It was in vogue. Urinalysis testing at the time became quite a thing. So they decided they were going to test all their firefighters. So I became the attorney, and we sued, and we ended up winning. So we did win the case. It took a long time. There wasn't much negotiation. That's one thing I've learned about civil rights litigation. You don't settle very often, civil rights litigation, which I find unfortunate. I would like to see that change. So I can say I won my very first civil rights case. And then it all went to hell from there. Because I have discovered that if you are a cause lawyer, if you are a civil rights lawyer, you have to be prepared to lose. And lose you will. You will lose quite a bit. And that's just part of the job. You're going to win some of these cases, and that's, I think, what keeps you going. At one point, I got kind of depressed, and so I kind of charted out the cases that I'd argued, the ones that I'd won, and the ones that I lost. And I had a losing record, but it didn't look as bad. It cheered me up. I didn't look as bad as I thought it was. My most recent efforts, speaking of losing, over the last 20 years, I've gotten interested in the public participation in the political process. That's my term of art for it. I've taken on minor candidates and somewhat controversial issues and attempted to get them into debates and attempted to get them onto ballots. That's kind of become my most recent endeavor. I find my value is I really believe that there is value in having more than 2 candidates on a ballot. I really do believe there is value. And I've been of 2 minds on this, and I've recently, in the last 20 years, changed my mind. But I do believe there's a value in popular democracy. At one point, I wasn't so sure about that. I teach constitutional law, and I was thinking Republican form of government, maybe representative democracy is really the way to go, and popular democracy, not so much. And it is. There are 2 sides to that. There are some really smart people who don't agree with me on this. But now I've come to the conclusion that I think popular democracy is an extremely important addition to representative democracy. I'm not sure if do you have an initiative here in Georgia? Popular? I don't think so. We've got it in Ohio on both the state and local levels. So I've gotten into that too to try to help get some initiatives on ballots. One of the most recent ones that I did, and this was, for me, ethically, morally, this was something of a conundrum because it involved marijuana, recreational marijuana. We just recently statewide in Ohio passed the recreational marijuana law. It was an initiative, a statewide initiative. Passed pretty handily, 57%. And I don't take any credit for that, but I did before that. I represented some local groups that, on the local level, because we do have city initiative, county initiative, we're sponsoring decriminalization ordinances so that marijuana, simple marijuana possession, small amounts, was no longer criminal. And we found over the course of about 5 years, and there was some significant litigation to get these onto ballots. The county election boards in Ohio answer to county prosecutors. The prosecutors represent them, and of course the prosecutors really didn't want to decriminalize marijuana, so there was a good deal of resistance. And so we did have some success. It actually proved successful litigation. So we were able to get them on a whole bunch of local ballots, and what that proved in Ohio was that decriminalization of marijuana was a pretty popular idea. And so then statewide, another group took it over, another group with a lot of money took it over and was able to get the initiative passed statewide. But my conundrum was, I'm really in favor of open ballots, and I'm really in favor of popular democracy, and I'm not a big fan of marijuana, okay? I'm not against marijuana. I don't advise anyone to use marijuana. My value is I do believe marijuana should be decriminalized, because I think the war on that particular drug has failed throughout the country. So I was able to come to terms with that. So I'd say, okay, we should not criminalize marijuana. There is value in having the choice to use marijuana. But I'm not so sure that there is much value in actually using the marijuana. That's a little bit of a choice there that I had to make, but that was the choice I wound up making. And I'm comfortable with that choice. I think I did make the right choice to the extent I was able to help decriminalize marijuana throughout the state of Ohio. Like I said, more recently I've been focusing on minor candidates in an effort to get them on ballots in Ohio and across the United States. I'm not, as part of that mission, as part of my value, to represent outsiders, you might say. I am somewhat careful in my own political participation. For example, I'm not a registered Democrat. I'm not a registered Republican. I'm not a registered libertarian or green or communist or socialist or anything else. I've had to take it upon myself to withdraw, at least overtly, in terms of political groups, because I want to be available to help any and every, practically, with limitations I'll state in a minute. Candidates and groups obtain ballot access. Just my pet for who have I represented? I've done the libertarians, greens, socialists. Haven't had any communists yet. Communist Party is not big in Ohio. But we did have a socialist candidate. That ended up in litigation because the news group that put together the debates would not allow the socialist candidate on the debate stage. So we ended up before the Federal Election Commission and lost. The Federal Election Commission is worthless. Okay, that's all there is to it. And we did wind up in federal district court where we won, proving that we had value. But the federal district judge did point out, he goes, your candidate only got 2,000 votes in the election. I'm like, well, this is before the election. We thought he might do better, right? And he didn't. So. In Ohio, my premier candidate, I guess, I represented Ralph Nader in 2004. This was after the 2000 election, of course, in Florida, where Nader was accused of basically handing the election to George Bush. So the Democrats were really pissed off at Ralph Nader. So in 2004, the Democratic Party around the country made a conscious decision to challenge Nader's candidacy on 24 ballots, especially in the battleground states. At that time, the state of Ohio was a battleground state. It's no longer a battleground state, but at the time, back in 2004, it certainly was. So the Democratic Party did bring in some hired guns from Washington, D.C., from a well-known law firm in my own state, and made this argument. And they started it in the newspaper and then took it into federal court, but it was the massive fraud argument. You're too young to remember that. Some of my colleague-age people would remember that. But it was completely fictional, the entire argument. And they trumpeted that argument throughout the country, in several states, and prevailed on that argument. And in our particular case, one of the problems with election litigation is there's always an emergency. It's always a fire. And so you wind up in court on short notice with just days or weeks before the election. And then you're putting the judge, the federal judge, usually in a spot, because she's got to make a decision in short order. And I have sympathy for them because, they're being thrown information. And I think the judges in that situation, to a large extent, rely on counsel. And so when you bring in lawyers from, big Washington law firms, I think the judge is looking at counsel and going, okay, you're credible. And when that lawyer then throws them this misinformation and malinformation and this massive fraud argument, I think that's a disservice. And I think the Nader campaign was certainly disserved in that situation. The judge basically said, okay, I'm buying the massive fraud argument. And Nader, you don't have clean hands. So Nader was kicked off the ballot. It didn't appear on the 2004 ballot. And I think that was just a terrible result. We were able later, 4 years later, to prove that we were right. And we had the Sixth Circuit basically rule in our favor. By that time, Nader had already been kicked off the ballot. My point is that I think, as a cause lawyer, of course, going in, you obviously have already made your moral decision. And you should think long and hard about it before you do that. On the defense side, you're being dragged into it. I have to believe that on the defense side, even though you might not consider yourself a cause lawyer, you still have a moral decision to make. And I believe in that Nader example that the lawyers who came in and made this massive fraud argument, they knew it had to be false. I think that was completely immoral in my estimation. I think that was a disservice to not only the court, but also, more importantly, I think it was a disservice to society at large. Because I think we do have a value in fair processes and open elections. And I hated to see that happen. Of course, value, morality, merit, those are, they're fluffy, right? One person's value is another person's bane. So there's always some subjectivity that goes into the decision. And I'm sure that the lawyers on the Democratic side, they probably had convinced themselves that they were actually doing society good, even though I don't think that was the case. The bottom line is, I think, and this is a tough one, and maybe Professor Longan can help us through this, but in terms of morality and the ethics involved, the universality path that you mentioned earlier, that we do have shared, values. I think we do, but a lot of them are hard, and a lot of them are going to take a lot of thought to really figure them out. And that's especially true, I think, in today's election law context, which is kind of what I've been involved in the last few years. I think society has built in certain basements, right? It may be first floors. So we've got criminal laws, right? And so, as a lawyer, you cannot go in and violate the criminal law. When you're representing a client, you just can't do that, right? And then we've also got codes of professional conduct that are maybe the next level up and are also a floor. You can't violate those codes of professional conduct. But my thought is we got to go beyond that and as lawyers. And, okay, we're not violating the criminal law. We're not violating codes of professional conduct. But still, we've got to step back and think, should I be doing this? Should I be making this argument in court? And as a cause lawyer, of course, you're going to make that decision before you go in. But even on the defense side, I hope you make that decision. Today, talk about the canary in the coal mine. Today, it's bizarro land in terms of election litigation. That is just the reality, and you've lived through it. back to 2016, 2020, 2024. We've got more election litigation ongoing now than we've ever had before. And it's not the minor parties. They are involved to some extent, but it's the major parties. Today we've got the major parties, fighting each other, making arguments that, in my professional opinion, are not only brazen, but are incredible on both sides. Now, at some point, of course, you've got the basement, you've got criminal law, and you've got, your first floor, you've got your code of professional responsibility. But that hadn't stopped the arguments. I mean, think Rudy Giuliani, you think John Eastman, and they've discovered that there are codes of professional responsibility. But there were a lot of really morally questionable arguments made that were never addressed in either setting, either in criminal court or before boards of discipline. And that's one thing we've really got to deal with. I don't think the criminal laws and the codes of professional conduct are sufficient to deal with the particular problem we have today in election litigation. I don't think it's going to change going forward. I'm not naive, but I would hope that the lawyers who choose to involve themselves in election litigation going forward, and civil rights more generally, will become maybe not cause lawyers, but maybe lawyers who are willing to take that second look at the morality of what they're doing. More generally with civil rights litigation, it's the same problem. As I said before, civil rights litigation rarely settles. There's very little negotiation in civil rights litigation, from my experience and from what I've read and what I've studied, comparatively speaking. Especially true in the context of what we call prospective litigation, which is basically what I do. I don't do damage work. Instead, it's prospective, and that's most constitutional litigation, but there's rarely settlement because it's so politically divisive. There's just no way it's going to happen, and I find that unfortunate, too. I've maybe had one case that I've ever handled that was settled. That was a parade case in St. Petersburg years ago, back in 1990, I think it was, and ever since then it's just been fought tooth and nail. I have argued against very good government lawyers who are very ethical, and it's been a pleasure. I have also argued against government lawyers who make me throw my hands up and I'm thinking, what are you thinking? I'm running out of time, but here's one stupid case that I had. I was representing the Libertarian Party trying to get them back on the Ohio ballot. They'd been kicked off the ballot basically by the GOP, the Republican Party, which spent $1 million to do it. I took pride in that. Okay, it cost them $1 million to do it. And got that through discovery. But during the middle, the government was on the side of the GOP, okay? Government can be that way sometimes. And so the judge has finally set a hearing date. It's an emergency hearing. He's like, and it was going to be a 3-day hearing, so I'm like, all right, we get a hearing. We lost, but I'm like, we got a hearing. And so he looks at the government lawyer and says, anything from you, government lawyer? And in these cases, you're supposed to post a bond, right? They always waive the bond in these election cases, so you're not supposed to bond. And so I'd asked for the waiver, and the judge, anything from you, government? She stands up and says, we demand a bond. I'm like, this is the first time I've ever seen that in my life. Okay. And the judge looks at me and goes, well, how much of a bond do you want? It's just $1 million. Just blurts it out. I'm saying, holy crap. I mean, I'm like, there's no way that could be a moral choice. I mean, because our client couldn't pay that. It was basically, if it was granted, we were going to be going to the emergency hearing. But I would hope that that could be avoided in the future. I'm sorry I wasted my time. Thank you very much for your attention. It's been a pleasure speaking to all of you, and thank you for having me come down here to Mercer.
So I benefited from Professor Hemingway's struggles earlier, and I now know how to do this, so here we go. So I think if I had to pick 3 descriptors to describe myself, I would go with father, husband, public defender. Literally, my professional identity is part of my personal identity. I was a career public defender before I came to Georgia in 2004 to be the first training director of the statewide public defender system here. I then spent a couple years after Hurricane Katrina helping to rebuild that public defender office. I've worked with public defenders across the South and now across the country. And in 2007, I joined the faculty of John Marshall Law School. The same time I founded Gideon's Promise. John Marshall was a great home because it allowed me to bring my passion, Gideon's Promise, into the institution. I speak to our new incoming law students every year for orientation. And I ask our students, why are you here? And we have an amazing group of law students at John Marshall. Many of them, first-generation college graduates, many come from communities that have been unable to access justice. And I ask them why they're here, and they share things like, I want to represent a certain type of person. I want to represent a particular cause. And I share with them a quote from an unnamed law student that says, the first thing I lost in law school is the reason why I came. Right? That hits me. The first thing I lost in law school is the reason why I came. And I share that with them, and I say to them, you're about to enter a first year where we are going to teach you that the law can be reduced to rules and doctrine, to black letters on a white page. Before you know it, you'll forget there are human beings behind these cases. And I challenge my students, at the end of your first year, after you've read dozens and dozens of cases, I want you to come to me and share with me the story of one human being, one person behind any of those cases. None of them could do it. They can't do it because the way we teach law, and this isn't a knock on John Marshall or any other institution, it's how we teach law in America, is we reduce complicated personal interactions to facts that we can use to mechanically analyze to arrive at a solution. And I say to my students, it's critical that you learn to do that. You can't be a good lawyer if you don't know how to analyze, if you can't issue spot, if you don't know rules. But if you do that without understanding the human impact, you won't be a good lawyer. I tell my students, as important as anything else you will do in 3 years, find your purpose. Find your purpose. So, I think there's a tension. Professor Brown talked about, he repeatedly said he's a cause lawyer. I think that there's this struggle law students have. Do I want to become a cause lawyer? Do I believe in environmental justice, reproductive rights? Do I want to do policy work or advocacy for a cause? Or do I want to represent people, clients, maybe corporations? Do I want to represent clients? And I think that there is a thinking among some scholars that when you're a cause lawyer, it is easier to marry your personal identity with your professional identity. And when you're a client lawyer, you're more of a hired gun, and you have to sort of do the work and then like wash your hands and go home and leave that identity. I want to share with you, I see myself very much as a client lawyer, and I also see myself as a cause lawyer. I believe I figured out how to marry those things, and I would urge those of you who want to represent people, particularly people who are living on the margins, whether it's as a public defender, civil legal services, right? Figure out how to marry your personal and your professional. Make that client your cause. So Professor Jones asked us to touch on the preamble of the model code. And I'm speaking fast because I've seen everyone else run out of time, and I know I can't get through all my slides, and I'm going to have to skip through some of them. I'm going to try to minimize that. But the preamble, I pulled out a couple of passages that I want to make sure I touch on. As a representative of clients, and Professor Hemingway mentioned this, a lawyer performs various functions. We're advisors, we're advocates, we're negotiators, we're evaluators. But I think one of the most important roles that I believe we play, particularly when we represent people, is left out. Storyteller. And I'm going to talk more about that. I think it is critical that we are storytellers when we stand next to people who have been silenced in a system that doesn't care much about their story. Paragraph 6, a lawyer should be mindful of deficiencies in the administration of justice, of the fact that the poor, sometimes persons who are not poor, can't afford adequate legal service. All lawyers should devote professional time and resources to ensure equal access to our system of justice. I do think that there is a mindset in our profession that if you go do work where you're not helping people that can't access justice, you have an obligation to find a way to do that. Again, I would encourage those of you for whom you see your personal identity, your personal values, the reason you came to law school is helping people who can't access justice, Don't see that as something you do as pro bono work. Find a way to have a career where that's what you do. It's your professional identity. Paragraph 7, many of a lawyer's professional responsibilities are prescribed in the rules of professional conduct, as well as substantive procedural law. However, lawyers are also guided by personal conscience and the approbation of professional peers. If there are any judges in the room, I apologize, but let me say this. I would ask you to think about, while I agree that the approbation of our peers can be alluring, is there a danger? And I'm going to talk about some of the things I've seen where lawyers become judge-centered, more eager to please judges than serve clients, and how that can lead to violations of the rules of professional conduct. And then lastly, virtually all difficult ethical problems arise from conflict between a lawyer's responsibilities to clients, to the legal system, and a lawyer's own interest in remaining an ethical person. I'm glad to say I don't feel that I have ever felt any conflict between my ethical obligations to my clients and my personal morals or ethics. And I think that's because I put in work on the front end to carve out a career where that's the case. I train, mentor hundreds of public defenders across the country, and critical to our model of recruitment, training, and mentorship is helping lawyers find that marriage between their personal and their professional identity. One of those lawyers is Travis Williams. If any of you saw Gideon's Army, you met Travis. Right? This is Travis with his arm around a client. I think this picture represents the essence of what we teach at Gideon's Promise, client-centered lawyering. Again, I don't divorce client lawyering from cause lawyering, because the client is the cause. The cause is standing with someone who's been stripped of their dignity, who has had their voice taken from them, and your cause is making sure that you understand their priorities, you understand the challenges they face, and you use your skills and your knowledge to help them navigate those challenges to achieve their priorities. That's the highest calling of our work, and so I have no conflict when I disagree with their priorities, because my goal is to help them amplify their voice. I see this as civil rights work. In fact, I see it as perhaps one of the most important civil rights struggles we're going through today. If anyone has taken the time to read Michelle Alexander, The New Jim Crow, watch Ava DuVernay's 13th, you know that there is a correlation between what we started in 1619 with racial terror and what's happening in our criminal legal system today. It is an ongoing extension of those civil rights battles that have happened for 400 years. So giving, I don't want to say giving voice, because the people we serve have voice. Helping people have their voices amplified and heard, I see as a critical role as lawyers, storytellers in a system that wants to strip people of their story, that wants to frame them in the image of the people who are prosecuting them and incarcerating them. The role of the public defender is to hear those stories and amplify those stories. In doing so, we infuse the system with humanity and dignity. That's the cause. I love this image, Frank Wu's painting. It's captioned "Indifference." These robotic legs walking past a homeless veteran curled up in a fetal position. And we've all been out on the streets when someone's asked us for $1 and we've walked by and ignored them. I teach my children, never walk by and ignore someone who asks you for help. And yet there are times I'm with my kids and someone says, "Can you spare $1?" And I'm saying, "I can't help you." And my kids tug me on the shoulder and say, "Daddy, what about what you taught us?" And I say, "Yeah, thank you for reminding me." As lawyers who represent folks on the margins, you will go into systems that will, over time, wear down on your passion, wear down on your spirit, and before you know it, you can find yourself sleepwalking through those systems if you don't quit. And so what we do at Gideon's Promise, what I think our job is as teachers and mentors, is to help lawyers not only identify their purpose, but when they get out into the field, to protect it and nurture it and sustain it. And I'm going to share with you, if I have time, a few models that we use to do that. That will depend on the time. But But we recruit some of the most passionate, smartest young lawyers across the country to join public defender offices in some of the most difficult places in the country. And they go through a 2-week boot camp and they understand exactly what every client deserves, and then they go into systems where they cannot give it to them because they have 300 cases. They don't have enough resources. Judges won't let them stand up and make the argument. And before you know it, the phone starts ringing, and me and other faculty members and mentors, we hear from students saying, I can't do this anymore. I feel like I need to quit. And so I want to share with you, if I have time, 3 models we use to try to support lawyers who are committed to doing this important work, marrying their personal and their professional identity. The first is a model that we call the motivation triangle, and it comes to us from a great trainer named Jeff Shear, who at the time was the training director for the Department of Public Advocacy in Kentucky, now the training director for the National Association for Public Defense. And what this model teaches us is this: for every person who comes to public defense for client-centered reasons, they have one primary motivator. Some have the social worker motivator, perhaps best epitomized by the quote from Sister Helen Prejean, that the dignity of the human spirit is that no person is as bad as the worst thing they've ever done. Some come because they're warriors. Paul Butler famously says, I became a prosecutor because I hated bullies. I quit being a prosecutor because I hated bullies. There are some people that do this work because they want to fight against a powerful entity and stand next to someone who doesn't have power. Perhaps the Nietzsche quote, distrust all in whom the impulse to punish is powerful, is most apt. And others do it because they see the system as racist and classist. It's a system populated almost exclusively by poor folks, disproportionately black and brown people, and they want to be part of a community that's going to change that. They're the activist. Margaret Mead says, never doubt that a small group of thoughtful, committed people can change the world. Indeed, it's the only thing that ever has. And what we do is we teach that even though you may have one primary motivator, every public defender I know who's client-centered, who does the work for the right reasons, has a little of all 3 in us. And so what we do is we teach our lawyers how to view, what was that number? I'm sorry. How to view the, oh my gosh, how to view the problem through various lenses. So maybe you're the social worker, but you have that one client you just can't connect with. Well, we'll say, look, tap into your warrior motivator, maybe even though you're not feeling that client. In a battle between the state with all its resources and that person who came from nothing, who had nothing, who do you want to support? And the warrior motivator gets you through. So we teach our lawyers how to tap into various aspects of their personal and professional identity to sustain themselves in really difficult situations. This is a great model called the ethics spectrum that I'm going to skip because I've got less than 7 minutes. But it really is a model that helps us look at everyday ethical challenges and figure out how to resolve them in a way, right, that avoids CYA, right, approbation of everyone but your client, being liked, not getting in trouble, lawyer-centered, and thinking, how do I help my client? But also recognizing that whether your motivation is CYA or helping the client, if unchecked, either one can land you in ethical hot water. And we work through exercises to help lawyers think about how to get as close to the help client side without crossing that line. I had a hypo that illustrated this. I don't have time. Call me, email me, I'll share it with you. And then this model, which I think is critical to our work, we call it close the gap. So one thing about doing this work is you will find, if you're a caring lawyer, you will start to feel like you're complicit. You'll start to feel like you contribute to injustice because you can't achieve the outcome every client deserves. And we developed a model called Close the Gap, where when a lawyer calls and says, I feel like I'm part of the problem, I need to quit, we sit them down and say, let's talk about the reality that you're facing. Let's talk about the aspiration you want to achieve. We've now defined the gap. Let's identify all the obstacles to closing that gap, and let's think about what you've learned, the lessons you've learned, to chip away at the ones that are manageable. Forgive yourselves for the ones you can't deal with beyond your control, and trust that when you're chipping away inch by inch, your colleague's doing it in a courtroom next door, another group is doing it in the next county over, another group in the next state over. You are making a difference. So those are some of the models we use to help people maintain their personal, married with their professional identity and not quit what I think is one of the most important jobs a lawyer can do. So I want to share this last story, because when the pandemic hit, we started getting a lot of calls from public defenders who said, I really can't do this anymore. I have people I love, clients I care about. They're stuck in cages that are COVID infested. They're dying. I think I need to quit. I've been filing motions. They're falling on deaf ears. And I thought back to 2010. I was in Birmingham, Alabama, training a group of lawyers, and a story hit the news. Some of you who are older may remember this. 33 Chilean miners were trapped underground when a mine collapsed. And for 17 days, rescue workers were drilling, putting microphones and lights, cameras into the mine, trying to find proof of life. And on the 17th day, a drill bit came back, and there was a note attached. Miraculously, all 33 miners were alive. And they were filming. The world was watching. I was fixated, maybe because we learned their stories. They were fathers and brothers and sons, and I'm a father and brother and son, but I watched. And I watched for the next 52 days. 52 days as rescue efforts went on. And on the 69th day, they rescued all 33 miners, miraculously. And I thought to myself, you know, as awful as those last 52 days must have been underground, I would take those over the first 17 any day. The first 17 where these miners didn't know if anyone cared, if there was any hope, if anyone was fighting for them. And I say to our lawyers, when you go to the jails, when you talk to people, when you deliver messages to their loved ones, you may not get them out, but think of how many people have lawyers that are ignoring their calls, aren't visiting them. When you do that, that matters. You are the lights, you are the cameras, you are the microphones. That matters. So I end with this. The happiest people I know in this world are lawyers. The most miserable people I know in this world are lawyers. The difference between the two is the first group found their purpose. It's not something they do on the side before they go home and then live their real life. It's who they are. It's their identity. A public defender, a dear friend of mine, shared a quote with me once. His grandfather told him. His grandfather was a minister. The quote is this: every day you write your epitaph. Every day you write your epitaph. Think about that. If every day you are writing the story of how you'll be remembered when you're gone, your legacy, how can you fail to spend one single day writing the most powerful, purposeful, meaningful legacy that you can write? If you do that every day as a lawyer, whether you think you're able to accomplish what your client deserves or not, there will be a day when you're taking your last breath and you can know that your children, your loved ones, the people who care about you have something to carry on with them. So I wish you all Godspeed. It is a pleasure to be here with you today, and I can't wait to see some of you in the trenches.
Well, good morning. I'm Christian Stegmeyer, and I practice law in Columbia, South Carolina, which is about 3.5 hours from here. And before I get into my presentation, I just want to say how impressed I've been with Mercer and the School of Law and the students. The best thing about being invited here today to speak is I've gotten to learn a lot more about Mercer. Our law firm is literally across the street from the University of South Carolina School of Law. So historically, guess where we recruit from? And last year I get a voicemail from Rachel Radicek saying, I know that your on-campus interviewing is long since over, but I'm interested in practicing in South Carolina after. Would you please meet with me? And we'd already hired our law clerks. We were 4 months, we were a month or two away from starting our summer session. But we met Rachel, and we were so impressed, and she spent the summer with us. And she's coming to work for the firm after she leaves, and she'll be leaves the law school here, and she'll be the first lawyer to join our firm from Mercer. And believe me, I'm spreading the word about Mercer in Columbia. So if you're involved in career services here, any member of the faculty, please talk. Let's stay in touch as far as that goes. I wanted to talk about three things today. Balancing zealous advocacy with ethics, the role of civility and professionalism, and then professional credibility and advocacy style. But I'm going to call a little bit of an audible before we talk about all that. My man Thomas is keeping track of time here, but I'll try to combine everything together, hopefully in a cogent, coherent manner. I listened to the professor talk about finding your purpose, and he's exactly right as far as that goes. But I'll also suggest to you this, and this is geared towards every law student in this room. Find your mentors. Find your mentors. Your mentor will set the cadence for your career. I've got two mentors that I consider second fathers. I had the opportunity to clerk for a judge on the Court of Appeals in South Carolina, Ralph King Anderson. And what he taught me about ethics, what he taught me about advocacy, he taught me about the law is invaluable. I was thinking last night when Judge Anderson from the 11th Circuit got up to speak, I was thinking to myself, having had the opportunity to work inside chambers, I can't imagine what working for him must have been like. Can you imagine that? And I had a very similar experience. And then my second mentor is my partner, Joel Collins. He's tried more cases than anybody. He was an Army JAG. He was an assistant United States attorney. He taught at West Point. And the thing that runs, the current that runs through the two of them is this, and this is why I mention this, is they are probably the most generous people I've ever met. And this is the reason why mentors and who you select as mentors is so important. I've got two daughters, and they're both unfortunately at Clemson. I went to Carolina, but their mother went to Clemson, so it's okay. One is a senior, and then one is a freshman. And we've got rules in our house. As it applies to both daughters, they have two rules: no motorcycles, no tattoos. But my older one has a special rule. My older daughter, her name is Grace. Her younger sister is Ella. The rule number one is for Grace is always look out for Ella. Always look out for Ella. And they're 2.5 years apart, and sometimes she'll complain about Ella. And when they started, Ella started her freshman year this year, it's a little bit rocky. And I told Grace, I need you to spend a little bit more time on campus. I need you to spend some time with Ella, just get her straightened out. And she was complaining about that. And all I had to say is, what's rule number one? And she knows the rule. And the reason why I tell you that is this. My greatest responsibility, I'm the managing partner of our firm. I'm also a practice group leader. I lead a group of 9 lawyers, including me. But I've got 8 lawyers and 5 paralegals and 2 assistants that work on my team. I'm responsible for all the business that comes in that keeps them working. My job is to watch out for them. That is my sole job. And to make sure that they're getting developed, make sure they're getting business, that there's plenty to do, that they grow in the profession. Because that's what my mentors did for me. So my piece of advice, especially when we're talking about ethics and how to do things the right way, setting the cadence for your career is be very selective with your mentors. A lot of y'all might join a bigger firm, and I'll share with you this. In a bigger firm setting, they'll have this required mentorship, and you might get assigned some partner who's not particularly interested in being your mentor, but the senior partner said that y'all are together. Mentorships can be informal. They don't always have to be formal. But my suggestion to you is this, is that when you join your firm or you join your setting, you've got about a year or 2 to kind of figure out if this is where you want to be. And a lot of that relates to who is leading you, who is mentoring you. If you are in a situation where you're not growing, you're not being watched out for, you're not being looked after, my suggestion is to you maybe find something else to do as far as that goes. And a corollary to this is, y'all have already been through a bunch of interviews already. And inevitably, at the end of every interview, the interviewer will say to you, well, what are your questions for me? And I was on that receiving end at one point. That was 25 years ago. It's been a while. But y'all have been doing it not too long ago and will continue to do so as you look for your job out of school. Here's my challenge to you is this. A good lawyer who is a leader, who is going to be responsible for you, they're going to welcome a question from you like, what is your leadership style? Tell me about your philosophy concerning mentoring. How will you watch out for me? What can I expect as it relates to development? Provocative questions maybe, but the good lawyer will receive that very well and be glad to talk with you about that. Because again, if you're the leader, your job is to take care of your people, and that means everything. So let's talk a little bit more about some of the areas as it relates to ethics and advocacy. Here's the thesis as it relates to number one, balancing zealous advocacy with ethics. The thesis is this. Advocacy can be conducted vigorously while maintaining honesty and transparency. I can't tell you how impressed I am with my faculty members here, my panelists. I've seen Gideon's Army. It's a pleasure to be able to meet you today and to work with you. And just looking at everybody's credentials, it's so impressive. But I don't do public law work. I represent multinational, multi-billion-dollar companies doing business in South Carolina. But I still have clients who expect me to do the job. And our situation, if you're paying any sort of attention, it's Georgia, it's South Carolina, it's Florida, it's every state in the jurisdiction. You heard the term nuclear verdict. The climate, the litigation climate right now can be a little, post-COVID, can be a little hostile when it comes to corporate defendants. And there's all sorts of reasons for that. We could talk about that all day. But we represent clients who want this. They want frictionless representation. They don't want histrionics. They want to get from A to Z as best as possible, and they want your best advice. The clients we represent are typically pretty sophisticated. They get sued all the time. This is part of their business. But from time to time, you might represent a client who has a real problem with getting sued, who has a real problem with their exposure. Sometimes it can be an existential crisis. Y'all have heard about the Murdoch boat wreck that happened down in South Carolina. I was a part of that civil litigation. There was existential crisis level exposure involved in that. We had a fantastic client we represented. We represented a convenience store that sold a beer, but we had a fantastic client that we had the privilege of representing. But in other cases where we've had existential crisis, emotion gets the better of some folks, and you get asked to do some things that you know this is not going to work out well. These are things against the way I would do this, and there could be a multiple number of reasons. Professor Parrish talked about being asked to do, having a friend asked to do something that he thought was otherwise unethical. We talked a little bit earlier today about having your guide stars. You have to stay fixed on your guide star. Your guide star are the rules of ethics, the rule of law, and you can't deviate from that. And the one thing I will share with you, I'm sorry, what was that number? Okay, I got to get it going here. The one thing I'll share with you is this, is you have got to be candid with your clients about setting parameters, about what you will and what you won't do, and sometimes that's hard. Hemingway writes, courage is grace under pressure. Sometimes you've got to do the hard thing. And Professor Hemingway talked today a little bit about leadership. And leadership takes many forms. And the one thing I'm impressed with when I heard what she had to say is this. Every leader, especially when you're representing clients, and most lawyers are representing clients, you have got to be the leader. You have got to be the leader. And sometimes that leadership requires you to say no for whatever reason. This is a really stupid way to spend money. Let me tell you why we're not going to win that. Let me tell you how that's going to drag this litigation out this much further. Let me tell you how that's against the law. Let me tell you how this judge won't perceive this well. You can't just go along to get along. You have to be the leader. You have to be the professional. Number two, the role of civility and professionalism. This is probably the one I feel the most strongly about, and here's the thesis. Civility and ethical standards are not just abstract ideas, but practical tools. Again, this goes back to having a guide star. You talked about your Georgia lawyer's oath. We have a South Carolina lawyer's oath that we take in addition to being sworn in, and it's very similar to what goes on in Georgia, what you swear to. You're going to be candid with the courts, obviously, but you're going to be fair and you're going to be transparent with the other side as far as that goes. I think about this a lot as it relates to my career and where I've started and where I want to end up. You have to have a very, very long view about your career. Mark talked a little bit about short-term wins, setting aside values for short-term wins. You can't fall down that lane. You can't go down that road. You have to take a very long view of what you do. And, with regard to the civil climate that goes on right now, there's a lot of money involved. I know over in Columbus, there was a $200 million verdict a couple years back involving a boating injury. CVS took an enormous verdict in Atlanta on a third-party assault case. That was a $45 million verdict. When you take a verdict like that, there are a lot of people asking questions. And there are a lot of people that ask questions before trial and then after trial, and it creates a lot of pressure. And especially in the civil climate now on the plaintiff's side, I love and respect my brethren on the plaintiff's side, but there's a lot of motivation by money as far as that goes. And by virtue of that fact, there's a lot of emotion. There's a lot of emotion. And Professor Parrish was exactly right. You have to be calm. You have to be calm. I had a Green Beret tell me one time, you'll never hear a Green Beret yell. Just won't. Your client doesn't need you being histrionic or hyperbolic. They need you to be the guide star. They need you to be the leader. They need you to bring them through the crisis. And as long as you are telling your client everything you know about the factual scenario, giving that client the best advice possible as it relates to their exposure and what the law says and what the possible outcomes, you let the client be the client and make decisions. And you do the best you can to be their attorney and their counselor. But you can't fall into the trap of being the guy that's yelling or screaming or losing their mind about things. If you read anything about the Stoics, Seneca essentially equates anger and the lack of control of your emotion to being like madness, to being mentally ill. So calm, collected, always being the person that people can look to. That's your responsibility as being a lawyer. And the last thing I want to talk about is professional credibility and advocacy style. And I thought and heard a lot about what Professor Hemingway had to say today. And I thought about 1 Corinthians 15th chapter. St. Paul writes, "By God's grace, I am who I am." And she made that remark today. You have to be your authentic self. You can't be anybody else but yourself. Professors talked about finding your purpose. You've got 3 years plus some more to find out who you are. There are all sorts of different types of clients. We know what the core values you need to possess, but there are different ways to handle things. There are different styles. When you do things inauthentically, I promise you, it becomes very, very apparent to everybody. And at the end of the day, your reputation is everything. One of the first things we talk about with our clients, especially our new clients, or our old clients, they know how we operate. We have a letter we send to our clients that says, these are the parameters in which we're going to operate. I will tell you, civil discovery sucks. When you're the defendant you know, the plaintiff has like 3 sheets of paper. The defendant has 10,000 emails and all that, and, you know, when you're representing corporations that are not in the business of litigation, you know, you have to recruit all these people internally to help you find emails, find documents, go into warehouses, dig stuff up, because you have to produce everything as far as that goes. And it's time-consuming, it's costly, it deviates from their core mission, but you've really got to tell your folks on the front end, I need your cooperation, I need your full cooperation. And even worse, if you've got a client that starts reading the requests a little too closely, trying to cut it just a little bit too much, I promise you, the truth always finds out. And more times than not, when that plaintiff's lawyer sent you that discovery, they already know what the answers are. They just want to know what you're going to produce. You know, it's uncanny the way that works as far as that goes. But you tell your clients in litigation, especially as it relates to discovery or trial, you know, for me, I'm not playing games. Our philosophy is this. Our clients wear the white hat. It's a two-way street. I don't have to represent every client that wants to be represented by Collins and Lacey. Not everybody gets to play for the Braves. Not everybody gets to be represented by Collins and Lacey. Our clients wear the white hat. We win on the facts and we win on the law, and when those two things get together, we feel pretty good about summary judgment. We feel pretty good about trial. And if we're not going to win on the facts, if we're not going to fit on the law, it's like the square peg in the round hole where you're trying to jam it in. You have to be the leader, and you have to advise your client. It's just not going to happen this time around. We need to figure out the best way to get resolved. And a client who values you, who values that representation, they're going to appreciate that. You don't have to be a superhero. Again, it's about the facts and the law, giving your client the ability to make those decisions, being the best advocate you can be within the bounds of the rules. And at the end of the day, when you think about the end of your career, or even a day-by-day thing, the thing as a lawyer that you want to have, and the professor talked about this, is that you don't want to have any regrets. You know, are there things you could do differently? Yes. I mean, I could tell you 1,000 different things that I'd want to do differently in any type of cases. But, you know, there are gaps that you can cross. There are decisions you can make where it's irreparable. It's irreparable. Don't fall for that. You know, at the end of the day, you have to look yourself in the mirror. You have to think about who you are as a practitioner, and you can't have those kinds of regrets. I hope this has been helpful. And again, thank you for hosting me. Like I said, I'll be spreading the word about Mercer. Thank you very much.
Well, gentlemen, thank you. That was quite provocative, if just the volume of my notes is any indication. You've given me lots to think about. We do have a few minutes. Thomas, are you timing this part as well? We have a few minutes for questions, so what questions are there? Yes, Professor.
So this was fabulous. I was taking notes also, including the quote that is now going to begin my article, which is your Corinthians quote. And
Yes.
it reminded me that I should be dealing with 1 Corinthians, and the greatest of these is love, since I talked about love. So anyway, but my question has to do with something completely different. The lawyer's role as advocate, courtroom advocate, is such a public role. It's on television, it's in pop culture. I'm often fighting against that and trying to convince people that they should be doing something other than courtroom law, or at least looking at it. But one theme of your panel that I think is super important in light of that very public-facing way in which the lawyer as advocate in the context you discussed works is that that tension that all of you, I think, have sort of expressed between zealous advocacy and going over the line. And I think, Mark, in your presentation, you talked about dangers to society. I'd like to pull one out that I think is sort of weaving in the background of all of yours, which is the lawyer's reputation in society.
my guess is we've all got thoughts about this. First thing I want to say is, if you are representing multinational, multi-billion dollar organizations, you can always give to organizations like Gideon's Promise, right? No, that was not your question. So I will say, I think you have to be ethical. And while I didn't get into the model of the ethics spectrum, understanding the rules of professional conduct and the comments are critical so you know where those lines are. There's a wide range of ethical behavior that you can engage in when you're confronting any challenge. You have to be ethical. You've got to be lawful. My view is, once you have been ethical and you have been lawful, your duty, if you are serving people, is to prioritize them. Be damned with what the public thinks about the reputation of the profession if they don't understand that even the most marginalized people are entitled to zealous, vigorous, ethical, legal advocacy. We've got to work on that in some other form, some educational form. It's not for me to change that perception while I'm serving an individual who is looking at losing their liberty and maybe even their life.
That's a hard question, especially today. I mean, reputation is so important to lawyers, no doubt about that. But I mean, with social media and the disinformation that we see today, it's like no matter, it's kind of you're damned if you do and you're damned if you don't almost. So that's a tricky one. How do you deal with that? My thought is, having represented groups that necessarily were not popular, I'm kind of like, well, damn the reputation. I mean, I'm going to do it anyway. That's my moral choice. But on the other hand, your reputation is also just so important to what your credibility is going to be and what you're doing. So it's a hard one. That's a real hard one. Maybe we can get an answer from Pat.
I think the perfect, and not to get political at all, but I think the perfect example that you raised today in your presentation was about Rudy Giuliani. Here's a person that, if he had just stayed the course, would have been wealthy, and when he died, they would have renamed LaGuardia after him, I mean, he was considered a hero of 9/11, considered a very good governor, or a very good mayor of New York, could run for president, and just for whatever reason, all the rules, everything went out the window for political gain. And they were talking about his daughter; she's come out for the Democrat ticket this time. But they were, to me, to be disbarred. I wouldn't to have that shame, to be disbarred in 2 different jurisdictions. So personally, he's destroyed his reputation. Second, what's the attitude the public has? Well, at the end of the day, lawyers will do anything. Lawyers won't do, the good lawyers won't do anything. So that was a perfect example.
Can I say one very quick thing along that? So I think most public defenders, good public defenders, have the example where they go to court, judges yell at them for fighting too hard, but then when a judge or a prosecutor or someone who has been aggravated with the zealousness of that representation has a loved one who gets in trouble, they're calling us, because at the end of the day, they do respect that. So it's one thing, public perception is one thing. Your reputation within the legal community, if you are zealous, if you're ethical, you're going to be respected, even if you're not loved in the moment.
What other questions do we have? Yes, Mr. Chateau.
Professor Brown, you kind of twice hinted at this, that you wish some of your constitutional cases would settle more often. Personally, I'm often worried about how many cases they settle and worry about whether lawyers are being advocates when they settle so quickly, and worry about whether we're doing our job to further justice and truth. Can you speak a little bit more about why you're wishing for more settlements?
Because I lost so many times. No, I think that a lot of constitutional problems can be pretty quickly settled. Because I think the constitutional, not that it's clear, you know that from your common law class, it's thick as mud. But there are some constitutional principles that have some clarity to them, and I think, like I had a parade case years ago from St. Petersburg, and I mean, the Constitution was pretty clear. You can't discriminate on account of race, and you can't discriminate based on point of view, and da-da-da-da. So it was an easy one, really. And we settled that case, and we should have settled that case. The city let us have the parade, and I think more cases ought to be that way. I do believe in the search for truth. I do believe in zealous advocacy. I do believe in all that, but not at all costs. I don't see it necessarily as a zero-sum game as much as some do. So.
Yes, sir.
One concept that came up is this idea of being a cause lawyer. And one thing I think about is how when we come to our profession and we come to the cases that we pick with our own cause in mind, how that in a way can gatekeep the change that our profession can make in the world. And I wonder if there's value in taking cases that you totally disagree with the person's objective or motive, but in a way they still, I guess I'm concerned about gatekeeping their right to our services when we find maybe that their views aren't popular, and how that can stop, we can gatekeep the change that our profession can make in the world.
I mean, it depends on the value there can be value in what you're doing even though you disagree with your client and your client's position. So like, I represent the Libertarian Party a lot, unfortunately, in Ohio because they've been kicked off the ballot. I don't consider myself a libertarian. So value-wise, I'm not sure if there's much, as far as I'm concerned, there. But my value is an open ballot, and that people have the right to be exposed to this idea and to make their own decisions. So that's the value that allows me to easily represent, the Libertarian Party, along with the Socialist Party and the Greens and what have you. So there can be a value there for you, even though. And then in criminal defense work, I'm sure it's even more. I mean, you have clients you don't want to represent, but you do.
Well, I think if you're a private lawyer, you might say, I have a cause. I will not represent cooperators. We call them snitches. I won't represent cooperators, right? You can do that as a private lawyer. You can say to someone, I will take your case, but I want to let you know my limits. I don't do X. As a public defender, we don't have the option to do that. Our cause has to be helping this person achieve their objections through any lawful and ethical means. That's the highest calling.
I've got a line. I will not represent Democrats or Republicans, even though I'm serious. Even though I believe in an open ballot, if they're not on the ballot, it's like I'm not doing it. I'm just not going to do it. That's my line. So.
All right. Well, I think we're out of time, but I hope you will join me in thanking our panelists. And Rachel, what's next?
Lunch.
Okay.
Oh, thank you.
You want to direct people where they should go?
I will.
Thank you so much.
You're very welcome. Are y'all ready to get started?
Yes, wherever you are.
All right, everyone. I think we're about to get started with our third panel, and Walker over here is going to introduce our wonderful panelists.
Good afternoon. My name is Walker Thomas. I'm a managing editor for Volume 76. I'm pleased to introduce our panelists and moderators for Panel 3, a lawyer as judge or other neutral actor. Justice Verda Colvin is a graduate of the University of Georgia School of Law. She was appointed to the Georgia Supreme Court by Governor Kemp in July 2021 after her appointment to the Georgia Court of Appeals in April 2020. She previously served as Superior Court Judge in the Macon Judicial Circuit, having been appointed by Governor Nathan Deal in April 2014. After her appointment to the bench following private practice in North Carolina, Justice Colvin served as Assistant General Counsel at Clark Atlanta University, and then as a state prosecutor, and finally as an Assistant United States Attorney in the Middle District of Georgia. Justice Colvin is committed to service professionally and personally. She's a member of several legal and civic organizations, has continually served on various committees in her role as a jurist, and serves as co-chair of One Macon. Professor Charles Jay is a graduate of the University of Wisconsin School of Law. Professor Jay is currently an Indiana University Distinguished Professor and the John F. Kimberling Chair in the Law at Indiana University Marr School of Law. He joined there in 1991, and he teaches civil procedure, legal profession, and judicial conduct. His work on judicial conduct, ethics, independence, administration, practice, and procedure has appeared in over 100 books, articles, book chapters, reports, and other publications. Professor Jay has served as reporter to the ABA commissions addressing the Model Code of Judicial Conduct, the 21st Century Judiciary, public financing of judicial campaigns, and the separation of powers and judicial independence. He is director of the American Judicature Society's Center for Judicial Independence, and before academia, Professor Jay clerked on the United States Court of Appeals for the 11th Circuit, worked as an associate at Covington and Burlington in D.C., and served as counsel to the United States House of Representatives Committee on the Judiciary. Judge Mark Treadwell is a 1981 graduate of Mercer University School of Law. Judge Treadwell is the United States District Court for the Middle District of Georgia. He joined in 2010 after unanimous confirmation by the Senate and served as the court's chief judge for 4 years until May 2024, as well as 2 3-year terms as the 11th Circuit's representative on the Judicial Conference's Code of Conduct Committee. Before his appointment to the federal bench, Judge Treadwell was in private practice in Atlanta and Macon, and is a judicial fellow of the American College of Trial Lawyers and a fellow of the International Academy of Trial Lawyers. He's a trustee of Mercer University, the Peyton Anderson Foundation, the Walter George Foundation. Judge Treadwell taught Georgia civil procedure at Mercer Law School from 1999 to 2023. Our moderator for this panel is Professor Caleb Byers. He's an assistant professor here at Mercer Law and serves as the Law Review's faculty advisor. Professor Byers earned his JD at the University of Tennessee, where he graduated as valedictorian of his law school class and served as editor-in-chief of the Tennessee Law Review. He served as a judicial law clerk for the Honorable Thomas A. Varlin, United States District Judge for the United States District Court for the Eastern District of Tennessee. Professor Byers has also served as a judicial law clerk for the Honorable Ralph R. Erickson, United States Circuit Court for the United States Court of Appeals for the 8th Circuit. And his work experience includes United States District Attorney, the United States Attorney's Office, large and small firms, and judicial internships for the United States Magistrate and District Court judges. Professor Byers teaches and researches in the areas of business law, criminal law, white-collar crime, and evidence.
Well, good afternoon. It's a pleasure to be here with you today. So I'll start at the beginning. Each of you, as law school students, are developing your professional identity as you progress through law school. But I think your professional identity really began before you ever entered law school. Your core values and guiding principles are the key aspects of who you are and the key aspects that will guide you in the practice of law. Honesty, fairness, integrity, commitment, civility, fidelity to the law, and a strong work ethic should be the components of your professional identity. I make every effort to display each of these laudable qualities as a jurist. My professional identity didn't start when I donned a black robe. These were components of who I was as a legal professional. The preamble of the ABA Model Rules of Professional Conduct is a roadmap, if you will, a guideline to how we should practice law as professionals. It specifically reminds each of us that we have a special responsibility for the quality of justice as officers of our legal system. This directive may seem difficult to achieve when passionately representing a client and dealing with opposing counsel who may be difficult, but we are reminded by the rules of professional conduct that we should demonstrate respect for the legal system and for those who serve within our legal system. I think the only way we can do so is by reflecting on the values and the principles that are essential to a successful legal career. I think the best way for me to illustrate this is to share with you the guiding principles I have followed throughout my legal career as a litigator. And these same principles that I will discuss have guided me throughout my judicial career. In summation on this topic, I will illustrate how all of these tenets aided in my initial appointment to the Superior Court bench here in Macon and my ultimate ascension to the Georgia Court of Appeals and now finally on the Georgia Supreme Court. First and foremost, I believe every legal professional should have a why. Tyler, here I go. Where are you? Okay, because he reminded me that I tell people that. Why did you decide to attend law school? I don't know anyone who doesn't have a laudable reason. With your why in mind, it makes it easy to have fidelity to the law and fidelity to your clients. My why is a deep and insatiable desire to serve, to help create a more perfect union. When I started practicing law in Charlotte, North Carolina as a new associate, I made every effort to be completely honest in my dealings, whether it was talking to clients, sharing information they didn't want to hear, or being candid with the partners about my assessments and impressions of cases that we elected to pursue. I did it respectfully, but in fidelity to the law and to the client. I had to honestly share my assessments. This unyielding principle stayed with me throughout my career. Additionally, I remember a case that Judge Treadwell presided over, and I was going to do this even before I knew Judge Treadwell was on the panel. It concerned a housing authority director who illegally funneled contracts for work to her husband at various housing authorities throughout the city in violation of her office and in violation of federal law. She and her husband were able to disguise illegality by creating a company in the name of one of his painters who worked for the husband. The painter was told he was just signing forms and contracts to ensure that they would be able to get work and to keep people out of their business. He was also told that this was permissible. The painter was paid $700 a week. His salary never changed. As I was trying to make charging decisions, the easy course of action would be charging everyone: the executive director, namely the wife, her husband, the contractor, and the painter, who was seemingly unaware of the scheme, although he knew he had signed something that helped him obtain work. That would have been the easiest thing to do, because if you charge everyone, you can't lose. But if the jury believed the painter was a bad actor and I didn't charge him, maybe they would let the other two walk. My supervisors were not convinced that I was making the right decision. In fact, their objection was such that I knew that if I was wrong by not charging the painter, there would likely be unfavorable consequences for me. However, I knew the easy route was not ethically or morally permissible. My independent investigation revealed that the painter reached out to a friend who happened to be a sheriff deputy upon receipt of a 1099 form which reflected he made over $100,000. That friend took him to the FBI. Furthermore, after I asked him to examine his bank statements, I found no large deposits. Instead, I found deposits that reflected his $700 salary, and I found that he paid his tithes in church each week. He was paid $700 and he tithed $70. I didn't charge him because I felt he was used as a fall guy. I knew it was the right thing to do. In my mind, that decision reflected for me what it means to be a lawyer. I felt I had a special obligation to my client, the United States of America, the legal system, and the painter who was wronged. My personal conscience could not do what was expedient for me personally. My conscience dictated my actions. My professional identity was set. There was not a question in my mind, regardless of the outcome for me personally and the consequences that might flow from that. I kept a golden book, which is an American series of children's books, on the sofa table in my chambers when I served as Superior Court judge here in Macon. It was entitled, All I Really Need to Know I Learned in Kindergarten. Developing your professional identity, if it is to be positive and admirable, should include the simple truths that we learned in our youth, even in kindergarten. These are the most important lessons in life and in developing our professional identity. Lesson 1, sharing. That's what our interaction with opposing counsel is all about. Sharing discovery, information necessary to ensure that there is a level playing field for all involved. In my work as a trial attorney in private practice, state and federal prosecution, I always shared my entire file, every witness contact information, every document submitted by investigative agencies. My thought was, I'm a seeker of truth, not simply securing wins. This same mantra has followed me on the bench as a trial judge, and I required every litigant to share information and to talk with one another. That meant that as a trial judge, I shared as well. I never hit the ball about scheduling or my final decisions on cases, and my fidelity to my oath of office mandated that I expeditiously addressed every case on my docket. Lesson number 2, be kind. Play fair. Don't hit people and say you're sorry when you hurt someone. In our profession, that simply means be fair with counsel, witnesses, clients, judges, and their staff, and all other people you interface with on a daily basis. Be fair. Be courteous. Bottom line, treat others as you would like to be treated. I made it a practice to be courteous even in the heat of battle. That's an important value for me in defining my professional identity. I was once assisting a colleague in an 8-week trial. Judge Trapp may remember this too. When you're trying a case for that period of time, you're in the heat of battle. Nerves are frayed, and it's easy to be less than fair and courteous. But I tried hard to never allow the stress of trial work to affect the principles I hold dear. So in this pill mill case, there were volumes upon volumes of materials. We had so many notebooks that we had to bring carts in to bring all the notebooks into court. The opposing counsel one day couldn't find the page in the notebook or the notebook itself to follow along with my co-counsel as she examined a witness. I noticed defense counsel was frantically searching to find where the witness statement was in the notebook. He just couldn't keep up. Defense table in federal court here in Macon sits behind the prosecution's table. I got out of my seat as my co-counsel was examining the witness and assisted defense counsel in finding the correct notebook and turning to the page within his notebook so that he could follow along. My co-counsel, who happened to be my best friend, was extremely upset with me, and she let me know that when she came back to sit down. She was upset because I helped him, but that was reflective of my values and my principle, if you will, that defined who I was and who I am as a legal professional. Courtesy for me is as important as being competent and pursuing excellence. It is part and parcel of my professional identity. It demonstrates respect for the legal system itself. I later found out that the district judge in that case, Judge Royal, who was presiding, was moved and admired me for that very act, although she wasn't supposed to tell me that. That has never left me as a trial attorney, nor as an appellate judge. As a jurist, I have an obligation to be kind, courteous, and fair to others, and remember that it's like what it's like to try cases and have the stress of time constraints as a constant consideration. Temperance is part and parcel of my professional identity as a jurist. I am mindful that I must always be considerate to those who appear before me, even as I sit on the Supreme Court of our state. Just because I have power doesn't mean I have the authority to wield that power in a way that is unfair and lacks consideration for all concerned parties. Lesson number 3, clean up your own mess and put things back the way you find them. For us in our profession, that simply means when you make mistakes, fix them. Vow to leave things better than you find them. And when you mess up, when you have not been fair to opposing counsel or your clients or even the court, as you should have been, apologize and make it right. This is especially true with colleagues in your office. That's what cleaning things up looks like. As a Supreme Court justice, we find ourselves occasionally reversing our own decisions and disapproving language in opinions that may be dicta. But this is what you do when you find that you have made mistakes, even when you're a Supreme Court justice. Lesson number 4, be balanced. Live a life being balanced with work, play, and learning. I strongly believe when contemplating your professional identity, it invariably encompasses how you live life. Being balanced, ensuring that you are a whole person and not just a legal advisor or advocate, enables you to define for yourself what it means to be a lawyer. When you have a balanced life, it helps you stay true to the values and principles that keep you mindful of your professional responsibilities to the law and to those whom you serve. I do this by lending my talents, my heart, and hand to things beyond the legal profession. I have always done this, and nothing has changed in my ascension to the state's highest court. I serve on boards. I speak at secondary schools. I serve breakfast to the homeless. I assist my community with initiatives to improve the lives of Maconites, as well as many other service projects. These opportunities help me maintain a balanced life and serve as a reminder of what I value, which is service above self, which serves as a reminder for me as an attorney, an advocate, and a seeker of justice. This reflects and defines my professional identity as a jurist. Lesson number 5, and my time is winding up, so I'm going to talk faster. Be aware of wonder and remember that we all are like the little seed in the styrofoam cup. That simply means we should always maintain a sense of curiosity and awe about the world and our profession. Even as legal professionals, we should try hard not to become cynical, cold, and indifferent. As you develop your professional identity, remember your responsibility to the public. The way lay people view us as legal professionals is primarily driven by how we respond to the world, to each other, and to them in our practice. Stay positive and build that into crafting your identity in the legal profession. Remember, even in the most basic or unexpected circumstances, life can sprout and grow like the seed in the styrofoam cup, reminding us of the potential for wonder and miracle in everyday things. We could use more of that in our identity, particularly in troubling times like today. As a jurist, we see so much. As a trial judge, I often saw people who had experienced their worst day, either as a perpetrator or a victim. As a justice on the Georgia Supreme Court, I am privy to every murder appeal in Georgia. That inevitably gives me a front row seat to see some of the horrors humans can inflict on others. However, nothing about what I have seen or experienced keeps me from being optimistic and seeing every case with fresh eyes. The litigants and counsel deserve that, and true justice demands that. The last lesson, from all I need to know, I've learned in kindergarten, is be brave. Be brave and unafraid to fly, like the pilot who navigated the first hot air balloon, manned balloon in flight. Develop a professional identity where you practice being brave. Advocate for causes and clients. Don't always pursue the easy. Be brave by being willing to explore areas of practice that may not, on first blush, seem to interest you. You may actually find your calling. I certainly did. Be brave. Make bravery a part of your professional identity. I guarantee you, you will be proud as you look back on your legal career. I made the decision to be brave as I stepped into the role of judge, and I made a bigger leap of faith when pushed, when I said yes to the appellate bench. It's scary charting the unknown, but sometimes that's where you find the best fruit. My service on the appellate bench brings a great deal of work, but also a great deal of satisfaction, knowing that my service makes a difference to communities throughout our state. According to the American Bar Association, approximately 0.4%, not even 0.5% of the U.S. population are attorneys. With around 1.3 million active lawyers in the country, that translates to only 1 lawyer per 1,000 residents. You have a monumental responsibility to develop a professional identity that is built around the principles and values reflected in the rules of professional conduct and the lessons learned in kindergarten. Just think, if you will simply remember these simple truths, these timeless values, and these always aiding and abiding principles, adherence to the professional and ethical rules that guide our profession will be second nature to you, and you will build a professional identity that will allow you to excel in your chosen legal field and in life. I tried to weave for you a picture in this presentation, a picture of how your professional identity should be formed by the simple truths and principles that encompass all of our rules of professional conduct. But you see through my journey, those professional identities, those values are reflected throughout everything you do. It doesn't start when you get to the place that you want to be. It begins when you start practicing law. Employ those principles and you will develop a professional identity as an attorney that will take you anywhere, whether there's partner at a firm, counsel at some legal entity, or jurist on our highest court within this state or the United States. Your professional identity is what will propel you or impede you. Your professional identity is what will propel you or impede you. It's up to you. Thank you.
I know that today is a big day here, not just because of the symposium, but because the bar results came out. My 2 clerks who took the bar both passed, and I said, well, I'll take the rest of the day off and go up to the law school for the symposium. I think they heard the first part of that, because I don't see them out there now. I told them they could start their weekend. And I have to say one thing about Justice Colvin. The case she talked about, the Housing Authority case, like most white-collar cases, it was a very document-intensive case, and there were two very good defense lawyers on the other side representing the two defendants. And, of course, we put cases on the trial calendar almost as soon as they're indicted, criminal cases. And 99 times out of 100, they get continued, not once but several times. But these lawyers on the defense thought that they could catch then AUSA Colvin unprepared. They announced ready that very first time in that document-intensive case. Well, they miscalculated. She was ready, and she got the convictions, and they were convictions that were warranted. I want to talk at a practical level about ethics, and specifically the Code of Conduct for the federal judiciary, with the notable exception of our United States Supreme Court, and with one other exception that we might talk about later. The federal judiciary has a very comprehensive and robust ethical framework, and I know something about that because, as you heard, for 6 years I served as the circuit's representative on the Committee on Codes of Conduct for the Judicial Conference. For 2 of those years, Judge Erickson, who Professor Byers clerked for, was chair, and he had a tough job, as we all did. It was a tumultuous 6 years. We had 2 high-profile cases of workplace misconduct that required us to revamp our workplace conduct rules. We struggled with the proliferation of privately funded educational organizations, and there's still a struggle over that. And we struggled with the role that judges can play in what, under our code, are called law-related organizations. I'm going to get into a little bit of that. But I think it's fair to say that the general public and many lawyers, particularly with the cases that reach the media, I think it's fair to say that most don't know that we have that robust ethical framework in the federal judiciary. So I do want to talk about that. These quotes I've put up there, I use these in the ethics training I do as kind of bookends of the ethical paradigm. Certainly the first quote was definitely from President Andrew Jackson, and it's a common thing we hear from politicians about the importance of an independent judiciary, but President Jackson threw in a qualification that I've emphasized there, an independent and virtuous judiciary. Apparently what he meant, given the second quote, was that if in his view the judiciary was not virtuous, then maybe they would lose their judicial independence. Because in the second quote, which most historians now think he really didn't say, but he did this, this is the Worcester versus Georgia was the Cherokee removal decision, the Trail of Tears decision. And even though the Supreme Court said that can't happen, it did happen, and the executive branch of the government did nothing to stop it. But it's a little more nuanced than just being virtuous or ethical, as we would probably put it today, as I will put it today. Under our code, the structure of our code is we have to be perceived to be ethical. Perceptions are the key to our ethical framework. If there's a perception of partiality or impropriety, then we have failed to abide by our code. Let me put this in a context that lawyers can relate to. Money. Let's say you've got a case and you think it's a $50 million case. To make a point, we'll take unrealistically high number, particularly for the type cases I'm going to talk about. But the problem is this. In this hypothetical case, it's a Title VII case based on transgender discrimination. And we know since the United States Supreme Court in Bostock that discrimination based on transgender status is sex discrimination in violation of Title VII. The problem you think you have with this very lucrative case for you and your client is your judge. The judge you have drawn in private practice represented exclusively defendants, and she handled a lot of transgender cases and won many of them. Before her appointment, she was openly and vehemently critical of the Bostock decision. Her spouse is involved in organizations lobbying against transgender rights. Since her appointment, she has attended at plush resorts private educational seminars where speakers attack the legitimacy of the medical diagnosis of gender dysphoria. Now let's flip the script just to be balanced on this. Let's assume that it's a Section 1983 case involving Second Amendment rights. Still worth the $50 million, you think, but your judge has been very critical of the idea that the Second Amendment protects gun ownership rights. Before and since her appointment, she's been openly critical of the Second Amendment in that regard. And to make matters worse, from this lawyer's standpoint, both of our hypothetical judges have hired law clerks who feel, think, and act the same way they do on these issues. Now, all you have to do with your $50 million case is get it to a jury, which means you've got to get it by a summary judgment motion. And what is that lawyer's perception going to be? It's going to be because of what this judge's background has been and what her current involvement in various matters is, that he does not think she can be fair. So that's what the code is aimed at, is minimizing the perception that we cannot be fair. Now, to illustrate how this works, I'm going to talk about law clerks. Hope you can see that. With the assistance of my law clerks, I've come up with two profiles. One, a liberal third-year law student, two, a conservative third-year student. I'm not going to go through all these. That's the reason we've got it up. But they're involved in perfectly legitimate activities. One is very much on the left end. The other is very much on the right end. Well, they're going to be law clerks in August after they graduate in May. And how is their life going to change? What is going to be their identity compared to what their identity is right now? And that will be determined by the code of conduct, because law clerks are chamber staff, and as chamber staff, for all practical purposes, they are subject to the same ethical requirements that judges are. And by the way, as Pat knows, interns too are subject to these same limitations, and I always have a conversation with Pat and a conversation with my interns about their obligations under our code of conduct. So, as you can see, they're very active in a lot of various areas. So what's going to happen? Well, let's take politics first, in both partisan and nonpartisan, because judges can be involved, and law clerks, in no political activity, regardless of whether it's partisan or nonpartisan. So that means all the posts, all the comments, all the likes on social media stop. The blogging stops. The committee has struggled with how to, with both judges and law clerks, because more and more people are active in that arena before they become judges and law clerks. What do you do with that body of comments and opinions that this person has put out there? And the advice we have given is you leave it there, because it becomes a part of the record that the lawyers need to know about as both the judge and the law clerk, because the judge has to know about whether the law clerk has any issues that might prevent her from being involved in the case. So all of that stops, but it's preserved. The bumper stickers come off their cars. They can't attend the political rallies that they enjoyed attending. Not sure why anybody enjoys that, but that stops. Jane, you'll see, is managing her husband's campaign for a nonpartisan position on the school board. Not only can she not manage that campaign, she cannot be in any way involved. She can't go to campaign events. She can't put her husband's bumper sticker on her car. The yard signs come down. Well, you say, what about my spouse? She's not a law clerk. She's not a judge. She wants to put up a yard sign. Well, the judges and the law clerk's obligation are to make best efforts to dissuade the spouse from doing that. I don't know how successful that has been. This is good news in a way. You cannot contribute to any political campaign. But in fact, you cannot be involved in any fundraising efforts at all. That too is good news in some ways. And this is relatively brand new guidance that the committee has come out with, one of our students hopes to work for the National Rifle Association Political Victory Fund. If you're going to work or plan to work after your clerkship for what is under our definition, a political organization, and that's not just Democrat or Republic or Libertarian, it's much broader than that. If you plan to work for a political organization, you cannot seek employment with them while you are a law clerk. And there's other restrictions on seeking employment. We do allow law clerks generally to look for jobs while they're law clerks within some limitations, but not with political organizations. Law clerks are subject to the same conflict of interest requirements and standards that judges have. Moving on from the political, and what really has become a problematic area are advocacy groups. If you cannot be associated, I cannot be associated with any group that might be advocating on one side or the other of an issue that may come before a federal court. And we could list those all afternoon, and they're very reputable organizations: ACLU, NAACP, NRA, CPAC, Southern Center for Human Rights, Sierra Club, Judicial Watch. Those are off limits for judges and law clerks as advocacy organizations. This has been a particular problem with law clerks, not so much for judges, although it has been for judges. And that is, we all know we have a duty of confidentiality, but particularly our younger, and most of our law clerks are young, of course, and even with our younger judges, they have come up in an era where you comment publicly as a matter of course, with the social media and other avenues. And I talked about that in some context, the political context, the advocacy context, but also what we do is very confidential, and sometimes law clerks who like to talk about what they've done during the course of the day forget that. And they find themselves posting about what's going on in chambers. Well, that can't happen. And there's a whole shift for all the reasons I've said in what that identity is if you're going to be a federal law clerk or a federal judge. So, I hope that illustrates how robust our code of conduct is, and it's not that much different from our state ethical rules. I think it's a little more precise in some ways, but notwithstanding the fairly high-profile things we see in the media about where things haven't gone as they should, By and large, I think that the federal judiciary at least has the framework that can ensure that litigants will not have the perception that their judges cannot be fair or impartial. Thank you.
I spend my life in an adversarial relationship with technology, and so I'm sort of basking in the afterglow of actually getting this done, never mind that it was with the assistance of a federal judge. Here's the thing, is that up to this point in the presentation, everybody has been talking about my life as a counselor, my life as an advocate, my life as a judge. They're an inspiration. I am not. I am not a judge. I have never been a judge. I just am a fanboy. And in fact, I think one thing that was not really said about these other folks is that others have talked about, well, think seriously, find your purpose. And being a judge is one of those purposes. I've just found traditionally, most law students don't think about it because they don't think that it can happen to them, and because it's multiple steps removed from where they wind up. Nevertheless, I think in its own way, it is an extraordinary calling. And that said, it is bloody hard. And one of the things that I do want to talk about that distinguishes the role of a judge from the role of counselors and advocates are really the pressure points associated with professional identity for judges in this modern era. And some of them are in need of work. The first one has to do with the transition in professional identity that judges undergo from their being practitioners to their being judges. The second has to do with the internal tension between a judge's personal identity, who they are as people, and their professional identity as neutrals. And then third has to do with kind of the external pressures that we are seeing increasingly imposed from without, and the incentives on judges to override the duties of their professional identity. Now, the first one, if you take a look at this one of the weiritudes of life from among American judges is that the people on the right side of this bench are all drawn from the people on the left side of the bench, unlike some civil law systems where judges opt into a professional track for judges very early on. Here they come from practicing lawyers, typically litigators, and good lawyers, therefore, do not necessarily make for good judges because the temperaments are fundamentally different in some ways. That a good judge has to be open-minded as to the issues they confront. Lawyers are under no similar obligation. Judges have to exhibit no prejudice in relation to the parties, whereas there's no real problem in lawyers cultivating a prejudice in support of their clients. Third, approaching the facts in law, judges are likened to umpires that call in the facts in law like they see them, whereas lawyers are perfectly at liberty to spin facts in law in manners they deem dubious. The ethics codes don't prohibit that. And finally, we've heard a lot about cause lawyering, which is celebrated and I think encouraged. Cause judging, not so much. And so I think that we are looking at a fundamentally different approach in attitude. And by the way, I should say that navigating that transition is as old as the hills. Advocates become neutrals. And it is a fairly well-worn path, not for everybody, but for those that it is. It begins in law school, where at this point you folks know the difference between a lawyer making arguments and a judge deciding cases. That's further reinforced once you get into practice, and you learn your own personality type. Do you have the personality type of a neutral, or are you born to litigate? Are you born to argue? And if you're born to argue, you opt out, and if you don't, in a lot of states, judicial nominations commissions will weed you out, saying you don't have the temperament, son. I mean, and that's another way of dealing with it. But then once you ascend the bench, judges attend, which is almost universally called baby judges school, where they're introduced to a code of conduct that is fundamentally different from the rules of professional conduct that other judges have been that other lawyers have been talking about early on in the day. It's just a fundamentally different sort of schema for reasons I'll get to. And then there's no substitute for on-the-job experience, where judges are working that transition from being advocates to being neutrals. They're learning as they go. If they kind of sort of suck at it, they will sometimes end up being in a situation where they're forced to disqualify themselves from cases where they went too far, and in extreme cases, discipline. But this is a manageable transition that judges undergo, and it's been going on for generations. The second one, which I think is more difficult to manage and is more pressing in today's day and age, is the transition between between a judge's personal identity and a judge's professional identity. Professor Rapping talked in terms of marrying your personal and professional identity. To no small extent, judges need to divorce themselves from work a divorce between their personal and professional identity. Certainly, at an elemental level, I think judges have to marry their personal identity insofar as they see that the way they can administer justice, the way they can do good, is by being neutrals. So to that extent, it's not incompatible. But the reality of it is that each of us has a race, a gender, a sexual orientation, a political viewpoint, and there is increasing concern that judges are allowing these aspects of personal identity to eclipse and get in the way of their obligation to be impartial, independent, and forthright. And so we see it reflected in these cartoons, which aren't funny, they're just representative of the perspectives, that this concern at the U.S. Supreme Court level, that judges, a commitment to the law is being eclipsed by, in the upper left corner, their religious view, their religion. The upper right corner, their ideology or partisan affiliation. The lower left corner, the race of the judge. And the lower right corner, the gender of the judge. These are these are omnipresent concerns that are becoming more and more in play as, some political scientists and others say that judicial impartiality is a myth. And is something that we shouldn't really take seriously, a point with which I couldn't disagree more, but let's go into that. From turning now to the code of conduct that Judge Treadwell was talking about, the ethical duty is pretty clear that judges need to separate their professional identities as independent arbiters of law from their personal identities, and it begins with the oath of office. The oath of office that judges take everywhere typically includes an oath to administer justice without respect to persons, which is a weird turn of phrase dating back to the book of Deuteronomy. But it really stands for the proposition that judges need to administer justice without regard to the irrelevant personal traits of either the people they're judging or the judges themselves. And that notion is reinforced in specific code of conduct provisions. I'm referring here now to the ABA Model Code of Judicial Conduct, which forms the basis for the Georgia Code that Justice Colvin follows, and the Code of Conduct for U.S. judges that Judge Treadwell follows. It originates from the 1972 model. Rule 2.2 says that judges have a duty to uphold the law fairly and impartially, and there's a comment that says, although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. Rule 2.3 goes on to say, judges, you need to perform duties without bias or prejudice. And Rule 2.4 says, judges, you should not allow your judgment to be influenced by family, social, political, financial, or other relationships. As you're going, you should be thinking at the back of your mind that these kinds of restrictions really, many of them really don't apply to lawyers who are advocating for causes and so forth. It's unique to the judicial role. Here's the rub. Social science data tell us that judges are, in fact, influenced by their own genders, their own race, their own religion, in cases where gender, race, and religion are at issue in the case. Social science data also tells us that judges are subject to the influence of their ideology across a range of matters, a range of issues. And so the question that it begs is, how concerned should we be about that? And I think the answer is, well, it depends. The duties of professional identity, clearly forbid judges from allowing the influence of their personal identities to subvert the rule of law. That is abundantly clear. And the one thing I should say is that from what you are being told by the judges today is the same message I have heard from, last count, I've spoken to 5,000 judges since I started this business. It is universal. This is the commitment. And it is sort of born, it's really deeply embedded in the DNA of good judges everywhere. What that means is that in easy cases, when the facts are clear, the law is clear, the outcome is clear, your personal identity has no bite. It should have no influence. And although you will have some sort of suspicious sorts arguing to the contrary, I have seen no evidence, empirical or otherwise, to suggest that except for the isolated corrupt judge, that this is a problem. To the contrary, every judge with whom I have spoken can cite chapter and verse, cases in which they ruled contrary to their personal views because the law required it. It is just, and it is part of something, sort of a part of judicial courage. It is part of the business of being a good judge. It's trickier, though, in hard cases, where the law is uncertain, the facts may be indeterminate, and some sort of judgment is necessary. Some sort of discretion is necessary in these hard cases. Even then, it is abundantly clear that this doesn't allow the judge to sort of use the indeterminacy as a smokescreen and said, oh good, now I can do whatever I damn well please. There is, again, not much evidence that that happens. To the contrary, I think the better explanation lies in this point that in these hard cases, judges are doing their best to apply the facts, to apply the law as impartially as they can manage, right? But they are confronted with two comparably plausible opposing arguments, right? And they've got to figure out which one is right, which one is correct. And it is kind of unavoidable in that case that they will side with the argument that their education, background, life experience, which can in some cases include their life experience filtered through their race and gender, and their policy perspective lead them to conclude is the right answer. That isn't judging gone rogue, that's judging done right. It's a normal part of the process. But here's the problem, that there are two possible explanations for why these extrajudicial influences affect judges in these very, very hard cases. One is the possibility that the judgment can be tainted by implicit bias. In other words, that the influence of these implicit effect of these these other influences in these hard cases is working a nefarious effect that we need to worry about. That's born of a kind of prejudice that's subconscious, that the judge isn't even aware of. And so to that extent, that would fall into the category of something we need to worry about, something that we need to manage, right? Conversely, though, there are other cases where you can speak in terms of the judge being informed by their personal experience. It's not a bias. It's just, I know the world. I can bring that world to bear more effectively by virtue of having experience with the world in these very hard cases. And the code of conduct articulates or recognizes that very thing. It encourages judges to engage in outreach with their communities. It encourages judges to engage in extrajudicial activities subject to the limitations that Judge Treadwell talks about. Part of that is, well, we want to make sure that the public retains its confidence in judges, and getting them out there is one way to do it. But part of it is reciprocal. Part of it is it makes for better judges if they know the communities they serve. And in jurisdictions in which trial judges technically run for office, I say technically because oftentimes they run unopposed, they nonetheless favor it because it gives them an opportunity to get to know the people they're serving, to get to know the people they're judging, to understand their problems more effectively, to use empathy, right? And to that extent, we can see that these influences in these hard cases, in this situation, are not problematic at all. They're good judging. The difference between being empathetic and understanding a situation versus being biased in relationship to a situation. And so the challenge, I think, is to ease the tension between professional and personal identity in these situations. And one way, of course, is through implicit bias programming, and all good judicial organizations do have implicit bias training. Problem is, I don't think it can reasonably end there. And there's another piece of social science data that I find really interesting, which is the research on panel effects in panels of appellate decision making. As I said before, there's evidence that race, gender, and ideology can affect decisions in cases related to race, gender, and have the ones with ideological valence by individual judges. But when we see panels comprised of judges of mixed race, mixed genders, mixed ideologies, that influence disappears. I mean, there is indications that the deliberative process assists judges in checking each other's biases to a certain extent. It assists them in informing each other of their respective life experiences to the effect of neutralizing some of those differences. And one of the challenges, I think, for the future is at the trial level, where you don't have a panel, you got one, are there ways in which you can mimic the effects of panels at the trial level? And it is worth noting, it's beyond the scope of today's talk, but it is worth noting that there are exceptions to the rule against judges engaging in ex-parte communications that allow them to talk with other judges, that allow them to talk with experts on, say, judicial bias, as a way to sort of bounce off their ideas. Now, trial judges are very busy, but in unusual cases where their implicit bias training says I should be a little concerned about this, there are opportunities to mimic the effects of panel decision making, to neutralize that bias and reconcile that sort of tension between the judge's professional identity and personal identity. The last point I want to talk about is the external pressures and incentives to override the duties of professional identity. This is not coming from within the judge, but from without. And here we have just, I mean, I'm telling you nothing you don't already know. That within the federal judiciary, we are looking at an increasingly partisan selection process dating back to the 1980s, culminating in diminished respect for the Supreme Court, unlike what we have ever seen. And to be clear, the public does not mind judges being influenced by their ideological predilections. They know that in hard cases that will happen. They do worry about judges being perceived as being part of political agendas or being partisan. And that is the difference that we're seeing with a precipitous drop in Supreme Court confidence. Annenberg 2 days ago said the same thing is happening with the federal judiciary generally, and it's dropped to 50%, the lowest it's been in the history of the survey. And we do have some evidence that there is, that heightened partisanship in the lower federal courts, driven, I think, by this partisan appointment process, is also in play there. That we have, new evidence that en banc decisions are determined in an increasingly partisan way beginning in 2018. We have sort of the judge shopping problem where ideologically aligned judges are sought out by plaintiffs in cases, and then there's a backlash within the judiciary against trying to regulate judge shopping. We have agitation over membership in ideologically aligned organizations, be it Federalist Society, the American Constitution Society, and the ABA. And we have, a new spate of 13 judges out there weaponizing their clerkship hiring practices by boycotting schools with whom they have a political beef by saying, I'm not going to hire Yale graduates because I don't like Yale's policies unrelated to the clerks. All of which suggests that we've got this new political pressure we haven't seen before. And so where does this take us? I think the same, by the way, there's a mirror image going on in the state systems, where we end up seeing partisanship rearing its ugly head in the form of state Supreme Court elections, big money being thrown at those elections, first over tort reform, then crime control, and more recently abortion and redistricting. So the question becomes how to combat the escalating external pressure on judges to sublimate the duties of their partisan identities as their professional identities as impartial, independent, and forthright adjudicators. And to sublimate that to the partisan political predilections of their professional identities. There are a lot of well-worn proposals that sort of say, let's regulate their independence, let's control them. I tend to be averse to those proposals, and in a conference on professional self-identity, it's not my ambition to tread the tires of proposals that seek to reform the judiciary from outside of it. Rather, to escape the escalating external pressure that's really threatening to contort the judge's professional identity, the judiciary should look inward to the code of conduct itself, augmented by a deeply embedded institutional culture that pushes back against encroachments on its core belief in judicial impartiality, integrity, and independence. And if there is a common thread to this conference so far, it is that this embedded culture of lawyering is driving the decision-making of lawyers everywhere, and that includes judges. Acculturation to the norms of the judge's professional identity begin in law school, where future judges are introduced to the differences between lawyers as advocates and judges as neutrals. Those norms are reinforced after law students graduate when they become litigants who are trained to persuade judges on behalf of their clients with primary recourse to facts and law, and the judges, not the judges' extra-legal predilections. The norms of, thank you, the norms of the judge's institutional culture, the norms of the judiciary's institutional culture are then revisited when lawyers transition to judges and internalize their codes of conduct. Code of conduct norms are further entrenched by continuing judicial education programs, by code of conduct committees like the one that Judge Treadwell was involved with, and by higher courts that reverse the rulings or issue writs of mandamus against judges who fail to disqualify themselves when their impartiality is in doubt, and finally by disciplinary bodies as well. The divisive, polarizing, partisan forces I've described here pose a threat to the embedded institutional culture that protects the values underlying a judge's professional identity. The time has come for the judiciary to double down in defense of that culture. Historically, a judge's acculturation to impartiality, integrity, and independence norms came naturally and easily at a time when systems of judicial selection did not prioritize candidates whose, I'm 30 seconds off, I'm hanging in. sort of like feel like I'm turning into one of those old Federal Express commercials where I'm suddenly accelerating the presentation. The problem is, I think, that some new judges joining the fold in this new partisan environment, who arrive with more resolute partisan allegiances than their predecessors, may be more resistant to immersion in the nonpartisan culture of the judiciary that has preserved its collective professional identity than in the past. And to blunt that development, judicial systems need to steel themselves for the uncomfortable task of protecting, defending, and policing their traditional norms from a new generation of judges, most of whom are like their predecessors, but some of whom do not always share those norms to the same extent, and who require additional wheedling, persuading, and when necessary, shaming to join the fold. Thank you.
Well, thanks to our panelists so much for joining us today. Certainly, I think a common thing we're hearing is the importance of impartiality. The truth is, at least in my experience working for judges, that most judges really are just trying to do the right thing in the interests of serving the profession and, promoting respect for the legal system itself, which is true for counselors, advocates, as we've heard today, and certainly true for judges as well. With that, those brief comments, happy to turn over for questions that you all have for our panelists.
Could I talk about this last point, combating the pressure and that theme, Professor Byers, that you just identified? It strikes me that stepping back to the appointments process is something that might be illuminating in that regard, and we have an interesting history of that in Tennessee. I'm sure that the judges are aware of that, probably are as well, where we have a sort of mixed system with our Supreme Court in terms of political appointments from the executive branch and legislature, and also a voting process. The voting process has been politicized, as has as you might expect, sort of the state process in Tennessee. How do we preserve this culture in light of the highly politicized nature, potentially, of retaining people in office or as a judge, or actually appointing them to the bench?
When you say preserve the culture,
The culture that
Okay.
we were just talking about, the culture and norms that might help protect us from the pressure of politicization. Is there, maybe you can illuminate for me, because I haven't been a clerk, things like, the judges school or other things where this culture is maybe embedded in the judiciary, regardless of the process of appointment.
maybe Georgia is like Tennessee in that if someone leaves in the middle of their term, then the governor appoints. The governor, of course, is affiliated with a political party. I'd like to think, particularly based upon my appointment, I was appointed initially by Governor Deal, and then appointed by Governor Kemp. And, they tout me as being the first African-American female ever appointed by a Republican governor. Based upon who I am and how I presented myself in practice and as a trial judge, I am hopeful and thinking that there are those who are looking beyond Ds and Rs are how people's stances on issues to say, is this person qualified? Are they fair? And do they do their best to follow the law? And I think that's what you have to have in your system of government, people who are committed and really see the value in looking past all the things that we use to put people in a box. Because most people don't fit neatly in any box. Nobody does, regardless of gender, cultural background, racial identity. Most of us are a hodgepodge of a lot of different boxes that come together to make who we are. And so I think it's about having people who can see that and be willing to do that and to make those kind of decisions that reflect that. And so that's my hope. And I think that's the only way it can really change and get to what it needs to be.
Just to be clear, we have our retention elections are done usually as elections.
And we have elections, so you're appointed, but then the next election cycle you have to run. So I was appointed, and 8 or 9 months later I had to run statewide. So you have to be retained by the voters.
Judge Treadwell can correct me here, but one of the things I really admire about the lower federal courts is the embedded structure they've created for creating this kind of culture. I mean, it begins with Baby Judges School, then there's Federal Judicial Center educational programming devoted to it. The Dear Abby Committee does more than just, they issue advisory opinions, and Judge McEwen testified before Congress that they were responding to up to 1,000 requests a year. The Judicial Conference of the United States is responsible for overseeing this, and judges work their way through the Judicial Conference, so that there's just participation in the revision, evaluation, application of the rules that I think creates this culture that pushes back against what may be a sort of a partisan predisposition that judges may have as lawyers coming into it.
This is a little bit broader perhaps than your question, but I mentioned that without saying what it was, that there was one issue that I felt that the federal judiciary, one ethical issue that has not been handled well, and it relates to the appointment process, but more specifically, it is the American Bar Association. Fine organization, nothing wrong with it, but what happened was that in the 70s, the ABA began taking positions on matters that come before federal courts. And mostly those positions were on the left side of the spectrum. Before I came on the Codes of Conduct Committee, this issue was dealt with several times, and while we were there, can judges be members of the ABA? And the committee, in its advice, said several times that they can, because the ABA has a separate judges division, and therefore they're separate from this ideologically oriented ABA general body. Well, that doesn't, I've come to conclude, pass the perception case. It certainly didn't pass the test, didn't pass the perception test among conservative lawyers. And if you look at some of the founding principles and what some of our conservative legal organizations were saying when they began forming in the late 80s and early 90s, they were very clear. They were forming in response to the ABA's influence generally, and in particular the ABA's influence on the appointment process of judges. I think, the benefit of hindsight, the federal judiciary, through its ethical body, probably should have said no. Judges cannot be members of the ABA because the perception is, as the ABA has taken the positions that it has, that it supports one side of the spectrum on issues that come before the court.
Professor Floyd?
I'll follow up on that slide we have up there, Professor Jay's membership in ABA, but also the Federalist Society and the American Constitution Society. Where do those other two organizations fall in terms of being either partisan or advocacy organizations?
I'll let you speak for the committee, but they concluded that neither of those were appropriate to be members of. The ACS did not object to that. They agreed. The Federalist Society did because, from their view, they were straining hard to avoid the perception, to avoid being technically an advocacy group. I think the problem does come back to what Judge Treadwell was talking about with appearances, where I think the perception of the Federalist Society is, well, yeah, you are kind of aligned. And so I think that the recommendation was to give the ABA a pass, and Judge Treadwell was objecting to that part of it, and to sort of say the other two were unacceptable.
What we're talking about is Advisory Opinion 117, which you will not find, because notwithstanding the prerogative of the Codes of Conduct Committee to issue advisory opinions, after that one was published, well, it didn't quite get issued. And you won't find it. It's out there, but because of a lot of objections, Advisory Opinion 117 was, by some process that I didn't understand then and don't understand now, not enacted. But if you read that, it's, I think, a good discussion of the issues we're talking about, and it was not critical of either the ACS or the Federalist Society, not at all. I mean, there's nothing wrong with those organizations. The issue that we were trying to address was whether judges' membership in those organizations could be perceived as having preconceived notions about issues that come before federal court. And yes, the ABA got mostly a pass in that opinion, and what I'm saying, and quite bluntly, is that was probably wrong.
Anybody else?
I'd like to know how y'all approach the hard questions that Professor Jay mentioned in his talk. You don't have to say anything specific in specific cases.
It's funny, when he said that, I kind of smiled to myself, because I always say, when I try to explain the way, it's like I have to have a divided being. You know, I am who I am. I believe what I may believe personally, but I am duty-bound, and I read the oath often. I am duty-bound to follow the law, and I have to follow that even if I don't like it, even if it's different than what I would have done had I been a legislator. And so I just make that a practice, and I read it so I can do that. And what the hard part is, and I try to explain to lay people, if I don't follow the law, particularly if it's something that I don't like, how do I justify following the law just because it's something that I like? And so as a result of me following the law, at least I'm showing the voters or people in the public that this is what it is. And if you don't like it, then do what it takes as a voter, as a constituent, to change things so that it can be what you want it to be. But if I don't show you what it is, then you don't really know what you're facing. And so that's kind of how I try to make myself stay on the right road.
And how do you deal with the really hard case, though? In other words, where it's, if you know what the law is, then I'm with you 100%. But how do you deal with that case where, boy, there are two good arguments here, and I can't say what the law is? I have to say what the law is. Don't you sort of have to bring a little of your personality into play to figure out which of these two arguments that are comparably good is right? That just seems so hard.
As I think about something I've had to decide, what I've done to try to do that is find all the case law I can to justify whatever side I end up thinking is the right way of looking at it. And then I've compared against the case law I find that may not be what I like, but if it's not as strong, then I'm going with the stronger argument that I just happen to like. But I do try to look at precedent, and if it makes sense, then I feel like I have to follow it. But if it doesn't, or there's some way to distinguish it, then I do.
Two quick things come to mind. I know we're almost out of time in response to that. One, I was sharing this story with Justice Colvin. Probably the only one in this room who'll remember who I'm talking about is Scott Spivey, a very good trial lawyer here in Macon, T. Reese Watkins. And he had a judge who was struggling to make a decision on the bench, and he said something to the effect of, you know, I just want to do the right thing. I want to do justice. And Mr. Watkins, crooked finger, they called him because he had a crooked finger, and he liked to use pointed the finger at him and said, it's It's not your job to do justice. It's your job to follow the law, and which is what Justice Calkins is talking about. The other is this, and it works the other way, and this is another small-town lawyer whose partner went on the bench down in Lawrence County in that circuit, fairly rural circuit, and he hated it because every time he had a case before him, if it was a close case, the judge was going to go the other way because he was so careful about whatever implicit bias he may have and so careful about his obligations that close calls
Went the
didn't
other
go
way.
the lawyer's way.
Which ain't great either.
No, but I do think it reflects how most judges, in my experience, try to handle those close cases.
Well, thanks so much to our three excellent speakers here. Please join me in thanking them. Great to have you. Please come down.
Thank you so much.
Yes, of course. Presentation, and as I told you, I got several of your articles.
Thank you.
It was a lot of fun.
Oh, yeah, that's right.
On a lot of issues.
Judge Treadwell?
My own little canvas bucket, thank you.
I don't talk to you again. Have a safe trip back. I don't talk to you again. Have a safe trip back. Thank you.
I was going to ask you one question, Sean, and I decided not to eat up the time. We don't have to talk it through now. You mentioned shaming.
Well done. How are you? Everybody good?
Shaming. Yeah.
We're okay. We're okay. Everybody was out today. David had to go to big here yesterday.
That's a great idea.
It didn't take, but I think it's possible.
Good to see you. Good to see you.
Hi, Judge Treadwell. I didn't get to meet you this summer, but I worked for Judge Self. You sent him the Ware opinion, and I wanted to thank you because it was very helpful. But I didn't get to thank you over the summer, so I had to thank you today.
You were down there.
Let's not return to behavior.
I learned a lot, and like I said,
That's great. Well, thank you.
Very helpful.
Have a good trip
One
back.
of the better ones on that issue, so thank you.
Wow. You guys go first and work.
Yes.
Until this trip, you'll have a good
Pleasure to meet you, Judge. Matthew, I'm the youngest of seven, so I'm gonna call the dog's name. I just want to say, if you remember her, Jordan Bracewell, she was an intern. I was texting her before this. She did pass the bar this morning.
Well, of course she passed the bar.
She was calling me in tears. I was like, I never doubted you for a second. You could.
Glad I'll share that.
Yeah. It's an honor to meet you, sir. I reached out to your chambers. Appreciate you talking about the responsibilities of a clerk. I'm interning at the statewide business court right now, but I reached out to your chambers about clerking for you, how you like your applications. So I appreciate a foray into my ethical obligations, whatever I do.
But the story behind
I
this
appreciate your speech. Thank you.
I mean, serendipitous, amusing, I mean, it's just really, if there's ever a dull moment at Wesleyan, it must be when I'm talking about this speech, I'm going to laugh. Because it's amazing the way it's got it about and what happens. Well, yeah, back, actually, the reason our class even mentioned there is because of the whole.
Yes, they go out these doors.
And we were some negotiations.
I remember you
There's your story.
That's my
Well, it was funny that it
For
would.
my high school business class.
I
know.
It
It is on there. That's good to go.
What was that, 2018?
I'm just gonna keep it open. Okay, that's fine. Put this up, so.
Okay, and she was walking in with President Knox. And,
That way we don't have to.
that was when the announcement was made. And I guess she was speaking.
I went to the celebration of them where
And, and then I guess she came to do it last speech. They'd asked me to do it the year before. I was running for reelection, and so I called and said, oh my gosh, they set the reelection for the Tuesday after that graduation speech. I can't do it. I have to be here that weekend. It's okay, we'll put you down for 2015. And that's how
good to see you, Judge.
I would
Thank you so much.
I'm
Well,
telling
it was
you,
great.
It's an amazing story. The
It was
whole
an
thing,
amazing
soup to
speech.
nuts.
Yes,
Thank
and I have-
you. Thank you so much.
And sometimes it gives me PTSD.
Right, yes.
Yeah.
Yes, I do.
Yeah.
Yeah, I've been texting throughout the day. What did you do tonight?
Well, I'm sorry to bombard you, Justice. I thought you were going to head out.
No, I'm gonna say, I'm about to head out. This is horrific.
Either roommate or they, Atlanta with Sweetbriar. She was, they were carpool.
Can we get y'all anything?
Good, I got some water.
Did you have a presentation that you needed on the computer, or you?
No, I'm still talking.
Perfect.
Well, now we're just gonna, pick from all the good stuff
Bring it
y'all
home.
said. Yeah, right.
I thought the order we ought to go in is whatever order y'all sit in. This way, so I guess you go last.
I was speaking to a friend of mine last night. I told her at the pleasure having dinner with you. She was saying,
Yeah.
she was out about it, and like, I took a look at it.
Yeah.
It was an amazing.
Amazing, to have that data, huh?
Yes, it was really good. I saw that.
Do you want me to go first? I'll do it for you.
No.
Oh, I mean, I'll do it. That's no problem.
Given how much you disclose, I'll do whatever you want.
Take out, flip it.
No.
Yeah.
Both presentations
Yeah.
are open. and
Oh, I
they're-
gave it to you, one of the staff.
So, what, so you don't even have to escape from it? You just gotta, click down here.
Oh,
Yours is on the left, yours is on the right. That is going on. It is this little guy, looks like an easel or a pull down.
No, I mean,
Which remote?
which remote? You got this
That
one.
one does it.
The one on the right goes forward, the one on the left goes back.
Got it?
is that it?
I'm more like.
Is he going first?
Yeah.
Professor, I hope you don't feel like all these Georgians on one side, Oklahoma, North Carolinians.
There's no one in this room from North Carolina. I've been lonely all
Oh,
day.
you don't know that. Maybe.
Once a Davidson person, always a Davidson.
Oh, my, you're pretty hardcore.
Great frustration for law school to do. Law students tend to keep the affiliation of their undergrad instead of the affection and the money to their law school. But no one's as bad about that as Davidson.
Right.
Which was trouble in Carolina because we always had a lot of Davidson students. No.
I'm very glad.
Reminded me of a friend of mine, a friend of mine at the Chapel Hill Law School. He's a big baby. And I think, of course, he loves the target. He had this amazing, beautiful story about how the law school supported him in his difficult parts of his life. He was like immensely indebted to Chapel Hill.
You might be the next name for
But you've done it.
I will never be that.
Be that sort of a big university.
Right, yeah.
He's old, he's old.
Yeah, he's probably 60.
I mean, there are a lot of those stories, but also at a time when, of course, it costs $150 a year to go to law school. And so if the dean chipped in $25, it was a big deal.
Well, yeah, I think it was a came from sort of, I think, learning. They want to see. I mean, that's what he was like. He was amazing. And it's because like this crazy wasn't mean like the typical things that I do. It's just it's a story about Chapel Hill. Level up.
I'm close friends with Tom Ross, who used to be all professor and then with Howard. Tom is an extreme target, always was, but not over David.
It was you know, I've been to Fort Myers, for West Virginia.
My first teaching job was
But I put this is the president of the seminary or law school, and I said, "What's a good school for you to work?" One guy said, "Oh, Davidson." So a few years later, I applied. Every time he would come over to visit, he would meet his kids. Oh my God! I was sitting there. They would say, "Well, you visited
Yeah.
Yeah.
Well, I used to think it would be put something in the water, everybody like touches Charlottesville, something like hypnotic.
They started putting up some stuff.
Yep. Okay, I will take that. All right. Okay.
I'll start the wave, you just.
I have no idea if my slides line up with my presentation. We'll figure this out.
Just roll.
All right,
Nobody will
everyone,
know.
we're going to begin our fourth and final panel, and Seth is going to introduce our panelists.
Hello, everyone. It's a pleasure to be with you today. My name's Seth Elmore, and I'm the 11th Circuit Survey Editor for Volume 76 of the Mercer Law Review. I'm pleased to introduce our panelist and moderator and final panel, lawyers as active participants in public life. Our first panelist is Mr. Doug Amar, a 1989 graduate of the Washington and Lee University School of Law. Mr. Amar first worked as a volunteer for the Georgia Justice Project when it began in 1986, then joined as a staff attorney in 1990, and has led the project as executive director since 1995. The Georgia Justice Project provides holistic criminal defense and social services for its clients. For example, in 2020, it assisted over 6,000 Georgians with criminal justice issues. During Mr. Amar's time as executive director, the project has helped change 22 laws in Georgia that have worked to reduce barriers for re-entry, and he has received numerous awards for being a leading voice addressing issues of criminal justice reform. Our second panelist, Professor Gene Nickel, who is a graduate of the University of Texas at Austin School of Law. Currently, Professor Nickel is a Tinsley Distinguished Professor of Law at the University of North Carolina, where he teaches courses on the Constitution and federal courts. He previously served as president of the College of William and Mary and dean of the law schools at Carolina and Colorado. Professor Nickel is the author of numerous books, including, most recently, Lessons from North Carolina, Race, Religion, Tribe, and the Future of America and Indecent Assembly, the North Carolina Legislature's Blueprint for the War Against Democracy and Equality. He served as director of the Poverty Center at UNC until it was closed for publishing articles that were critical of the North Carolina Governor and General Assembly. Professor Nickel has been a columnist for the Raleigh News and Observer for over 20 years and has published articles in several leading law reviews, as well as The Nation, Washington Post, Supreme Court Review, Southern Cultures, and Slate Magazine. Our third panelist is Mrs. Teresa Pike Tomlinson, a graduate of Emory University School of Law and a partner at Hull Booth Smith, where she practices in complex trial and appellate civil practice. She has led litigation teams in notable high-profile cases throughout her career. Ms. Tomlinson also served 2 terms as the mayor of the Columbus, Georgia Consolidated Government, Georgia's second largest city. In January 2011, she was sworn in as the city's first female mayor, and in May 2014, she was re-elected to a second term, making her the first mayor since the city's consolidation in 1971 to win re-election in a contested race. As mayor, she oversaw nearly 3,000 employees, a $275 million budget, served as public safety director and homeland security director for a 16-county region. In 2020, Ms. Tomlinson finished second in a field of 7 candidates in the primary election for the United States Senate. Last but not least, our moderator for this panel is Professor Tim Floyd, who is a Tommy Malone Distinguished Chair in Trial Advocacy and Professor of Law here at Mercer. Professor Floyd teaches a variety of courses in criminal law, civil procedure, and legal ethics. Until 2023, he served as Director of Experiential Education at Mercer, supervising clinical and externship programs. Professor Floyd has published 3 books and is the author of numerous articles in the area of legal ethics, law and religion, and criminal law and the death penalty. His most recent book is The Formation of Professional Identity, The Path from Student to Lawyer, with Professor Longan and Daisy Floyd. Professor Floyd devotes much of his service to access to justice issues, and he has represented several defendants in death penalty cases, including the first person convicted under the Federal Death Penalty Act of 1994. Professor Floyd received his law degree from the University of Georgia, where he served as editor-in-chief of the Georgia Law Review. He previously taught at the University of Georgia School of Law, where he was the director of the Legal Aid Clinic, and at Texas Tech University School of Law, where he was the J. Hadley Edgar Professor of Law and co-director of clinical programs. And with that, I leave. Thank you all.
All right, we're going to see how this works today. And, you know, I can't believe everybody's still here. It's Friday afternoon. It's a beautiful day. But anyway, so I'm glad you all are still here. All right. It's really an honor to be here. Doug Amar is my name, and I've spent some time down here at Mercer over the years, and I'm so glad to be back. And I'm really here, well, first of all, thank you for the law review, the school, and the professors. But I really owe my thanks to Tim and Daisy Floyd, who are longtime friends, so thank you for asking me to come back. But I just hope that you all will suffer the hurricane force winds after I leave that will sure to come at you for like, what are you doing for inviting that scallywag to come down here? All right, so I'm going to do a couple things today. I'm going to try to do a lot. I talk fast. I'm from West Virginia, not New York, but I talk fast, and I don't know what that's about. But I'm going to kind of dive into this conversation around this. I was asked to talk about this active participant in public life, which is very appropriate for me as my role as a lawyer and as the director of the Georgia Justice Project. We say GJP for short, so I'll say that quickly and get it out of the way. So for the 38 years this organization has been around, we have always done direct service work, and only for the last 20 or so years have we done policy work. So we've done both sort of the individual work and in the last good many years done sort of the broader scale work. But for us, we see these two as very integrally related and connected. And being an advocate, both historically and currently, we still represent folks. I'll actually be in court on Monday, amazingly. Don't Justice Coleman, don't get mad, get scared. I know I still go to court some, just because I want to. But we see those as very connected and really inextricably connected. We believe that one iterates the other. In other words, direct service work informs and shapes our work at the broader level and the policy level. So last night's speaker, I was really intrigued, probably why I thought about this a good bit, Mary Smith. She suggested that there's often a connection between those of us, people who want to do individual work but also see a larger change. But at the same time, those things don't often run concurrent. They don't happen at the same time. And they're really rarely overlapping. And often people like us, I would say, are too impatient. We want to see it all happen at once. And so how do you navigate this place where they don't happen at once, where, in other words, doing individual work is individual work, representing a client, one at a time, versus sort of trying to get to a systemic level issue or in the sense of the public sphere. But we believe that they're very connected, and it's important to sort of stay with the work individually, even though the change might be distended by time and effort, they do go together. So for the last, I'm going to try to use the slides here. Oh, I got it working. Okay, I'm just a few slides that pop it up. I've got a few more. It's going to get deep. I mean, a lot more text on these things. Little visuals that keep you. This is in our lobby at our office. And by the way, our office is right behind the King Center in the old Fourth Ward in Atlanta. And we've been on that block for 36 of our 38 years. So for the first 20 years of our organization's history, as I mentioned, we focused solely on individual work, and that's being an advocate for somebody and helping them. But we've done that in a very unusual way, and I would actually dare to say an iconoclastic way. So in and of itself, our work, our direct service work, has defied traditional professional dictates. And that work, I'll explain a little bit more detail, was really about pushing the boundaries of the attorney-client relationship. And we did this simply, and we've done this, it's helped us apply our knowledge about the system, but it's given us a boldness and really a boundary-breaking approach to give us the confidence to go and do more, to create more, and to innovate more. So I believe I was asked here to come and talk about this idea of how our work, I think, connects to these principles from the ABA model rules, and I think we have something to say about it. So let me just give you sort of my bona fides about why I think I'm here for a moment, and then I'll dive a little more deeply in our work. So first, our organization has actually passed 23 different laws in the last 15 years. We got one this year, so we're up to 23. 2, we have pioneered the first expungement summits in Georgia. that happened about 10 years ago. And these are day-long events that actually, that's when I got to know Justice Colvin here in Macon, doing events here with the players. I'm actually doing one tomorrow, our staff in Clayton County with the solicitor there. 3, we have launched and operate the only expungement desks, we call them second chance desks, inside courthouses. We have one in Cobb County for the last couple of years, and then we have one in Athens, as well as in Augusta that serve 2 different counties there. And these desks operate in partnerships with the local players, prosecutors, judges, clerks, to bring quick and streamlined approach to clearing up somebody's record, AKA an expungement. And as you might know, there's about 4.5 million people in Georgia who have a record, so there's a lot of demand for this work. 4, in partnership with the Department of Corrections for the last 6 years. Now, I'm a defense lawyer, by the way, so I say partnership with corrections. I say partnership with prosecutors. You're starting to get the vibe here. That's unusual, right? It's unusual for me, having been a defense lawyer for 34 years. But in partnership with the Department of Corrections for the last 6 years, we have gone into a prison, the only prison inside the perimeter of Atlanta called the Metro Reentry Facility, to help remove barriers to reentry before people get out. And that work is primarily focused on warrants, outstanding warrants that people have often obtained while they're incarcerated, but also helping people obtain their driver's license or overcome suspensions to the license. And that issue is primarily due to debt, not bad driving or HV violations, just people who are poor, who missed a court date and owe something to a court, and they have that help being held over them. Number 5, and stemming from this experience in the prison system in the last 6 years, we've been invited by the City of Atlanta and Fulton County to bring that work into the Fulton County Jail in the City of Atlanta. We call it the Warrant Clinic, where we are helping remove holds that folks have at the Fulton County Jail that stop them often from going to accountability courts. Of course, stops them from getting out of jail, but also it stops them from sort of the new diversion center that the city is launching that opens up in about a month. And that's been fascinating to be asked to go do that work inside another jurisdiction. And by the way, I'm going to give you a data point here. Holds for the prison system, about 40% of people in prison have a hold. In the local jail, I don't know what it is in Macon and Bibb, but Fulton County did their own assessment, 30% of people in the jail have a hold, which is a lot, meaning there's some other problem that's not being dealt with usually. Okay, and number 6, as part of that warrant work, we have a collaboration with the Department of Community Supervision. That is actually the Probation Department of Georgia, DCS. And that's wild that we work with them. They are so committed to this work around warrants, they've assigned what they call it the portal, the probation, or the hold portal, not the transfer portal for, I know it's football season, but they've assigned somebody to just work on this issue with us to help resolve these holds for folks all around the state. In fact, they want to roll it out faster than we're able to, but you get a sense of, again, the scope of that work and how it's happening. And for dessert, I'll save one issue, and that's around restorative justice. And I don't know, how many of you are familiar with restorative justice? As in, okay, a couple. I have one slide I'll throw up there. You'll have to learn it fast. But basically, we are partnering with elected prosecutors, a handful of elected prosecutors around the state, where we are offering and creating a mechanism so that there's a victim-centered healing diversion for adult felony cases. So now you can tell I get excited about this, which I do, and I get excited about talking about this accelerated change that we're in the middle of by leveraging our knowledge and our commitment and our experience gained as criminal defense lawyers. We have learned from our direct service work and that we've seen gaps in the system, and that we brought specific solutions to those gaps, whether they be individual work, whether they be a policy change, or creating mechanisms in between. But as I mentioned, that wasn't always the case. We didn't always do that kind of work. So I should put up this slide, so I should put this up to give you some numbers. So the summer of 1986, I had moved to Atlanta from Birmingham, Alabama. I was 2 years out of college, and I was on my way to law school. And I was going to this church, and I met this guy who actually was the founder of our organization, John Pickens. So I convinced him, after 5 very aggressive tries, to let me volunteer, and he finally did let me volunteer. At the end of that time volunteering, right before I went to law school, I sat in his office. He had his office in his house because it was just one person. He had his office in his house, and we sat, and he just wanted to, do the whole mentor, how you doing, how to go. And I, being the bold, brash, I guess, 24-year-old, we're talking. I said, well, John, I said, this is great work. I said, but what are you doing to change the system? And he didn't pause. He didn't skip a beat, and he said, nothing. And that really, this is a picture of John Lewis and me at one of our events a number of years ago. And I remember just being caught off guard, really flat-footed, right, by, thanks, I remember just not even knowing what to think. because it wasn't what I expected. And I said, well, the system's broken, isn't it? He's like, yeah, it's terrible. And I said, then why aren't you doing something about that? You know, again, what am I doing? 24-year-old kid, no experience. What do I know? But and he basically said, listen, I'm trying to help one person at a time, help them have a good experience in the court system, give them effective and, representation, follow them afterwards, and help them not come back to the system. I mean, he just sort of said, this is what we're doing. I'm not sure what happened next. I really don't remember, but I was really speechless, and I remember thinking that anybody in the world I knew, at least anybody I knew that could change the system would be somebody like him. He was a former King and Spalding lawyer, and he'd been a corporate litigator for 15 years before we started the organization. And he was also a legend, actually, of sorts. He was a tall white guy, as you can kind of see. Went to Rice University on a tennis scholarship, Vanderbilt Law School. He was Mr. Basketball in his home state of Alabama. This is before integration, he always reminded me. But he had more scholarships for tennis than he did for basketball. So he actually played on the Davis Cup team. Tennis people, I don't know tennis that well. Okay, good. You're all good lawyers if you know about tennis and golf. But anyway, he played at Wimbledon twice while he was in college. I mean, he's a phenomenal. I'm like, this is a guy. He has access most of us will never get. And I thought, it's amazing if he's not thinking about that, if he's not willing to do that. That really was humbling to me. Now, looking back, I think I was just embarrassed. I was embarrassed that, I didn't know, like I said, I didn't know what the system was about. I was more embarrassed, not just from my ignorance as much by my arrogance. Was this sort of subconscious privilege peeking through my questions? I don't know. But looking back, I was pretty ashamed of that. And a few years later, in 1990, I joined the staff, and I remember, I was a second full-time employee, so we were small. And we were on Edgewood Avenue, so the same spot, same area, and it was a rough neighborhood. That's why we were there. We shared a building with another nonprofit that has a cafe for those on the street. We had about 300 square feet in the front. I had a big plate glass window beside me and a desk, and then there was the street. I was a storefront lawyer, man, and it was something. And I remember those first 6 months or a year, I just remember thinking, I really thought something was dying. I mean, when I say something was dying, I thought I smelled rotten flesh. That's how deep it was for me. And what I realized was dying inside of me was sort of part of my ego, part of my expectation about being a lawyer, what I thought it meant to be a professional. And for me, I grew up really poor in West Virginia, single parent, my dad, addict, the whole, and I was struggling to get out of poverty. And I thought, and here I am on Edgewood Avenue, drugs all around me, crime, and is this what I was supposed to do, right? And so what I realized happened, though, and what was going on in the first year or two, is part of me did have to die. I had to die to this concept of who I thought I was and what I thought it meant to be a lawyer and what I thought it meant to be, have a good education. We were just talking, I was fortunate to go to Davidson College undergrad and fortunate to go to Washington Lee Law School. And I kept thinking, is this why I worked my butt off? Is this why I made such good grades and all that? So part of me had to die to this deeper reality of being present to the suffering of others. And even my own suffering, because I thought I was trying to escape that. So for me, those first few years at the office were really challenging. And then for the next 15 years, we did not pursue policy, right? We stayed, grounded in serving people one by one. Now, let me transition for a second. So I'll talk about sort of some more details about us. So our organization is about a $4 million shop. We have about 40 employees. We serve lots of people. There's lots of ways of cutting how we serve people. There's a direct attorney-client relationship. Last year was 2,600, about another 6,000 in terms of all the events we do. We had about 250 volunteer lawyers from big firms and in-house counsel all over the metro area. In fact, our volunteer of the year last year was a paralegal from Home Depot in Orange County, California, and no one had ever met her. We brought her in to thank her, and Home Depot. So that I was floored. We had people helping us in California we've never met. Kind of a trip. This is just a way of talking about some of our the work we do in light of that earlier arc of justice, I call it. We show up at every part of the system. From the very beginning, we're defense lawyers. We show up in prison. We show up post-conviction. A lot of folks know us because of our criminal records work. A lot of folks know us because of our policy work and the work we've had there. But now this is the shift. All this is interesting. I wanted you to understand it. But it's really, to me, I thought the chance to talk to you all today was really about, I don't want to just say what we do. I don't want to even say how we do it. I'd rather talk about the deeper meanings underneath it. And so for me, one of the things we talk about all the time is our work is holistic, systemic, and optimistic. Now, to me, I'm going to go fast because I want to get to optimism. And the optimism part is the fascinating part to me. And by the way, these are words that we didn't create. Other folks came and talked to us and came up with these words, and I think they were accurate. Now, I could talk about holistic, but you kind of get the sense. We talk about holism a lot of different ways. We follow our clients to prison. We work with folks after they get out of prison. There's a client that Tim actually worked on with us who's still in prison, a case I lost and cried in court with my client in about 2006. We visit him regularly and take his mom to visit him. And he, by the way, he said a powerful thing recently. He said, when we represented him on this tough murder case, his mom was on the street. And as soon as he got convicted, his mom got clean. He's been in prison now for 20 years. And one of our social workers came back a few weeks ago, or a couple months ago, and said, he said, you know, if the cost of my mom getting clean is me serving time in prison, I'm willing to do that. Because we always thought, and he did too, that he's innocent, or shouldn't have been there. So the point is, we stay with our folks and their families, and that's one way of talking about this long-term relationship, which I think is one of kind of the most interesting parts of what we do. I want to get to a couple more things, and I'm going to run out of time. We stay with our clients by having events for our clients. Some of these pictures are some of the events we do regularly. We do 2 big events a year, 3 minutes. And we have a big back-to-school event we do in July, and a holiday event we do and Christmas time. Again, we're trying to create community, bring our people together, so that they know we're not just trying to be the lawyer. We're trying to be more than the lawyer. Again, these are just some examples of talking about what we mean when we say holistic. I could talk about collateral consequences till the cows come home, because we sort of, our expungements are us at our office. I won't do that. But let me just get to this, and I'm going to put a plug in for policy. We've actually changed 23 laws, and these are the most recent, and some of the biggest ones we've had, all signed under Governor Kemp, interestingly. Okay. Now, but what does it mean? Oh, but I had to put this chart up. We can't talk about this stuff without talking about race and disparity. But the reason that Georgia has so many people under correctional control is this graph. This graph shows every state in the country with correctional control numbers, and we are that leader in that because of probation. The top of that chart is about that, and all these charts are disparate with regard to race. And on the right of this chart, you can see the probation rates in a number of counties around the state. So I have to just put that out there in my very limited time, which I'll try not to go too far into. All right. But, and also, let me state this. This is about restorative justice. Let me go back. What does it mean to be optimistic? I love talking about optimism, and I believe we're optimistic. We have law professors who come to our office all the time, and I love some death penalty guys who've come from California, and they were walking around the office one day, and they were going around to get some coffee or lunch, and they said, what is going on? I mean, what do you mean? He said, these people are smiling. People are laughing in your office. I mean, this is hard work. I said, yeah. One of the ways I talk about our work is another catchphrase I like, and that is, a lot of people believe in fighting against something. We believe in fighting for something and for someone. So what we do, even from the moment we take a client, I'm the 17-year-old kid I'm going to court with on Monday. We're focused on not just fighting the state's case. That's what you're taught to do as a defense lawyer. But really, what is it you want to do in your life? And how are we building that up? Not just in the case with our social workers, but how are we staying with that client long term to do that? Here's what we found, is that court systems, prosecutors, judges, respond to that generative approach. They respond to you doing something proactive, and they respond to you creating a path that wasn't there before. We have 80% of our cases, our criminal cases, and we do homicides to shoplifting, 80% result in the last 3 or 4 years, 5 years, in non-convictions. Non-convictions, not because they're innocent, because we're walking folks through that process, and the court system responds positively. I would say another number, we have about a 4% incarceration rate, meaning when we do lose, very few people go to prison, but some do. I think, again, the system is responding to that optimism. So, last point, I know I'm out of time, about optimism, is this idea. I love to talk about restorative justice. This is the chart we use to talk to folks. This does not happen in the criminal legal system in Georgia. The idea that the victim is the focus, the victim is healed, like a mediation in civil cases. You all know what the answer for. What is a remedy in the civil case? You're all in law school. What is it? What's the remedy in a civil case? What's the remedy in a civil case? To what? No. To make the plaintiff whole. What's the remedy in a criminal case? You ever talk about making the victim whole in a criminal case? It's about sentencing. It's about probation. It's about fines and fees. Restorative justice is bringing that kind of approach into criminal setting. We have set up an apparatus now with, well, mainly 2 jurisdictions. We just took a case from Augusta where the prosecutors can send us cases, and we have trained people, staff, and volunteers to do a restorative justice process like mediation if the victim wants it, if the DAs want it, if the defense lawyer wants it. And then that process can be an alternative to just sentencing somebody or pleading out. So this is, to me, another example of an optimistic approach inside the criminal legal system. With that, I'll stop because I know I'm sorry. I get excited. And it's Friday afternoon, so I have to be excited. All right. Thank you all very much. How do I do it?
Well, it is such a pleasure to be here. Do you have the little clicker thingy? Okay, I was going to say. I correctly calculated that I would be able to stand on a whole lot of information that has occurred earlier today. And so I'm just going to jump in to some summary concepts. This is my wheelhouse right here, my passion, to talk about being a purposefist versus being a transactionalist. I'm a purposefist, but I was trained to be a transactionalist. So I hope I can give a little bit of insight that is reflected throughout my career. I want to talk about the span of the two concepts. Like anything, there are extremes. This is a bell curve in my mind. On the one hand, if you're an extreme transactionalist, you're dealing with a lot of moral agnosticism, and I don't know that's a good thing. If you're an extreme purposefist, you're an ideologue or full of sanctimony, and I don't know how helpful that is either. So hopefully you can cut that middle slice of the bell curve that's so important. The one thing about your professional identity you're going to find is that it is unique to you. It is your personality. It is literally your fingerprint. And so none of us, none of the great speakers you've heard today are going to be able to tell you how to adopt your professional identity. We can give you some of our thoughts about our professional identities or others that we've seen, but I hope that you'll cherry pick the stories, the experiences, the observations, and then choose those that help edify you as you develop your professional identity. What do I mean by these terms? A purposefist is someone who has a real passion, a moral drive that aligns with their professional effort. Now, this could have happened before. Maybe you just have always been into environmentalism as a kid, you were recycling around the neighborhood, and then you thought, well, I'm going to be a lawyer because I'm going to do things in another way. Or you got into law school because your parents made you go, or your friends were all going, or whatever, and then you thought, oh my God, wouldn't it be fabulous if I use this education I'm getting to do all these things I'm very passionate about? Either way, it doesn't matter. You are emotionally tied to your role as being a lawyer. So you utilize it for your professional drives, and you have a great professional affinity. Now, I had the opportunity to work with Sutton Egna for 2 summers in a row, and he can tell you I have no life balance whatsoever. In your minds, to me, it's perfect life balance. I work all the time because I freaking love it. I love it. I sit out by my pool on the weekends, and I read depositions, and I'm looking for those nuggets of gold in cases. I can't wait to write briefs. I could be reading a murder mystery, a caper novel. Sometimes I do, but mostly I'm working because I love it. I have a very high degree of passion and marriage between my personal and professional affinity. Hopefully you'll strike that balance for whatever it is with you. A transactionalist, on the other hand, is not necessarily negative unless it's in the extreme. They're calming, they're wise, a steady hand. They're the ones who, in this horrific divorce dispute, is able to say, I know, but let me just run out some other possibilities for you. So sometimes having transactionalist qualities are very, very good things, but they do tend to be rather dispassionate, objective, and have a greater separation between their personal and professional ethic. So you are here because you are able. And that's because you had by birth, by the environment you were given. You have intelligence. You have a base rationality. You like to do things like word puzzles, Rubik's Cubes, or something like that. Your brain works like that. You like structure. That doesn't mean you don't like a little chaos, but the chaos, the emotionalism, the ingenuity, reckless innovation, you know where that belongs in some sort of structure you have in your mind. That's the way you think. You feel connected to things, your community, your neighborhood, your state, whatever it is, because you have a sense that you're part of a social contract. Because after all, being a lawyer, the law is a social science. It just is. It's about community, how we live together in some sort of order. And so because you have this predisposition, you have sought education and training because you're going to do it better. And you feel like you've been called to serve. And you need to know that the law is a legacy that is going to live long beyond you. You are a gnat's eyelash in the legacy of the law. You are going to touch it this much, but that touch is going to be very, very meaningful. And so you know you're just a cog in the wheel of that next thing. You're going to carry that baton just a bit, and you better not drop it. So you've been called to serve. You're going to take these abilities, and you're going to aid those who are not able because they don't have these traits. So I want to share with you, I don't have any children, so I have like all this advice. So I find myself giving people advice in like elevators, and these people are like, I don't know, that woman's weird. Don't get in there with her. But I will. I'll just pontificate all the time about life lessons. Here's one. Risk tolerance. You all have a moral breaking point. There's a point at which you will do something very bad. Where is it? You better start knowing right now. And hopefully it's somewhere very far away. But I have seen great people destroy themselves because they were not aware of where their risk tolerance was. And so I'm going to just give you the cheat sheet right here. Are you prepared to be unpopular? I once interviewed a young man who had been the SGA president of a major university. He had been homecoming king, and he had been the youngest member ever invited to a very prestigious, exclusive alumni association. And I was looking at his resume, and I was so overwhelmed by this because I'm just, I don't know, I'm unlikable in some way that I can't put my hand on, but nevertheless. And so I said, my God, are you prepared to be unpopular? And it stumped him, and it stumped me because I didn't know the answer to the question. I hadn't planned it. It wasn't a trick question. And we then had this amazing conversation that stuck with me today. And by the way, he's a great lawyer in New York. He worked with us for a while and then went on and did great, great things. But you need to know, because there's going to be a time where the people you want to be with, it doesn't have to be because you're criminal defense and bad clients are in the media. That could happen. But it's probably going to be your friends. Those people real close to you. Either because you're the tax lawyer that just came up with a way you think is better, it's going to cost them a lot of money, or you're the person that thinks this private golf club needs to be integrated in some way. Something's going to make you unpopular. You need to know where that is. Are you prepared to lose? That's the one. Because you build your life to win. You invest the work to win. And you care about it, and you put all your chips on this, and you're about to lose. Will you change the playing field to win? Here's a test that was developed in the women's restroom of the United States District Court for Minnesota, St. Paul Division. As I walked in to a courtroom with me, a first-year associate with my local counsel and a paralegal, to Skadden Arps, Vetter Price, Briggs and Morgan with their whole galley, and a federal judge who played golf with all of them, and proceeded to say some uncomfortable things. And so right before that, I had an overwhelming wave of nausea. And so I went to the women's restroom because I was the only woman on the floor, and I developed this test that fortified me, but also balanced my passion and my rationality, and that was, I have worked as hard as any human being possibly could. I am not making a stupid argument here. I have thoughtfully considered and respected all the contrary views. People say they do that, they don't. You need to really put yourself in your opponent's shoes and think about why it is they're doing this. And at the very least, you're going to better your arguments, but you may come to some resolution through that. And do I just want the best right thing done? Because don't forget, you're a steward for a system you're just a cog in. And so you may think it's helping your client right now, but I cannot tell you the number of times I have beat my opponent about the head and neck with a case that he pushed forward that he had to know was not going to be good in the future, and I rammed it down his throat 5 years later. So you better just want the best right thing to be done, or you could be eating what it is you're doing if you're out there helping people create bad law. Plus the fact it's a breach of your oath. But Max McLamry, a Mercer Law grad, he was one of my many, many mentors, and he was the best and very worst mentor ever because he was gruff, curmudgeonly, he was a Dutch uncle, he had no soft delivery, and he spent years yelling at me. He would not have ever passed any HR test today. But he was wonderful and brilliant. And one time he gave me this research project, and I kept putting in the query. And by the way, if you put in the query of the rules you know, you're going to keep getting the answers that you know. And so I came to him and I said, I've tried to do this, and it's just, we can't do it. And he looked at me and he said, Teresa, the law is a tool for justice, not a weapon of power. And if you're not making it work for justice, then you aren't working hard enough. And he was right. So, I am the Forrest Gump of my life. I don't know why, but I just end up in these weird places with these amazing people, and like history's made, and I'm just sitting there going, I don't know how I got here. I seriously don't. I was hired by a great law firm by accident. I am convinced they had no idea they were hiring me. I was the only woman, I was the only associate in the entire firm. It was a boutique, complex litigation firm, and I don't think the senior partner knew I was there for 2 years. Anyway, and so I was assigned to a case called the I.E. DuPont Dana Moore's bin lake case. We represented farmers. They had used a fungicide. It killed their plants, sterilized their ground, and their greenhouses. We went to trial for 6 weeks in federal court. Our expert witness was 3M. They testified that they had one of the world's 2 mass spectrometers, that they could see that there was a contaminant in our farmer's soil. They could not identify what it was. DuPont had the other mass spectrometer. Their expert took the stand, and he testified that he could identify it, and it was not sulfonylurea. The jury was out. We settled. The judge approved the settlement and entered a final judgment. A year and a half later, we got a call from a lawyer in Hawaii, and he said, I've just been up to the Hawaii Supreme Court twice, and on discovery abuses and some bin lake cases, and there's a box of documents you need to see. Because it looks like when there was a young lawyer named Teresa Pike waiting for 90 minutes for the DuPont expert to show up for his deposition, they were actually in the fax room of a prestigious Atlanta law firm sending transmission sheets back and forth, telling the DuPont expert to continue to dilute his soil samples until he could defirm that sulfonylurea was in our soil. The case, we could not set aside the judgment. It had been over a year. Our clients had spent the money. We couldn't rescind the agreements. We came up with a unique procedure. We filed a sanctions matter. The judge issued a $101 million disgorgement. It went up to the 11th Circuit. The process was upheld. My husband's $101 million verdict was reversed because it was criminal in nature, and the 11th Circuit reversed it, did not reverse, referred it to the U.S. District Attorney's Office for criminal proceedings, and Judge Hugh Lawson called everybody in, and we resolved the case by funding 4 ethics chairs, including the boodle ethics chair in Mercer. And the Supreme Court got $1 million or so to fund ethics. That's my longest one. But that was such an amazing experience of the law and how you affect justice, and transactional lawyers in a fax room making transactional decisions because they were afraid to lose. Almost lost their bar license. Midtown Inc. I became the executive director of Midtown Inc. while on sabbatical for my law firm, and learned about public discourse with people who are not rationally trained but believe very much in their communities. And we did some amazing things with transactional lawyers who were not transactionalists, who did innovative bond projects, tax things that made renewed communities. It was one of the most rewarding experiences, but I learned then how to be phenomenally unpopular, because until people feel comfortable about what you're doing, they are very angry. And but we did a lot of good. Mayor, I was the mayor of Columbus, Georgia. Being a lawyer helped me understand how to bring the structure of the law to the chaos of politics and the power of politics. 4 constitutional officers threatened and then did sue us for more money. We've been giving them more money. They've been overrunning their budgets, but nevertheless, they wanted more. The purpose was, we could have been transactionalists and just given them more money. But the purposeless mayor convinced the legislature that we had to stand our ground under Georgia law and insist that the legislature set the budget. And they couldn't threaten to sue us and, in our minds, extort us. 2 judges over 2 circuits were recused, whole nother story. And then we won on summary judgment. So being a purposeless lawyer pays off, and it helped the system of justice throughout Georgia. Saving Sweetbriar, my alma mater. I was set to be the graduation speaker, and the board, former board, voted to close the school. I ended up being a witness in the trial to save Sweetbriar, went up on an emergency appeal to the Virginia Supreme Court. They ruled the board could not close Sweetbriar College, but in the interim, I gave a speech at the graduation. The lawyers from college wrote me letters. We're going to sue you for libel and slander if you give this speech, da-da-da-da. That speech, if you ever get the opportunity to hear it, people think, where's the lady who told me that she listens? Yes. People think it's just a speech about closing a college. That speech was so laden with legal stuff you can't even imagine, because we were in the midst of negotiations. Mark Herring, the Attorney General, had called me right before I got up and spoke and asked me to say something in that speech. There's so much going on. But being an orator, being a lawyer who knew how to resolve these issues helped us save that college. I ran for Senate, and I was supposed to be the party's nominee. I had 100 people supporting me. Andrew Young, Roy Barnes, everybody. Great, great, great people. Well-funded. And then a young man with a big idea ran and beat me for the Democratic primary. So, when you are well-funded and expected to be the nominee, let me just say something. There is no shortage of very skilled people who will offer you ways to change the playing field. And it was a moral dilemma, but I had seen somebody when I was running for mayor who was supposed to be the mayor, and I ended up beating that individual, but he called a press conference and ruined himself. Destroyed his reputation. He finished 3rd in a 4-way race, and he no longer even lives in the city. And there was no way. I've disappointed a lot of people who invested in me. I lost something that I thought I was trained to do and going to do a good job, but let me tell you something. It was the proudest loss I ever had, and I voted for John Ossoff proudly, and I'm going to vote for him again in 2026, and he is doing an amazing job. There's nothing worth losing your reputation over. The practice of law, my last story. You have such clarity when you have mileage on you. It is an amazing thing. And so I hope you all have long, great careers in the law so that you can look back and have these moments I was arguing an issue of first impression before a federal judge, and I was losing. But someday, the United States Supreme Court is going to rule in another case that my analysis was correct. Until then, the judge thought wrong. So my opponent had wisely shut up and sit down. First rule of the law, when you are winning, stop talking. And he had. I was still talking because I was losing. And so the judge said to me finally, and I know him a little, professionally and so forth. And so he said to me with a smirk on his face, Ms. Tomlinson, you can go back to your client and report to them that you have well earned your fee today. Well, he just told a purposeless lawyer that I was a transactionalist. So without thinking, my sternum splits open, and from my heart and my gut, I say, Your Honor, I am an officer of the court. I am here trying to keep this court from manifest error. No, he was very kind, and he chuckled, and he said thank you, and then ruled against me. But that's the way I feel about the law. Every time I'm in front of a court, I act like I am that judge's greatest law clerk, and she needs me to help her make the right decisions. I love the law, and I hope you guys will love it half as much.
Hi. You always know you're at a law review conference when you see first all these marvelous young people all decked up to the nines. Don't pretend like you dress like this every day. Second, the crowd is all pushed to the back of the room. And third, you're here until the last speaker croaks. So I'm not going to pretend like I'm honored that you're still in the room. I ought to start with an apology. I know I look kind of out of place. I'm not sufficiently dressed. I've got the weird hair. This is what happens, especially for someone who's spent most of the last 40 years being a law school dean or a university president. But this is what happens when you get old and go to seed. I just want you to keep that in your head. My oldest daughter, who's a historian, I'm a constitutional lawyer, and she says, I studied the founding fathers for so long that I started to look like one, and I think some truth in that. I'm delighted to be in this marvelous and beautiful place. This is a remarkable law school. There's some warmth for me, too, also because this room is named after Griffin Bell. I know probably you older folks all have your Griffin Bell stories, but I've got my own. I was thinking about this 20 years ago. I was given the charge of speaking, giving the kind of keynote address at a huge legal conference with thousands of people in the audience. And the subject was the 50-year anniversary of Brown against Board of Education. And they sat me down before I was to get up and speak at the lunch table, and there sat Griffin Bell, Oliver Hill, who had tried a number of the Brown cases, Julius Chambers, who's the greatest civil rights lawyer in the United States, Judge Marriage from Richmond, who had done the desegregation cases there, Judge Justice from Texas, who had done the desegregation cases when I was a kid, and I thought, Jesus Christ, I'm supposed to talk about the meaning of Brown against Board of Education, this jackleg law professor with these great heroes. I fully expected that when I finally stood up and spoke, Thurgood Marshall was going to have resurrected from the grave and be sitting in the front row scowling at me. Well, Griffin Bell talked me off of the ceiling. He was a delightful and wonderful man, and so just to be in a room named after him warmed my heart. I think it's to great credit that Mercer is looking hard at the lawyer's role. I particularly admire the focus on the lawyer's obligation as public citizens, something that we pay attention to, I would guess, less frequently than other purported ethical obligations. I also want to salute, we heard about this last night, President Mary Smith's leadership on these issues, especially her formation in 2023 of the ABA Task Force on American Democracy with Judge Ludig and others in these most challenging of times. It's great to be in Georgia as well, cousin to North Carolina in these ravages from Helene. I'm guessing that no Tar Heel would easily describe Georgia as the promised land. But if you come from a state like mine, a state that has, at least for the last 15 years, been engaged in an intense and often losing battle to secure its democracy, Tar Heels could reasonably concede that over the last decade, Georgia has been home to some of the most appalling and the most inspiring democratic work in the country. Maybe I should just say that Georgia is obviously home to much heroism in the American democratic cause, and it's an honor to visit the scene of the struggle. So, the role of the lawyer as public citizen, maybe to many the surprising role of the lawyer as public citizen. Not only to seek to improve the legal system, addressing questions of access to justice and the rule of law and the fair administration of justice, but also furthering, as it's put, and I quote, the public's understanding of and confidence in the justice system. These responsibilities of public citizenship arising because, and again I quote the ABA, in a constitutional democracy, legal institutions depend on popular participation to maintain their authority. This obligation of public engagement with the community, with the Commonwealth, for lawyers and even beyond lawyers, is both ancient and foundational. Luke 12, verse 48, of course, reads, "For everyone to whom much has been given, much will be required, and to him with whom much is entrusted, he will be asked all the more." Going back even further, Pericles, in the funeral oration, explained that as Athenians, we alone believe that a man who takes no interest in public affairs is more than harmless. He is useless. Robert Kennedy, the real one, centuries later, citing Pericles in his South African Day of Affirmation speech, said that the Greek word for idiot comes from the term for a person who does not participate in public affairs. And focusing on this profession, and very explicitly these times, the ABA Task Force for American Democracy concluded, quote, that our country and democracy face a variety of very serious threats, and too many lawyers have taken our democracy, our rule of law, our civil norms, and our freedoms for granted, and have not done the hard work required to keep a free and fair democratic republic. Judge Ludig specifically noting that American democracy and the rule of law are in peril this day, and lawyers are both uniquely responsible and uniquely obligated to stand up for the United States Constitution, democracy, and the rule of law. And coming at the question from yet one more direction, we're in a law school. I'm an old man. I have almost lived in American law school since I was 21, over 50 years. A home of students and teachers, a home of scholars, folks who draw yet another obligation. As Ronald Dworkin would put it, in no other occupation is it so plainly and evidently the responsibility of professionals to find and tell and teach the truth as they see it, Scholars exist for that and only for that. For that and only that. So some real pedigree, this pedigree of obligation. Can we ask then, how are we doing on this crucial ethical front, on our joint obligation to perform as public citizens, sustaining our system of government? I mentioned that the ABA's task force concluded too many of us have taken the rule of law and even democracy itself for granted, instead of doing what it calls the hard work of keeping a free and fair democratic republic. I know, of course, that lots of folks principally think of Donald Trump and his crew, as Judge Ludig does, as the most profound threat to the rule of law and American democracy. I think that too, I'll admit. But as Georgia folks know, the former president isn't the only menace to our constitutional order. Much of our anti-democratic work is, I think we should say, localized. So with your permission, let me talk about North Carolina to make the point I'm after, the state I love and that I know. In Carolina, over the last 15 years, we've been governed by the most times all-white Republican caucuses of the North Carolina General Assembly. They repair to their closed-door meetings to craft the laws and standards of the state. From those often supermajority caucuses, state lawmakers have given us, the courts say, not me, the courts say, the largest, most pervasive racial gerrymanders ever seen in the United States. They've enacted the harshest voter suppression laws passed in America in a half-century. The greatest, most blatant and distorting political gerrymanders in all of American history. Extreme political gerrymandering recently reinstated happily by a new and highly partisan North Carolina Supreme Court. State justices saying without embarrassment that our free elections clause requires free elections, but not fair elections. Rigged elections are okay, as if Tar Heels were idiots. The North Carolina General Assembly has, and again I quote, used surgical precision to make it harder for black people to vote. They have been caught repeatedly, judges say, with the smoking gun, embracing racial discrimination to disenfranchise their adversaries. Later courts have ruled that neither this legislature nor, as far as we can tell, any other legislature in the country has ever done so much so fast to restrict access to the franchise. Other judges ruled that the General Assembly's serious, long-standing constitutional violations have denied black Tar Heels a constitutionally adequate voice in the state legislature, calling into question their willingness and competency to comply with the Constitution. Race-based violations have been so profound, and we might add unrepentant, that they have, courts say, interfered with the very mechanism by which people confer their sovereignty on the General Assembly. We have, in short, no actual government of, by, and for the people in North Carolina. And there's been more to this purportedly crucial racial work. They have repealed the state's path-breaking Racial Justice Act, allowing broader race-based challenges to death penalty verdicts. They responded to the Black Lives Matter movement by making it harder to get access to police video. They effectively invented new special criminal penalties for black demonstrators and welcomed AK-15s for angry white ones. Now they tell us what we can and cannot learn about our racial history, but only after passing a law lionizing Confederate memorials, explaining that the Civil War wasn't actually about slavery, only tyrannous northern tariffs. Lincoln apparently got it wrong in his famous second inaugural. North Carolina's Republican caucuses not only look like a white people's assembly, they have governed like one. So has this stirred the North Carolina legal community? Not as much as those obligations of public engagement or public citizenry might suggest. Now, to be clear, the North Carolina NAACP and the Moral Monday movement has fought the onslaught. Common Cause has entered the fray. The marvelous Southern Coalition for Social Justice has helped carry the burden. The ACLU and League of Women Voters have as well. But the bar, the state bar, the regulatory side, the institutional legal community, the large and powerful network of law firms and law schools and public and private schools, the Attorney General, and the legal sector, mostly crickets. It's hard to prove a negative, of course, and I'm not interested in that anyway. Maybe I could just make the point or hint at it through the editorial pages of the state's two largest newspapers. Though in this instance, the papers are complaining only about a subset of North Carolina's anti-democratic work, the recent intense partisan politicization of the North Carolina Supreme Court. Our local papers have written, North Carolina's courts have become politicized at the behest of the Republican-controlled legislature with the passive or overt cooperation of Republican judges and justices. What's striking, though, is that co-opting a legislative power, or a check on legislative power, is in the legal community's lack of protest of it. The North Carolina Bar Association, the papers say, law school deans, leaders of prominent law firms, and retired judges have been largely silent about the hijacking of a branch of government that is supposed to put allegiance to the law above loyalty to a political party. My good colleague from Duke, James Coleman, has written, the legal community should be speaking out and loudly. Every law professor and every prominent lawyer in North Carolina ought to be screaming about what's going on. This is how democracies are lost. It's not through some violent revolution, it's because people who are in a position to speak out remain silent. And that's what's going on right now. The newspapers conceded that the lack of objection from the legal community is understandable. Lawyers are loath to get on the wrong side of judges, and law professors and deans at public universities worry that their objections could lead to budget cuts. Still, the Charlotte and Raleigh papers say, lawyers take an oath to support, maintain, and defend the state and federal constitutions. That defense is sorely needed now, and it is not coming. It's hard to resist comparing the official response of the Bar Association and the leaders of the legal community to the United States Supreme Court ruling in Brown against Board of Education in 1954. At the annual Bar Convention in 1955, newly elected President John J. Hall said in his inaugural address, our state will never abandon segregation in the graded schools. The children are not ready, the parents of the children are not ready, nobody is ready for it. The mixing of races in our public schools cannot be accomplished, regardless of what the United States Supreme Court says. Horace Sterry, the vice president of the bar, again speaking to the convention, quoted Governor Luther Hodges saying compliance with Brown against Board of Education would be disastrous to the white children and disastrous to the colored children of North Carolina. You cannot enforce a law that does not meet with popular and local approval. Black Tar Heels themselves prefer to preserve their racial integrity and go to their own separate schools, the president of the bar said. I. Beverly Lake, a locally famous Wake Forest law professor who would later run as a segregationist candidate for governor against Terry Sanford, speaking for the Attorney General's office, told the North Carolina State Bar, my oath to support the Constitution of the United States is not an oath to accept the sociological assumption of the United States Supreme Court or to bow in humble submission before whatever command comes out of Washington. These pointed speeches were then published on the front pages of the state bar journals of 1955 and 1956. So our bar and professors and lawyers haven't always been mum. I close with two, at least tangentially related points. Since, as I said before, we're in a law school, a Southern one, I should concede that on those few occasions when professors have sought to publicly challenge legislative and executive actions to subvert democracy, at least in state law schools, Republican officials and legislatures have not infrequently sought to retaliate. Even old, cranky, thick-skinned academics like me have occasionally felt the sting. As I've had it explained to me, there's a new sheriff in town. We set your budget. You'll do what we say. Before the powers that be closed a poverty center that I ran, I was instructed that I should place a disclaimer on all my publications announcing hilariously that I don't speak for the University of North Carolina. Take my word for it, no one has ever thought that I spoke for the University of North Carolina. I was sort of honored to be singled out from among the 3,000 faculty members, so I didn't mind. But for fun, I asked how the new rule worked. I assume it applied to newspaper articles, but I just published something in the Harvard Journal of Law and Policy, so I asked, did the disclaimer apply to them? It was explained to me that I didn't need to worry about fancy law journals. My rough translation was, no one in North Carolina reads that shit. It's only when you write for the Raleigh News and Observer and the Charlotte Observer that you need to explain how much your employer detests you. My apologies to the good folks of the Mercer Law Review. North Carolina lawmakers think Chapel Hill professors are too political. My own sense is that it's sort of the opposite. We are a very, very long way from James Coleman's demand that every law professor and every prominent lawyer ought to be screaming about what's going on in this state. Coleman's wish, and as I take it, Judge Ludig's moral claim, that in our peril, lawyers are uniquely responsible and uniquely obligated to stand up for democracy. As that obligation begins more broadly to attach, if it ever does, the tensions from political interference will expand as well. Carolina has been specifically condemned by the AAUP for a cascade of partisan violations of academic freedom, faculty governance, and racial equality. Other studies have decried the intense transgressions of traditional academic norms occurring in the Florida public university system, which are perhaps even more outrageous than our own. There are, I'm sure, others that could be mentioned, but the old academic administrator in me senses a pattern, as the Chronicle of Higher Education put it 2 years ago. As higher education is attacked as an institution, employees up and down the ladder find their professional lives more difficult. Faculty members at state institutions feel under siege. Politically appointed governing boards examine what they teach, what they write, and what they research. Some will think twice about applying for jobs at certain institutions, while others decamp for greener pastures. And there is a partisan geography, the Chronicle wrote, to higher education's current clashes. Another expert decried what he calls the red state university blues. The Chronicle concluded that public flagships in red states find themselves at disadvantages compared with their peers in blue states or in private universities. Michael Harris, the chair of educational policy at SMU, has put it this way: it feels like we could have two separate systems, one red and one blue. I'm guessing in the long run, the citizens of purportedly red states, like my own and perhaps yours, won't be satisfied in the belief that their great public universities can compete only in football and basketball, not in research and teaching. Thank you very much.
Well, much to think about here and to ponder. But what questions does anybody have out there in the audience for any of our panelists?
This may be for everybody, I don't know, but I'm going to allude to legal
It's a little different in law school, I would concede, but I just spoke over the weekend to the orientation for the undergraduate student organizations at Chapel Hill. And what I tried to explain to them is students have more clout, more courage, more idealism than faculty and administrators. Faculty and administrators in a place like Carolina, or I'm sure in places in Georgia, I know in places in Florida, faculty members are scared, they won't put their heads up. Administrators are terrified because if they do their jobs, they will literally be fired. So I tried to explain to the Carolina undergrads, you're the only hope. It's stunning, but administrators aren't going to do anything to try and save the American Academy. Faculty members aren't because they want to just be left alone or teach their classes, or they just go somewhere else. That's happening in Carolina, it's happening in Florida. I hope it's not happening here. So I've got more hope for students than I do for faculty or administrators.
Well, I think there's a counterfactual in the fact that some firms, revoked offers to students.
Well, I understand. And I said it's different for law students, but that's, if they're all packaged up with a certain view of what the future holds for them, which I think most are, it makes some sense. But I'm confident even law students have much more clout than they know. And I was a university president, I was a dean for a long time. Students have a lot of oomph. We have these trustees who come in and they're simple lickspittle for the people in the legislature. And all they do, they pass these neutral laws which only apply to liberals. They don't apply to Republicans. But even those trustees, they don't want to be hated by students. Everybody likes to be liked by students. You don't want to be the ogre who comes in and squashes the idealism of students. So I've had too much counterfactual experience myself in believing that students have a great deal of possibility, and I want to encourage them to use it. You ain't got to have anybody else to protect you.
I want to add to that. Your youth and your inexperience are your two greatest resources, and you should use it because you don't know how things have always been done. You're seeing things in a new way, and you will find new solutions that those older than you have no concept of. Also, those who have some mileage on them, we know the future is yours, right? And so at some point, when you start conveying to whether it's the people you're working for, your family members that are older than you, when you start conveying that this is harming you and your ability to function in a more diverse, more environmentally friendly, whatever it is, environment that you would like them to join you in leaving you a future worth having, you'd be surprised. You'd be surprised how they stand down and realize that they're just holding this moment in time for you guys. Tell them what you want.
We are really just out of time. I want to exercise moderator's privilege and ask Doug Amar one quick question. I hope you inspired me with your emphasis on optimism. On the other hand, when I hear Gene Nickel talk about the threats to democracy and rule of law,
Don't hit me with that.
I've been staying awake at night worrying about it before I heard you talk. So you're speaking the truth, I believe. How do you maintain optimism? You're down at the legislature all the time. You get success there. How does it work?
Yeah, I left that out of my talk. I was supposed to be in there. I ran out of time, guys. Ran out of time.
Well, here, I gave you a minute.
A minute. I'll grab it. So one of the things, the way I think about things, I'm a very practical person. I believe the work should be very practical. And I say that in the context, let me give you some context. People say, I say this. I have an interracial family. We're together since college, 2 boys. I grew up poverty. This work for me isn't a philosophical jaunt, right? I'm not in this to sort of make a statement. One of my other favorite sayings is, some people believe that making a statement makes a difference, and I believe that making a difference makes a statement. In other words, that if you focus on what you can control, if you focus on the overlap, another one of my favorite things I didn't say is, I have so many people around the country ask me this. They say, "Look, how the heck do you get this stuff done in a deeply red state?" And they say, a lot of people say, how did you convince all those legislators to think like you? How did you convince them to have your values? And I look at them and say, if that's what you think how change makes, nothing's going to happen. I don't wait for that. I find the things that overlap. I find the things that are of interest, not just of interest. What are the interests? How can I take the interests of our clients, the interests of people we serve, and overlap that with the interests of business or the conservatives? And if you focus on finding that overlap, I call it the 5%, not the 50%, you can get some stuff done. And I think, I'll be honest, I worry that we're too focused on this hegemony of thought, the litmus test of language, as opposed to getting things moving. And I am just a person, I want to get some stuff done. If you want to get some stuff done, I suggest you can. You focus on that. If you're focused on, however, if you're focused on this point in time where we all think the same thing, we're all going to be still at odds, and nothing's going to change. That's the way I stay out.
I believe our peril is too great for that, to think we can get one little thing done, two little things done. Our democracy is literally in peril. When it's lost, it won't be returned. That sounds like exaggeration, but it's flat fact. Anyone who denies it, it seems to me, is putting his head in the sand, her head in the sand. So the exigency which we face is paramount, pervasive, and astonishing for people of our culture and our history. But it is here. And, it may be, for all we know, in 2 months, we'll have our last Democratic election for president. And that suggests that this is an emergency. It's all hands on deck. The stakes could not be higher, and they won't be accomplished, or the challenge won't be met by simply thinking, well, what are okay, you've got folks on one side who want to end democratic government, and folks on another side who are trying to carry forward the American promise. What little middle ground is there that we can suss out? There ain't any middle ground there. So
let me just say, I don't listen, subject-wise, I would agree. One of my good friends, former intern, former board chair, is a senator in North Carolina, out of Asheville. And we sat together recently, and she talked about the progress she's having in she's an uber liberal, makes me look conservative. But I would say the difference might be that I'm talking about criminal justice. But here's what I would say.
It might be, but I tell you what, if you talk to her and she said democracy is not
no, that's,
in
I
great peril
I
in
wouldn't,
North Carolina, she's not telling you the truth.
But let me
and I know who it is, and I know she is telling.
But let me tell you, put in context. So 20 years ago, 15 years ago, 10 years, 30 years ago, we were having the same conversation about criminal justice. There was no light between the two poles.
This is not 30 years ago. So
Yeah,
I'll shut up.
I hate to cut off this conversation, but that's my job here. I don't have much of a job today, but that's it. So I'm going to have to do that. But let's congratulate on our panel.
What is in that bag?
Well, now you get to find out. I'm going to just look. What is in there?
All right, yeah. Just a koozie and a
We're not done. We got Professor Jones coming up.
We have concluding remarks, which I'm going to open. First of all, with a comment about Gene Nickel, who referred to his wonderful hair. At least he has hair. I'm jealous. I wanted to follow on, actually, the conversation you were just having, because I had a side conversation with Mary Smith last night, in which she informed me, and she may have spoken with others about this as well, that law students at other law schools in Georgia, I think she mentioned Emory and Georgia State, and she may have mentioned the University of Georgia as well, are helping the Project for American Democracy. And she was very open to Mercer Law students getting involved in that assistance as well. So just bear that in mind. I think that's something we could explore.
I have contact info for the state director on that, if anybody wants to know.
Very good. Thank you. My name is Mark Jones. I serve as Joint Faculty Coordinator for this symposium. I have the happy task of expressing thanks. Again, I know we've had some thanks expressed already, but you can never express thanks enough, I think. Expressing thanks to several groups and individuals who've made this symposium possible. First of all, our wonderful speakers. Our terrific keynote speaker last night, Mary Smith, and our very high-powered panelists today. What a wonderful smorgasbord of ideas we have been treated to. Absolutely terrific. I mean, we've heard about so many different concepts. I mean, my head is full of them. True North, relationships, ethics, purpose, service, many, many, many more. And of course, the last part of the discussion on the last panel here suggests that perhaps another panel we could have had, or maybe another symposium, is the role of the lawyer as legal educator. Pat, this morning you began by saying that this is the third symposium in a series on professional identity, and that we'd had two more before, one in 2016 and one earlier this year in March, which you organized, wonderful symposium. And you hope that this would be the next step. I firmly believe it has been the next step, perhaps even a giant leap. Justice Colvin, you referred to the first hot air balloon, I believe. So I thought I could throw in a reference to the first moon landing. So many thanks to our panelists, first and foremost, and to our speakers. Absolutely wonderful. Secondly, second group I want to thank is our planning committee. And you will see the members of the planning committee. I know they've already been mentioned, but on page 6 of your program, if you have your programs available to you, when Rachel approached me towards the end of the spring semester and broached the idea of this symposium, which was her idea, by the way, to have a symposium on the multiple roles of the lawyer. I said to her, and she asked me if I would help. I said, I'd be happy to help, but we're going to need help. We're going to need others involved. It's going to be a complete team effort. And that's what it has proven to be. If you look at the symposium planning committee, you will see faculty members and law review members listed there. The faculty members, that's not untraditional. In the past, when we've organized symposia, we've had faculty work together to generate a slate of speakers and panelists, and that's what we did this year. We identified those faculty who would be particularly helpful in finding speakers on the topic of professional identity. You see there Caleb Byers, the Symposium Joint